Good morning, everyone. This room is in a slightly different time zone than the rest of the building. It's still only 9:59 according to our official clock on the wall. So we're just holding off for one more minute.
All right. Good morning. Welcome to the February 18th, 2026 General Law Public Hearing. We are going to get started. The first hour is reserved for public officials. After that, we will alternate. If we go past the hour with the public officials, we will alternate. The order has been published, and we are looking forward to kicking off our work. Representative Lamar?
Thank you. We've got 41 folks signed up to testify today. We will make some time at the end for folks who forgot to testify if they're here and want to. We'll reserve a few minutes for those folks, but we're going to try to move expeditiously. We have you on the timer, 3 minutes for folks, and they're providing testimony. Please just let us know what bill you're testifying on, and please provide any written testimony of what you testify in person. It's so helpful for the committee as we move forward. We rely more on the written testimony than anything else. And with that, spring training games kick off on Friday. So my goal is to be out of here by then. So let's keep the questions somewhat brief. And with that, Representative Tigliano.
Let's get going.
Okay,
Thanks.
great. And yeah, thank you for that. And just a reminder, when you come up, make sure you press the button so that the microphone is on. Please state your name and where you're from, whether you're in person or online remotely. So with that, we will kick off. And first is the Attorney General's office, I believe. I don't see the Attorney General, but I do see the Kara and Michelle. So if you and Nate.
Yeah, if the T would like to join Nate up front, I think that would be great. And you might want to just introduce yourself all at the outset of your testimony, because I'm certain there'll be different times where we refer to different folks.
Yeah, my name is Nate Kalishman. With me is Mike Wertheimer, who is our chief of the consumer protection section, Michelle Lucan, chief of our privacy section, and Rebecca Bourne, who is an AAG at consumer protection. She's been instrumental in our social media litigation. So Chairs Maroney and Lamar, ranking members Ciccarella and Rutigliano, distinguished members of the committee, thank you for allowing us to testify today. The Attorney General wishes he could be here, but he was stuck in a meeting with his fellow attorneys general that he could not move. We've submitted written testimony, so I will be brief in the bills. House Bill 5037 builds off of the social media bill from last year. It adds a warning label that displays when a minor opens an app, and it redisplays after a prolonged period of time. House Bill 5125 is the same as the ticketing bill from last year. That was 7182. We would just respectfully ask that place of amusement be added to the definition of entertainment event to make sure that amusement parks are covered. And also for ticket resellers to display the face value amount of the ticket when they're reselling a ticket. That's the original amount the ticket was sold for. House Bill 5128 aims to protect our most sensitive data, which is DNA. It provides Connecticut residents with complete control over their genetic data and requires express consent anytime the data would be transferred or sold, and it bars targeted advertisements from the use of this genetic data, as well as increases security for this information. Senate Bill 117 helps streamline our data breach process by requiring companies who experience a massive data breach, which would be defined as 100,000 affected users or more, to create a forensic report and provide it to our office. It would also allow us to recover any costs associated with the forensic report should our office have to conduct it ourselves, and it has significant fines for any company that fails to provide a report. And then finally, Senate Bill 119 has to do with the used car warranties. This law was originally created in 1987 and it hasn't been updated since. Used car prices continue to go up. They last longer. People buy more used cars. And so we feel that that threshold to sell a car as is should be increased as well. Currently, it's at $3,000 or less or older than 7 years. And we think it should just be changed to a car that's 10 years or older, as well as keep the warranties in place for 60 days or 3,000 miles, whichever happens faster. So that's our testimony. I just quickly want to thank Patrick Kania, John Newman, and Brennan Flynn, who've helped work on these new bills that we are proposing to you guys. And with that, we're happy to answer any questions.
Thank you very much. I do appreciate the time and bringing so many folks here to help us answer some of these questions. The AG's office has been instrumental in developing a number of these bills over the last 2 years, including a few of these that we were able to get through the House last year. We know that there were some minor modifications that folks wanted to make as we advanced this year. We thought it was important to at least start the process with the bills as they pass the House. Your comments and suggestions as to ways that we could improve or amend those bills have been taken all along, and certainly will be considered as we progress through this process. I do think you'll see testimony from a number of other impacted entities who wish us to consider amendments as well. So we might be engaging with you and them as we proceed to try to figure out the best bills as we move forward. Both a ticketing bill and a social media bill received broad bipartisan support in our chamber. We anticipate a similar outcome this year. They seem to really be issues that impact folks from all stripes of Connecticut. So I think the Attorney General's straight over the head on these issues about trying to regulate. There will be questions that arise. There will be questions that arise during the course of this afternoon. There will be a lot of opposition to some of these. Your willingness to engage with those folks alongside us will yield a better bill. We're not all going to agree at the end of the day on the full components of these bills, but you do see the will of the legislature to move forward, in large part led by the efforts of the AG's office to get us to a good place. So I just want to start by saying thank you. The bill that is somewhat new to our committee in consideration, two of them actually, with respect to major data breaches and used car warranties. If you could expand a little bit more about what came before your office that has generated interest in moving forward legislation this year.
Sure, I can start with the data breach notice amendments that we have proposed. So these amendments are aimed at addressing a troubling trend that we've seen in our data breach investigations, where companies have not been providing forensic reports to our office. And so to take a step back, I head up our privacy section at the Attorney General's office. We receive a very heavy volume of data breach notices submitted to the office. We review every single one of those. Last year, we received 1,800. And we often investigate these data breaches to make sure we understand what happened, what led to the breach, what vulnerabilities were involved. Are companies taking this seriously? Are they addressing those issues so this doesn't happen again? Connecticut residents' data is compromised by these data breaches, and we take this very seriously. So for these matters, our amendments are aimed at what we have labeled as massive data breaches. So these are breaches that impact 1,000, 100,000 or more Connecticut residents. To give a sense of what that looked like in our workload, last year, out of the 1,800 breach notices we received, only 7 of those would fall under this threshold, but those were breaches that impacted a large number of Connecticut residents. And for us, our investigations are often frustrated by the fact that companies are not putting their forensic investigations into writing so that they don't have to provide the facts to us, or engage in counsel and then raising claims of privilege. But what we need to do is to be able to conduct fair and thorough investigations, and we can't do that if we don't get the breach facts. So this amendment bill is aimed at requiring companies that experience these massive data breaches to conduct a forensic investigation, document it, and provide the reports to our office.
Excellent. And if you have a chance later this afternoon or in the coming weeks, take a look at some of the testimony that's been submitted in opposition. I think there's some misreading of the proposed legislation that's led to some of the confusion in opposition. And we can easily work through some of that. But there are some relevant questions, I think, that we could seek to address and have less opposition. There's going to be opposition. But like trying to forestall some of the opposition that seems perhaps to be born out of misinterpretation would be helpful.
Yes, we are happy to do that. We've already been reviewing the testimony and would be open to talking about this more at any point.
Excellent.
Representative Lamar, thank you. Mike Wertheimer, I'm the chief of the Consumer Protection Section. As to the used car, the amendment to regarding used car warranties, as you can imagine, used cars and cars generally, but used cars specifically, are a major source of complaints, consumer issues that are brought to our office. More people are buying used cars today. There's just a report in the Washington Post this morning about how the average price of a new car is now more than $50,000. That's the first time it's ever happened. It's 30% higher than it was in just 2019. More people are buying used cars. In addition, used cars, as Nate referenced before, are just lasting longer and are more expensive than when this law went into effect. And when the law went into effect, it was designed to put a baseline warranty if you're going to buy a used car, but there were limits. And the limits may have been appropriate for 1987, but times have just changed since then. That's a long time ago. Those limits were that you had to provide a limited warranty for cars that were over $3,000, but less than 7 years old. And that warranty was 1,500 miles or 30 days, whichever comes sooner. We just think, based on our experience dealing with consumer issues in this field, that those limits are just antiquated and need to be updated more to meet today's standards. So we propose the limited warranties apply to any car that's less than 10 years old, get rid of the minimum price requirement and expand it to 60 days or 3,000 miles, whichever comes first. Just better protect consumers.
Excellent. Questions, Senator Maroney?
Thank you. I do have a question, I guess, on the genetic data bill. Is that a response to the 23andMe? And then what other states have run this bill before?
So that bill, you're on point. That bill was a direct response to the 23andMe data breach and our work investigating that breach. This isn't our testimony, but we co-led an investigation into that breach on behalf of states from across the country. And as part of that investigation, it became very clear to us that Connecticut residents deserve more protections over their genetic data. It's the most sensitive data there is. It's inherently personal. It's immutable. There are at least 27 other states that already have genetic data privacy laws on the books. And so when we're working with other states as part of a multi-state investigation, differences in state laws come to the surface. And it became clear to us that Connecticut residents were less protected than individuals in other states. And so really what we did in this bill is looked at models that other states have passed and drafted this to try to make sure this is as strong as possible for Connecticut.
Thank you. Now, on the social media bill, I think later today, we're going to hear a lot of testimony that it may be unconstitutional, First Amendment issues. Could you address some of those issues?
Sure. Thank you, Senator. Most of what I think you'll hear when opponents of the bill point to court decisions that address constitutionality, any negative decisions have addressed bills that address the content of what these social media platforms are publishing. And our bill is content neutral. New York and California, as I think you well know, have already passed very similar bills. And the only courts to actually rule on this bill are in California. And they both upheld the core principle, which is the ability of states to protect minors' access to an addictive feed in a content neutral way. So we don't have any concerns about the constitutionality.
Thank you. And I think another place where you sometimes hear challenges to the constitutionalities around age verification, but can you explain how you've avoided that with this bill? You're not requiring um, IDs or anything. Can you talk to that?
Sure. So the bill does not specify the ways in which social media platforms need to provide age assurance. And they don't have to take ID today already. Social media platforms are identifying users' ages. And this doesn't really impose new requirements there. It just ensures that in order for a minor to access certain content, they've done age verification. They've assured, that a minor has parental consent. In addition, there are many laws, state and federal level, that do require age verification already. So we don't have concerns about that either.
Thank you. And I just want to make sure I was reading the bill correctly. I think at one point it said unless they have actual knowledge that it is a covered minor, they should be treated as an adult. Was I reading that correctly?
That is correct. The platform does have to use commercially reasonable and technically feasible methods to try to, determine the age of the user. But if they aren't able to do that, or if they have actual knowledge that if they don't have actual knowledge that the user is a minor, then they have to treat the user as an adult.
Thank you.
Representative Tigliano to be followed by Representative Turco.
I just
Nope.
have two quick
No,
ones.
no,
Go ahead.
go.
You sure? I just, when you first testified, you said that there's going to be a disclaimer on minors when they sign on to a social media app, right? How does that work? Like, how do you know that they're a minor? So why does the disclaimer there? And is the disclaimer for the kid or for the parent? I was confused by what a disclaimer would achieve.
Sure. So the bill requires the social media platform to use reliable methods to determine the age of the user. Once they have determined that the user is a minor, which again is already happening and being required or will be soon required in California and New York, then it's a warning that pops up. And as Nate was saying, it pops up when they first open the platform in a given day. And then once they've been on the platform for 3 hours in a given day, it pops up again. But it's just sort of an add-on to the bill because the bill was already requiring the platforms to use reliable methods to determine the age of the user.
What will you consider a reliable method? So you're really sort of leaving it up to the social media companies to determine whether somebody is under 18.
Yes.
Is it a best
so-
effort thing too? So it's like, oh, well, geez, we did our best, but that 14-year-old, we didn't know.
Right. So there are a variety of ways social media platforms are already doing this, and they would be permitted to continue doing it under the law. They can use facial recognition technology. They use the behavior of the individual on the platform. They can request an ID, but a user does not have to provide an ID, and they can't require it. And kind of fortunately, I think for us, there are rulemakings underway in New York and California that are providing more specificity around how we can kind of evaluate the efficacy of the platform's methods. And our bill is designed to be interoperable with those laws and the regulations that they end up with. And I think what we'll see is kind of a movement of the market to whatever ends up being finalized in New York and California, and they're well on their way there. And that will be able to be applied to Connecticut residents as well.
Okay, thank you. In theory, I'm in favor. I just didn't know operatively how it would actually work. Because that even raises a concern now. Oh, the camera. Well, you have to get permission to use the camera. And then all of a sudden you're sort of using the camera for a minor. Is that even legal? You know what I mean?
Yeah.
I just think that there's pitfalls. On the ticketing bill.
If I could speak to that
Go,
really
please
quickly.
do.
Yeah, no, just to, we have heard concerns about data privacy, and that is a real concern. And there are 2 provisions the bill includes that, are geared to safeguard against concerns there. One is that the data that the social media platform collects has to be immediately deleted after it's used for age assurance. And the second is that the platform is not permitted to use the data for any other reason. So we are, aiming to provide safeguards against privacy concerns in the legislation.
I appreciate that. I had a quick question on the ticket bill. You had mentioned amusement parks. I thought the ticket bill, if memory serves me correctly from last year, it's a reselling platform. I wasn't aware that amusement parks were part of that.
No,
wanna
the,
speak to
the,
that
the
one?
bill is broader than just applying to resellers. There are provisions about resellers. But there are also provisions about upfront pricing.
So you're
and
saying
other
for an
things.
amusement park, if they have fees on the ticket to get into the park, it has to sort of be like going to a concert, they have to do it ahead of time?
Yes, or just, there's a definition of the venues or events that are covered. And this would just make it explicit that amusement parks are part of that in addition to concerts and games and things. There was some ambiguity and this just removes it. They shouldn't be treated any differently than those other sorts of events or venues.
I appreciate the clarification. Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Chairman, and thank you to everyone in the Attorney General's office for all your leadership on these issues. First on the ticketing bill regarding the face value having to be printed on the resold ticket. I believe that was in the Attorney General's office initial proposal last year in front of this committee. It came out through the legislative process because we were told that it wasn't technologically feasible for the resale companies to do. These tickets get transferred several times, and they don't know what the original value was. I believe New York and some other states may have been trying to do this, and I'm just like some clarification. If you have any updates that it has been proved to be technologically feasible, why you believe it should be in the bill this year.
I think it's important, we think it's important for the consumers to know not just that this is a resold value, but have an idea of what it originally paid cost so that they can shop around or look at other options. I think that the original face value is often printed on the ticket. And I understand we're not dealing with just printed tickets anymore, but there is some sort of printout. It's not information that is completely unattainable. I would suggest at the very least, every reseller knows what they paid for it. They bought it from somewhere, and at the very least, that should be on there. But I don't think it's insurmountable to access what the original price of the ticket was. And I do think it's relevant to a reasonable consumer trying to make a good decision about how much to spend on any particular ticket, what the markup was.
Thank you for that. And then regarding the social media bill, we will likely hear testimony today that will say that this bill is going to restrict minors from accessing content that's relevant, important to them. Maybe educational materials, maybe connecting with communities that they want to connect with. Can you clarify that this bill is not prohibiting a minor from searching for the content they want to view, but is restricting the tech companies from using addictive algorithms to decide what the minor sees?
That's absolutely right. The minor has every ability to still go in and search for whatever they want to search for, to connect with whomever they'd like to connect with, to find their community, to find their people. And this just prevents the social media company from essentially spoon feeding or force feeding people what they're seeing, minors in particular.
Thank you very much. Appreciate that. Thank you, Mr. Chairman.
Thank you. Representative Acker.
Thank you, Mr. Chair, and I apologize for my late arrival. I had to meet with the governor's office this morning, so thank you for your testimony. I just want to back up on a comment that I walked in on. It was regarding following legislation in California and New York. Can you touch on that a little bit? Because it seems like if they change, like we're legislators, we put laws in books. That's what we do. So you're saying that our legislation here will then change as that legislation changes in other states? Okay, if you could elaborate on that comment a little bit, that would be great. Thank you.
Yes, sure. So our social media bill is modeled after bills that have already passed in California and in New York. In those states, the regulators or the attorney general are writing rules that flesh out the details of how those laws will work in practice. And because those are such huge states also, we expect the platforms to conform their behavior in those states, and they'll be able to conform that behavior to what they do in Connecticut, consistent with our bill.
Thank you for that clarification. I truly appreciate it. Thank you, Mr. Chairman.
Thank you. Senator Ciccarello.
Thank you. Sorry, I was a little late as well. I was not meeting with the governor's office, but I just have a couple of questions. So you're speaking about the California legislation when it comes to the social media protections for minors. There was two bills, if I'm not mistaken. There was one that's going into effect in 27 and one that went in effect on 25. Which one of those pieces of legislation are you referring to when you're saying they were challenged regarding the First Amendment issues? And what are the difference between those two bills and which one is closest to what we are going to be proposing?
So you're right. And there's one of the two bills, which I believe is the one that largely went into effect in 2025, is almost identical to our bill. That is the bill that was challenged in legislation Net Choice v. Bonta. And that is the bill where the district court in California found that it rejected Net Choice's challenge and found that ultimately the state could restrict minors' access to addictive feeds. And the Ninth Circuit Court of Appeals affirmed that decision. So now I believe parts of that bill have gone into effect, and the other pieces are sort of awaiting the rule writing process from the California regulators. The second bill, I'm kind of blanking on what it did. Do any of my colleagues? I can't remember offhand what the other bill did. It's not the bill our bill's modeled after, but we'd be happy to get you more information on that this afternoon if that's helpful.
Okay, thank you very much. Yeah, 'cause it's just a little confusing because the one that was due to go in effect on 27, I think was in 24's legislative session there. And then the one that is in effect was in 25's legislation, the one that you're referring to. So I was just confused if maybe they're trying to fix something or do something a little bit differently. So that's why I asked as we're in this process. Switching gears, the data breaches. I have some quick questions for you. So I was listening in and I think you said there was 18,000 data breaches?
1,800.
1,800. Okay, that's good.
Luckily not 18,000.
Yes, that could be best. And we see these type of forensic crimes and digital crimes happening more and more, which is alarming. And then out of the 1,800, you said only
7 would meet this threshold that we have plugged into the law for a massive data breach. So it's 0.3% of the breach notices that we review. We've purposely did that to keep this focused on the breaches that we really need information for and very promptly on behalf of Connecticut residents.
Got it. Excellent. And it is so important. And there was only a small number of those, that small percentage, and none of them cooperated with the investigation?
So that for those breaches, I don't have that information offhand, but what I do know is that this is a common problem that we are seeing. So it is very frequent that we're reaching out to companies and asking for the details related to their investigation relevant to a breach, and the companies are trying to shield that information from us. So I can't speak directly on the 7 from this year, but what I can say is we are looking into a very large data breach right now where a company purposely kept all of these details out of writing, and we are currently being forced to go in and recreate that information ourselves, which is costly for our office. And we'll drag out our investigation, and then we'll start getting questions. What's going on with this data breach? What's happening? And sometimes these delays are a direct result of the company's conduct in responding to our investigation and trying to shield this information from us.
Got it. Thank you. And then a lot of the other companies that don't meet that threshold, are you collecting data from them on the data breaches as well?
Absolutely. So we have a good team over in our privacy section. We are constantly following up on data breaches, whether they would meet this threshold of a massive data breach or it's a lower number. to just give an example of that, sometimes we see a data breach that impacts only a very small number of Connecticut residents, but the data is extremely sensitive. Reproductive health data, biometric data, kids data. So there are reasons why we're investigating breaches even for a smaller impact. And to be very clear, what this amendment does is it requires these forensic reports for massive data breaches, but these types of forensic investigations need to be done anytime there's a data breach. What companies need to do is immediately respond to a data breach, conduct an investigation, figure out what happened, take steps to deal with any of the issues that have come up in their investigation. That has to happen across the board. So just by focusing this on massive data breaches, we are also not creating a perception that these forensic reviews and forensic reports don't need to be done for smaller breaches. They need to be done across the board.
Excellent. And the 1,800 that happened in the most recent year, do they self-report? Or-
Yeah, so it's our breach notice law requires companies to report to our office and to impacted Connecticut residents. You've probably received these breach notices in the mail. I got one this week. So it is a statutory requirement. That said, I think we do see a lot of cooperation with this requirement, and companies are often voluntarily reporting incidents to us that they do not yet know whether or not it's covered under the law, and this makes sense. For us, we're just trying to understand. We're also dealing with calls from Connecticut residents. I received this breach. What does this mean for me? What should I do? Why does this company have my information? So there's a very good reasons for this communication chain, and there's very good reasons that we need to have information promptly about these data breaches.
Absolutely. I agree. And I guess I'll be quick. I don't want to monopolize too much time, but this is interesting. I'm just trying to really understand it. So when you're saying you want their forensic reports, so basically a digital forensic investigator essentially would use like Celebrite or Oxygen or something like that. And then are you looking to see how the breach happened so then you could give them best practices, or what's the purpose for getting that forensic report?
Yes. So every time we're conducting an investigation, we're asking, did this company have reasonable data security measures in place? So these investigations will highlight any areas where there are weaknesses. And that is exactly what we are trying to do, is raise the bar for data security expectations. If issues come to light as part of these investigations, we will require a company to do better. Sometimes that's through formal action. Sometimes it's through a settlement agreement. Sometimes it's informal. So as an example, with maybe a smaller business, what we might do is say, okay, here's what we've learned from this data breach and the fact pattern here. And these are the areas that we see need improvement, and basically please pay attention to that and do better going forward. So there's a few different ways we can do it. It's not all formal, but that's why we need to be part of that process. We learn a lot through our breach investigations. We carry certain things we learned from one investigation over to another investigation, and we really do view ourselves as a resource for well-meaning companies that are trying to comply and are trying to protect sensitive data.
Excellent. And that's great. And it is important. I know Senator Maroney and myself, we really care about data privacy, and there's a lot of legislation around what data gets released permissibly, if you will. And it's something that we don't really think about, is all the data that gets stolen. And if it's being stolen, it's probably used for the wrong reason. So I have a lot more questions, but I'll talk offline. I'm putting Representative Tigliano to sleep over here with all these data questions. So, but thank you very much.
Senator, we're happy to reach out and set up a meeting separately and we can talk about these.
Are there any other questions for the Attorney General's office at this time? Seeing none, we're going to be in constant contact over the next few months, trying to clarify any of the points of disagreement that we can reach consensus on, and also to get further clarification on any of the points that we may need additional information. So I thank you all for being here. Please give the Attorney General our best wishes, and we hope he's doing great work.
Thank you. Thank you for the time.
Next up, we have Gretchen Schugartz, followed by Annie Fiervante. And if I ever get anyone's name wrong, it's a long day. please do not be shy about correcting me.
You nailed the name.
Perfect.
That doesn't usually happen. Good morning, chairs, ranking and esteemed members of the General Law Committee. My name is Gretchen Schugartz, and I'm a policy analyst at the Commission on Racial Equity and Public Health here at the CGA. We're a nonpartisan legislative office charged with making policy recommendations to reduce the impact of racial equities in public health. I appreciate the opportunity to speak today and am testifying in support of House Bill 5127, an act concerning medical credit cards. Residents in Connecticut are struggling with costs. Basic living expenses like housing, healthcare, and groceries are rising faster than wages, and many families are finding themselves having to make tough decisions about where to spend their dollars. A 2025 survey cited by OHS found that 2/3 of respondents reported delaying or foregoing healthcare due to cost. The survey also found differences along racial ethnic lines, with 78% of Hispanic and 77% of Black residents skipping care compared to 52% of their white counterparts. The residents who do opt to receive care may be exposed to medical debt, especially if they're already financially vulnerable. According to KFF, about half of adults wouldn't be able to cover an unexpected $500 bill. And so medical credit cards that advertise 0% interest can become appealing. However, this 0% is really deferred interest, a term which is commonly misunderstood by consumers. In practice, if the total amount borrowed is not paid in full by the end of the promotional period, interest can be charged retroactively to the total amount and not just the remaining balance. Worse still, these cards carry exorbitantly high interest rates, with the typical card having an APR of 26.99%. And people often obtain these cards right at their provider's offices. Currently, when a provider's office markets a credit card, there's an implication that the provider is endorsing the card. This can be problematic in a patient-doctor relationship where there's an implied basis of trust, which can lead to the intentional or unintentional exploitation of that trust. HB 5127 seeks to mitigate that risk. Given the trust we have in providers, these credit cards shouldn't be promoted by them, nor should providers receive financial incentives in exchange for a patient's business. We appreciate the provisions in this bill and respectfully recommend two things to strengthen patient protections. The first is teeth. What happens should a provider fail to comply? What will the consequences be, if any? And two, any written disclosures should, where reasonable, be communicated in the primary language of the patient. In closing, exposing patients to further medical debt via credit cards could perpetuate the cycle of economic and health inequity. This bill seeks to mitigate that. We're encouraged by the work of this committee. I thank you again for the opportunity to speak, and I'm happy to serve as a resource if needed. Thank you, and I've submitted a longer, more thorough testimony, but I'm also happy to answer any questions.
I like Led Zeppelin too. Thank you, Gretchen, for your testimony. And I sometimes exhaust the leadership of this committee because I oftentimes, after a public hearing, try to bring a lot of people together to work out some of the details that they raised during public hearings, try to reach consensus where we can, and then try to get further explanation as we move forward. I do really appreciate that you added some additional suggestions that we may wish to look at. I think the clarity of your testimony is very well received by this committee. There is, as you will see if you go on the public hearing testimony later today, you'll notice there's a lot of folks who've testified in opposition to the bill under consideration. Similar to a lot of bills, they get a lot of it wrong. They misinterpret some of the proposal in here. And so I'm going to talk to them as well about how to clarify where this bill seeks to go, what's attempting to do, and how it just does not prohibit the use of medical credit cards. It just creates very clear and upfront obligations about the card itself, who it can be offered to, when it can be offered to, and what it can entail. And I think your testimony did a great job of highlighting why we need to consider this legislation this year. So thank you for your time.
Thank you.
Other questions for Mr. Schugartz? Representative Turco.
Thank you, Mr. Chairman, and thank you so much for your testimony. And I think your testimony is very unique compared to a lot of people testifying today, because you bring in the issue of racial equity and health. and that there is a big inequity in who has more medical debt and who might be targets of these medical credit cards and the way that they are marketed. And I appreciate your explanation too of the deferred interest scheme, because I don't think a lot of the public understands that. And that's one of the concerns of mine. One of the things you mentioned was regarding the disclosures having to be in the primary language of the individual. I believe that that's in the bill. However, maybe there were parts of this bill where that is not stated clearly. And I think, as the chairman said, your assistance in making sure that happens would be important.
Do you want me to respond to that?
Yes, please.
Absolutely. The bill language actually says, that lines 126 through 127, that the information should be provided in the primary language in which such provider communicates with the consumer, which I'm trying to differentiate the language that they may communicate with the consumer versus what the primary language of the consumer actually is. And we understand that like not every single language may be covered, but just that a good faith effort be made to communicate in that primary language.
Yeah, thank you so much for that. That seems like a distinction that could be of importance in the way this language is interpreted, and certainly could use your assistance in fixing that. And the other area I wanted to touch in, which I think is a really interesting aspect that your testimony brings, is when you talk about this relationship between providers and patients and this building of trust, because this is a provider that's giving you information regarding your health, right? Whether it be vision, your teeth, your other parts of your body, or in this case with veterinarian, of the health of your animal. Is there anything else you can share regarding like how that level of trust then when it then extends to offering financial products may cause some confusion for patients?
Right, exactly. The provider is providing medical care or dental care. They're not financial advisors. So they're just offering something that they think may be helpful, but they may not. I'm not saying or trying to suggest that they're doing it maliciously to try to take advantage of patients or anything. It's just they may not be aware of all the factors and the person's financial situation and ability to pay within the promotional period. So it just does become very tricky when you have someone who's an expert in providing medical or dental care is now offering a financial product because of that trust.
Yeah. No, thank you so much for answering my questions. Thank you, Mr. Chairman.
Representative Tigliano, followed by Senator Chicarella.
I just have one question, because there's a lot of testimony on it. I think we're going to talk to a lot of people. And I just want your response to what the people who are against this bill say to us every single time, that these credit cards are necessary and that without them, people wouldn't get medical care.
I mean, the healthcare system has its issues and we need to work on that. I think this is trying to address, I think the medical credit cards are addressing the symptom of the problem, and we need to really address the problem. So that would be my response. I know it's not the best response, but.
I mean, quite frankly, you never get me to stick up for a credit card company. But, you know, are they making a point where, hey, if you didn't have this, you would be able to get that root canal? I mean, that's what they say. Sometimes, you know, you listen and you try to be reasonable, and sometimes it's a compelling argument. I just didn't know what the response would be. I appreciate it.
And I think that's a really fair point. And I think that as long as the transparency is there and that people understand that the 0% interest is really deferred, I think a lot of times there's just a misunderstanding. And as long as the transparency is there and people can make an informed decision, then that argument seems valid. Sure.
Thank you. And call your attention to the case in California where a complicated financial product is offered to somebody under anesthesia. They sign on, and then right, like there are examples we clearly need to protect
Right.
against. Senator Chigarella.
Thank you. And I'm trying to kind of take this all in. I see both sides of the argument. You know, we're very big on consumer protection. That's something that general law really deals with a lot. And we can understand someone under anesthesia or in a very, you know, kind of emotional and chaotic situation, may make a decision and regret it, or may not have all the information and is just focused on solving whatever issues in front of them. But it seems that if there is transparency, then you would be okay with these products still being offered.
Transparency doesn't necessarily, I don't know, I would be hesitant because sometimes the transparency is there, but that doesn't necessarily translate into the consumer actually understanding the terms. And I don't know how you would be able to confirm understanding of something while I would have to think through that a little bit more, but I definitely understand your point. But just reviewing some of these credit card companies, I did look through their website, and it is, for someone who's looking for it, it's clear sometimes that it's deferred interest, but I think a lot of people don't understand what the term deferred really means. And I think that's a key problem.
Absolutely. Talking about the problem at the root cause. That's why we got that financial literacy bill passed. So we make sure our kids know about this stuff. You know, it's interesting.
Senator
So
Chigarella, were you lead sponsor of that financial literacy?
it was teamwork, but yeah, I championed that across the line. But it is important, all kidding aside. And I got a lot of emails on this, and people wanted it to remain. And I remember I just got married, and my dog had to have a surgery. And I would have signed anything to save my dog, and it pretty much paid everything. It was like $12,000. And you know, just got married and didn't have the finances. They offered that card. I did make the payments, and it did work out. The dog lived a very long life. I paid it off, and I didn't have any type of crazy interest rates. But I think if getting to the original question I asked you, if it was transparent and it was to someone that was not under some form of medicine, I mean, duress is a different thing because that could be in any situation that we just talked about. But if they're not intoxicated, if you will, or under the influence of some product, and they are explained, you know, the deferred interest, you know, if you don't make all the payments by this date, all the interest comes back. If it was clear and we found a way to kind of take care of two things, the consumer protection, but make sure a product's there for someone that might not have the means, do you think the majority of people that want to stop this would be okay with it?
I think that seems like a decent middle ground, but like, I know that if I had a $12,000 bill for my cat, I would probably want to sign up for a credit card, but I could also tell you I couldn't pay off a $12,000 bill in 1 year. And I think it's gotta be, it's tricky. I just make sure I understand. And I don't know. I don't know.
Yeah. And I know I'm not trying to stump you. I know it's a tough question because, again, I was extremely concerned. Will I be able to pay this? But honestly, I would have went into debt to save Bruiser. So, you know, how do you not give someone that option? That's the concern that I'm just trying to deal with. And I just want to your point, find that middle ground to make sure these resources are there and no one's being taken advantage of. So
I think also sometimes there might be other solutions that we aren't thinking about. Like maybe your bank can offer a lower interest loan. So I think it just becomes a little slippery when the provider's giving you the credit card rather than you going home, thinking through things, doing your research. I think it just becomes a little bit tricky when you're there, you're emotional, and you're like, yeah, sign me up. As opposed to maybe your provider saying, they have these credit cards, go home, look into it, call us back, and, you know, we'll see what we can do.
sure. And thank you so much for testifying. before us because we do have to flush this out, but it's something that we do have to really kind of digest. And again, to Rep. Tigliano's point, we don't want to defend big credit cards. We want to make sure we're taking care of consumers. But there is a lot of risk that is taken by these lenders. So I understand why the interest rate may be high. So it's something that we need to continue to flush out. And I thank you for coming up and testifying.
Thank you. Are there any other questions? Seeing none, thank you again for your testimony. We'll be in
Thank you.
touch. Next up, I have Annie Fioravante. Is Annie available online?
Yes, I'm
Before-
online. Good morning.
Oh, Annie, before you get started, I just want to welcome Representative Larry Pemberton, who newly elected, joined the committee for this is first official public hearing. So I want to say thank you and welcome. Montville, Ledyard, Norwich, Basra. Perfect. Outstanding. Well, thank you and welcome to the committee. I appreciate it. Next we have Annie Fioravante. Thank you, Annie, for that indulgence.
Welcome. Good morning, co-chairs, ranking members, and members of the General Law Committee. My name is Annie Fioravanti, and I'm the Deputy Director of Athletics at the University of Connecticut. Thank you for the opportunity to speak today in support of House Bill 5038. UConn has submitted written testimony for the record, so I'm going to focus on why the issue matters from the perspective of the people that we work with every day, our student athletes. At the very basic level, prediction market contracts tied to sports outcomes create many of the same risks as sports betting. When people have a financial interest in how a game turns out or how a specific athlete performs, that changes how student athletes are treated by the public. Our student athletes are mostly between the ages of 18 and 22 years old. They're highly visible, they're active on social media, and unlike professional athletes, they don't have layers of security, agents, or financial protection around them. That makes them much more exposed to outside pressure. The impact of this environment is already clear. New NCAA research released this month found that 51% of Division I men's basketball student athletes reported receiving social media abuse based on their athletic performance. This is an incredibly high number, and it reflects the reality our athletes are living in today. Another growing concern is financial targeting. Modern platforms are very good at identifying and targeting young users. When those tools are connected to products tied directly to sports outcomes, the risk of pressure, harassment, and exploitation increases, especially for college-age students and student athletes. Integrity risks are also emerging at the national level. Just last month, federal prosecutors charged multiple Division I men's basketball student athletes in an alleged point shaving scheme involving dozens of athletes and games. Situations like that are a reminder that our financial incentives tied to performance can create real risk for college sports and for young athletes. Across the country, states are taking action to address prediction market platforms tied to sport outcomes. Enforcement actions and new legislation are being used to prevent these products from operating as unlicensed sports wagering, particularly in connection with college athletics. For these reasons, UConn supports strong regulatory protections governing prediction market platforms. While House Bill 503 is an important step, UConn continues to believe that policymakers should carefully evaluate whether contracts tied directly to the outcome of sporting events, particularly those involving collegiate or amateur teams, should be authorized in Connecticut at all. At a minimum, if such contracts are permitted, there must be strong protections addressing contracts involving in-state collegiate teams, collegiate tournaments involving Connecticut teams, and contracts based on individual student athlete statistical performance. Thank you for your thoughtful work on this issue and for your commitment to protecting student athletes and the integrity of collegiate competition.
Thank you very much, Ms. Fioravante, for your testimony on behalf of the University of Connecticut. This is an issue that's emerging across states around the country right now as we try to come to terms with what seems a very lax federal regulatory structure for prediction markets in general. Their entrance into sports gaming, particularly in a state that has a negotiated compact which regulates sports gaming interstate, seems clearly violative of that compact, the current offerings in Connecticut. I personally am doing a ton of research and listening to a lot of experts trying to figure out what the nature of this product is, how it differs from a conventional gaming product. I fail to see the distinction that the federal government is drawing in this space. And I do think a regulatory approach is necessary. frankly, I would outright ban it if I was allowed to just exact my own will. But the bill before us today seeks to find a regulated approach. I think there's some folks who have difference of opinions about how we go about doing that. This process will unfold for the next month and a half. Hopefully we get to a point where we can provide the protections that our constituents need. An unregulated gaming marketplace has many of the pratfalls you identified, many of the potential pratfalls for our constituents who may avail themselves of these marketplaces, but also for our student athletes, as you so rightly are concerned with. So I greatly appreciate your testimony today, and I hope that you will be a willing partner as we move forward with this and other regulatory structures we may wish to place on the gaming marketplace. Thank you again. And with that, I have a question from Representative Ritigliano.
Thank you. Thank you, Mr. Chairman. Good morning. So I really appreciate your testimony. I heard every word you said. I agree with you completely. The question I have is that just about everything you said just now about the predictive markets could be said about sports gambling. Everything, the targeting of young people, the bullying of sports athletes, you name it, it could be said. Does UConn support putting the similar regulations on online sports gambling as it would for predictive markets?
Yes, I mean, there's already a prohibition in place on sports betting on collegiate teams in the state. So that already exists. So this would just be in addition, adding the predictive market piece to this, to that already existing legislation.
If you read the governor's bill as it's written, it says that it has to be exclusively marketed to somebody who's over 21. There's not a Saturday morning or Sunday morning that you could go without a half-hour infomercial about online sports gambling in the state of Connecticut. Do you support that not being available since they can't predict who's 21 and watching that show?
Yeah, I mean, from a marketing standpoint, I think any safeguards that we can put in place to avoid marketing to young people is a positive. I think, on behalf of UConn, I think that's something that we'd be supportive of. I know it's certainly challenging just given, social media, television, what others are watching, but that is something we'd be in support of, yes.
So does UConn allow on campus? I'm not talking specifically about, we've had these discussions about advertising and gambling advertising, and there is a marketable difference between sort of a billboard on a hockey rink or on the ice or something like that, and then the ability for one of these companies to set up a table and solicit customers on campus. Does UConn allow any of that activity on campus currently for sports
My
gambling?
knowledge, sorry, go ahead.
No, for sports gambling, I want to make sure we're clear.
Yeah, to my knowledge, we don't. I can certainly confirm that and get back to you with our government relations team, but to my knowledge, that's not something we're doing on campus. We do have a partnership with Mohegan Sun, but that is exclusively with the entertainment portion of Mohegan.
You mean when you say the entertainment portion, you mean like advertising shows that are at the casino?
Shows, sporting events, obviously, we compete there at times, so.
Okay. All right, I have 1,000 more on the gambling port, but I know this is about predictive markets. So is UConn as a position based for the university, do you support or not support the use of prop bets? Because I know not unlike the prediction markets, some of the bullying and athlete stress that happens is over some of these prop bets, which are part of this online sports gambling feature.
Yeah, we're not in support of that, of prop bets. A lot of concerns around, again, the continued impact those could have on our student athletes and the harassment of our student athletes. So that is something that I know the NCAA has also taken strong opposition to, and we've been in support of those efforts as well.
Thank you. I appreciate your answers.
Representative Ackert.
Thank you, Mr. Chair. And Mr. Chair, first I got to start off by saying I completely agree with the full out ban. So I want to thank Annie for coming in and testifying on behalf of the youth out there. But I think this market is something that if we even have a bill like this, we're validating in a way the use of it. And so I appreciate you coming and talking about those that are underage and what the bill reflects. But I think that anytime that we give credit to something like this platform, by regulating it, that we're saying, okay, it's okay above this age, or in a way, I'm not saying supporting it, but giving it, validity. So your thoughts on that, if you wanted to weigh in, but I think that this is a platform that just needs to go away.
You know, it's one that I've learned about a lot more over the last week or so. I can't say I'm an expert whatsoever, but from what I'm hearing and understanding of it, it's something that, I know we have a lot of concerns with, especially just on the sports piece of it. So I don't want to talk broadly about, the other aspects, but the sports piece is a concern for us.
Thank you again, and thank you for being here and giving us that input. Thank you. Thank you, Mr. Chairman.
Thank you. Are there any other questions? Seeing none, thank you so much for your testimony here today.
Thank you.
Next, we have Rafi Podolsky to be followed by Edmund Mierzwinski.
Excuse me. Thank you very much, Representative Lamar, Representative Tigliano, members of the General Law Committee. My name is Raphael Podolsky. I'm a lawyer and policy advocate with the legal aid programs. We represent people of low income in various kinds of civil matters, including consumer matters. I've submitted written testimony on two bills, Senate Bill 119 on used car warranties and House Bill 5127 on medical credit cards. I want to focus my time on the first of those two bills in particular, which I think is an especially important bill. As the Attorney General's office indicated, it's an update of an 1987 law that has not been updated at any point since then. The market on used cars has changed very much, especially in the last decade. People keep cars longer, the cars last longer. The existing statute essentially says that a card, excuse me, that a car dealer in selling a used car must provide basic minimum warranties if the car is of a model within the last 6 years. As a practical matter, that means you're talking about cars that cost normally, I would say, $15,000 or more. That price structure has gotten way out of date, because when people buy a car for, let's say, $10,000, $8,000, $6,000, they expect it's going to run for at least 60 days. It's a reasonable consumer expectation. And the law is designed to make sure that you cannot have as-is sales by dealers of cars that people reasonably would expect would run for at least some modest period of time. What this bill does is it adds 3 years to that timeline. From 6 years, it moves it to 9 years. Our suggestion to you is that you really ought to go farther than that. You really, our recommendation is you should go to 12 years. And that's because at this point in time, people who are buying cars that are 12 years old are typically spending somewhere in the $5,000 to $10,000 range at the bottom end, and somewhat more if they're buying a more expensive car. And so we would encourage you to take a look at that. I actually went on to ChatGPT to try and get some information on what's the going price of cars. And what it reported was basically that you're looking at $11,000, $12,000 often for a car that's more than 10 years old. And so it just kind of illustrates the need to match the statute to what consumers reasonably could expect. In regard to the medical credit card bill, which we support, I would add one. I guess I would say one thing in response to some of the questions I heard from a previous witness. It is possible to distinguish between transparency and what's allowed at all, and there's an inherent dilemma there. But it's real. I think it's really important that there's some practices that may be common that you want to make sure are stopped altogether, and so that. And I'll give you one example, and that's the deferred interest. The retroactive deferred interest. That's to say that interest is deferred, but if you're unable to pay the entire bill within that period, you're going to be charged not just interest going forward, but interest going back to the original date. People don't understand that. They don't expect that. They're shocked when it happens. And the people most affected are the lowest income people because they're the ones who cannot pay the bill off during the deferred interest period. They're the ones who get hit, not the ones who are able to pay it off during the period. So I support both those bills and happy to answer any questions I can answer.
Thank you for your testimony here today. I think what we deal with both of these issues, like many issues, we rely on you to give us another perspective on a lot of things that are under consideration. I think Representative Turco will be handling the lead on kind of our internal conversations with respect to the medical credit cards. So you'll likely be working closely with him on that. I think there are some federal prohibitions what we can and cannot completely allow or disallow. And I think that limits some of our authority. But there are other aspects of this that clearly come under state oversight and regulatory abilities to prohibit. So I think that's the tension that we'll be struggling with the next month or so. There are certain actions and actors that I think we want to ensure don't occur in Connecticut. And I think that's the focus where this bill is going to be. So I appreciate that. Are there any questions? Representative Turco.
Thank you, Mr. Chairman. Thank you, Rafi, for your testimony on both of these bills. I was looking over your written testimony on 5127, the medical credit cards. And one of the things I'd like you to kind of clarify a little further, you mentioned that a lot of times the medical debt people incur could have been covered under private insurance, Medicaid, or Medicare. And you also mentioned regarding that there are certain protections now that people have when they incur medical debt. You use an example of a hospital where an individual can't be sued. Can you elaborate a little bit more on the protections people can receive when they incur medical debt in other ways versus medical credit cards?
Well, I'm not sure I can add a whole lot to what was in my written testimony, but the legislature has put some protections in. Some are directed to hospital medical bills as distinct from doctor medical bills, but there are protections as to what remedies can be used. For example, you cannot put a lien on someone's house for medical debt. So there are things like that where someone in a position where it may make a difference. I mean, that may make a difference. And this will, to some extent, this will undercut that, because by putting it on a credit card bill, you're not going to end up with all this with the same protections. It's at that point, it's not really medical debt anymore. It's just credit card debt. So, and by and large, the consumer's not going to know. I mean, they're not going to have that level of knowledge to know what the difference would be. So that you want the system to provide the protection automatically, or at the very least disclose it. But I guess those are the major things that I would have in mind. I think there's a special rule for wage executions that deal with medical debt, but it's not a total protection.
No, thank you. Do you believe that the clients that you represent, if a product is offered as a medical credit card and it's being offered and marketed by a medical provider, that there could be some confusion that this is similar to taking a payment plan or a loan or some sort of negotiation with the medical entity themselves rather than third party?
Yeah, yes. I mean, I think there's room for confusion, and that happens. And I also think that the previous witness who spoke on this pointed out that sort of the trust relationship between the medical professional and the patient. And if a doctor says to you, the treatment that you're going to receive is critical. And I know it's expensive. Here's a way you can pay for it. We can help set the system up for you. Don't worry about it. You're much more likely to say, yes, let's do it, than in a different setting. And so, I mean, that aspect is is a certain uniqueness in this kind of incurring this kind of debt, because you really are looking to the medical provider from the kind of relationship you have to essentially give you financial advice. And it's just a fun, it actually puts the provider in sort of an odd position where they may be influencing how you do, exactly how you're going to pay.
Thank you so much, Rafe. Appreciate that.
Seeing no other questions, thank you again for your testimony today.
Okay, thank you very much.
Edmund Mierzinski, followed by Chris Vandehoof. Good morning, Edmund. There's a button right in front of that microphone if you want to push that.
Thank you, Mr. Chairman and members of the committee. I'll be very brief because I know you've got a lot of bills and a lot of people here to speak. And I've testified many times, not before this committee in a long time, but it has been, anyway, I want to make sure that I get this straight. I'm Edmund Mierzinski. I'm a retired consumer advocate for both US PIRG and Connecticut PIRG. I started my career at Connecticut PIRG and been at US PIRG for 50 years almost. And the basic problem that we're here is we're strongly supporting HR 127 from Representative Turco because medical credit cards are different from regular credit cards. They are limited to charges associated with medical care expenses. And so by the way, these are relatively new financial products, and consumers I think patients may be unaware that if they miss a payment or can't pay the full balance on the card, then they'll end up with a higher rate. Skipping down, I just want to say that we did a study of medical debt in Oregon. Oregon is a member of US PIRG, and so Oregon PIRG or OSPIRG did a study of medical bankruptcies. We found that the single most frequently listed medical debt holder was a medical credit card. Credit card was called Care Credit from Synchrony Bank based in Stamford, Connecticut. And we found that we've got a chart of that in my testimony. I apologize. I'm not the expert on this testimony. I'm giving this testimony just as a courtesy to our expert. Couldn't be here. She's in Washington, D.C., but she can answer any really hard questions that you have. But I hope that my specific question, I want to get into probably the most important point that I make in my testimony is, you must have seen this before, but this advertisement, these advertisements for these medical credit cards, in small print flashing by you on your television, that used to be that the common scheme was used to sell rugs or furniture on late night TV. Now they're selling medical credit cards, just like they're selling rugs and furniture. And anyway, I've got a number of points that we make in the testimony. And again, I'm happy to answer any questions you might have.
Thank you, Edmund. I appreciate it. I'm reviewing your written testimony now, and I think there's probably a number of conversations that Representative Turco plans on entering into to get some clarification, particularly how this has been utilized in other states. We've seen some consumer comments about this product in Connecticut and how it's been used, but it's good to get a broader perspective about examples across the country where this may be a more relevant tool that's being used in a lot of places.
And I know that, by the way, I know that at least several other witnesses today are going to support Representative Turco's bill as well. Charles Bell from the Consumers Union is here today, and he's in person. He can answer any questions in great detail. And I think I've got some sort of a factoid in my testimony that Care Credit has 250,000 partners marketing this product to consumers. Then when we did our study, we said 250,000. I believe the Consumers Union has maybe updated that to 280,000 partners selling this product. So these products are being sold to consumers by people who think they're the doctor. They're at the doctor's office, so they're being sold a credit card anyway. I'm sorry, Mr. Turco.
All right. Are there any other questions? Seeing none, thank you so much for your
Thank you very
testimony
much.
today. Chris Vanderhoof, followed by David Zhao.
Good morning, Mr. Chairman, ranking members. My name is Chris Vanderhoof, and I am a board member of the Sports Fans Coalition, and I'm here today on behalf of the organization to express our general support for House Bill 5125, an act concerning entertainment event tickets, with a request for some language changes. The Sports Fan Coalition is a nonprofit grassroots organization that was founded in 2009 with the mission of representing fans wherever public policy affects games and entertainment. We applaud Connecticut for being one of only 6 states that expressly protects ticket transferability, an important safeguard for consumer freedom and fair market competition. 5125 builds on that tradition by mandating all-in pricing, banning speculative ticketing, prohibiting deceptive websites, guaranteeing refunds for fans when events are canceled. And we support these protections. Look forward to working with the committee to advance this legislation. However, we are concerned that the bill's all-in pricing provisions do not conform to federal standard established by the FTC and the Federal Ticket Act. We strongly urge the committee to amend the bill to align with those, and I'm happy, Mr. Chairman, to provide some language on that. All-in pricing should present one total price throughout the buying process with an itemized breakdown available at the end. So the consumer would see the price, wouldn't change when they get to the end, but the breakdown at the end would be there for them. Displaying, we find, multiple numbers throughout the purchasing process is confusing to consumers and can undermine the clarity and fairness that all-in pricing is intended to provide. So ensuring consistency with the federal standard will create a better, more intuitive experience for the fans. That is well under 3 minutes, Mr. Chairman. I will happily answer any questions, and I also look forward to the start of spring training.
There you go. You crushed it. Thank you very much for your testimony today. I think you kind of hit the high notes of where we need to continue to modify this legislation to bring it into compliance with the federal standard. I know there's going to be ongoing conversations. There's a bunch of folks today who submitted testimony in opposition who I think for the exact same language were in favor of last year. So I need to try to figure out what's going on in that space. So
I wish you luck on that endeavor.
please be available to us. Please be available to us as we work through some of those details. I appreciate your testimony today. Representative Acker.
Thank you, Chris. Thank you for that testimony. Just how many states use the platform that you're talking about in terms of all-in pricing?
So I don't have that for you. I can happy to get it for you. All-in pricing is sort of a moving target, I think, right? Every platform is a little bit different. There's the primary market, there's the secondary market, there's the primary market that also has a secondary market. So I can get the information for you on what every state is doing, or at least in the region, pretty quickly, no problem. The one concern we have is that it may show you what the all-in price is at the time that you're going to purchase it. But then as you're clicking through, it's showing you what the fees are and the taxes are, and all these numbers are kind of different and confusing. And the number may not change at the end, so it's technically keeping up with it, but we just think that one number should be there at the front, and then you can get like a receipt as an itemized breakdown.
Exactly, because I was just looking at tickets for a venue, and here's the ticket prices if you're back, if you're up close, and that ticket price on the seat was this amount, but toward the end it was a different price.
Right.
So I think if the way you're saying it, when I look at that seat and it says $80, I know that's what the final cost of that seat is going to be at the end. So thank you for your testimony. Thank you, Mr. Chair.
Of course.
Seeing no other questions, thank you
Thank you.
again today.
Have a good day.
David Zhao, followed by Rufus Duram.
Good morning, members of the General Law Committee. My name is David Zhao, and I'm here to testify in support of HB number 5127, an act concerning medical credit cards. I'm a legal aid attorney at Public Counsel. We're a nonprofit out in California that provides pro bono legal services to low-income and elderly folks. We assist folks being sued by creditors and debt collectors, many of whom my clients are victims of what the CFPB has deemed, quote, abusive and deceptive lending practices involving medical credit card products being offered by providers. I know this happens because it happened to me in 2019 when I went to my dentist and I was unknowingly signed up for a care credit card while lying in the dental chair with fluoride trays in my mouth and charged over $1,000 for a treatment I was never provided. It's actually the reason why I went back to law school to become a lawyer, because I found that this is a very common practice across the country, care credit contracts with over 270,000 providers. And this practice that happened to me is so widespread that the CFPB found Synchrony Bank liable for violations of the Consumer Financial Protection Act in 2013 for unfair and deceptive practices in their care credit product line. These practices have not stopped, even in California, where we do have a middle ground law that requires transparency and disclosure from providers. In the years since I've been barred and practicing, I've seen dozens of medical credit card cases which disproportionately impact women and people of color. Cases such as Martha Castro, an elderly monolingual Spanish speaker who should have been offered treatment covered by Medi-Cal, which is our version of Medicaid, who was instead signed up for a care credit card while she was under anesthesia and given English forms to sign that she did not understand. Or Mr. Garcia, whose name I have anonymized, a father and owner of a local cleaning business who was uninsured and told he could sign up for a easy zero interest payment plan for a tooth extraction, but wasn't told that it was actually a deferred interest rate, which other folks have explained. And even though he was making the monthly suggested payments by Synchrony Bank, he suddenly saw his balances double last September, adding almost $6,800 in one day. He's since had to increase his monthly payments, foregoing childcare expenses, and stopped seeking medical care. Burdened by their debt, these patients forego additional care and have worsened health outcomes. They've lowered credit scores that destabilize their housing prospects, and they're often sued by Synchrony Bank. So much so that Synchrony Bank was actually one of the top 10 banks suing consumers in LA's superior courts that reported debt collection cases in 2024. In closing, based on my work, I believe the problem is not merely bad actor providers, which do exist, but rather that health and veterinary providers are simply not equipped to also be financial advisors. And from the provider's perspective, it is unreasonable to burden them with complex financial regulations, which we've seen in California are unlikely to work in practice regarding disclosure and transparency. And from the consumer's perspective, at the point of medical care when they are in pain or have a dying pet, and especially with low-income and immigrant patients, it's almost impossible to make a rational, reasoned financial decision about a line of credit. To the extent that a consumer patient does make the decision to take on credit to pay for their care, which they should be able to, they should do so independently and outside of the medical office, not under the mental duress of seeking care or without time to think about whether they can afford it. And with HB1's cuts to Medicaid and with health coverage about to lapse for primary and emergency care for many people across the country, especially low-income and immigrant populations, I anticipate that this problem will only get worse. I've already heard stories of people being signed up for care credit cards while in the ER out in Arizona. And I appreciate Connecticut's initiative in getting ahead of this problem for its patients by creating landmark legislation that hopefully states like California out here can follow to close the door that is currently ajar between doctors' offices and Wall Street. And I'm happy to take questions.
Thank you so much for your testimony, David. And thank you for joining us from California. I do appreciate the perspective that you're bringing on an issue that, frankly, as you review the public testimony, has impacted more Connecticut residents than I had heard from on this issue. And so I think there's probably a lot of fertile ground here to create legislation that protects Connecticut consumers from the very specific and well-documented details that you personally went through. But it seems that many folks in California had gone through and a growing number of folks in Connecticut are experiencing. So I do appreciate the perspective that you're able to bring and offer us today. And I'm sorry, but thankful that you went through the experience that you did to help provide the benefit for so many countless residents who might be exploited by a bad financial product. I appreciate your time. Are there questions? Senator Cigarella?
Thank you. for testifying and sharing your experience and experience from some of your clients. When I hear that, I kind of, I get a little frustrated as well, and I could see how we have to address that. But when I listen to you speak, I have a question for you. Who are you more frustrated with? The service provider that I'm not saying I don't know all the details, so I'm trying to be careful here, but entice someone to sign for this credit card, to pay for the services, or the actual lending institution?
I'd say it's about 50-50. Obviously, providers oftentimes either maliciously or just because they're not financial advisors are giving out or describing these products in ways that end up being very misleading. It's not always their fault, but I'd say on the other side, a lot of times the lenders are not providing these providers with adequate education about their products. It's in fact one of the things that the CFPB pointed out in its consent order against Synchrony Bank back in 2013, and something that continues to not be, I think, addressed adequately. And so I think to the extent that someone wants to take on a line of credit, they should be able to do their own research independently and not rely on a medical provider who is not properly trained by the bank to explain a financial product. I mean, these folks go to medical school, they don't have economics degrees, so it's not really fair to require them to be trained by a bank to take on this responsibility.
Thank you. And yeah, I could see, again, I see both sides of this, and I'm really, really enjoying this public hearing, because trying to unpack this, because there's a lot of different areas that we're, discussing here. Because I could see where someone providing said service, they get them to sign the paper, they're getting their money, and maybe they're not fully explaining it, or maybe they haven't been fully explained the product that they're essentially trying to get their client to sign up for, so they could receive their compensation for the services rendered. So I could see where there's some issues, but I go on a plane, I get offered a credit card from JetBlue flight attendants. I go to TJ Maxx, they try to have me open up a credit card and don't explain it either. So, this is really interesting. I'm surprised this hasn't come up before, but we really got to unpack this more, because there are certain circumstances where you can't wait, maybe for an elective dental surgery or something along those lines. But when you have an emergency situation, and let's say a vet won't perform a service that will be life-saving for the pet, you don't have that time to think. So if we take away the resource, I have concerns, but I can see where we could make sure that they are very well informed on the very specific things that are the biggest concerns. The hidden interest rates, or, if they don't pay it off in enough time. But I'm really perplexed on how to address the consumer protection problem that we clearly see here, while not taking away a resource from people that would need it, who might not have good credit and can't get that funding and financing somewhere else. So I really look forward to continuing this conversation and then coming up with a solution to address the problem without creating another one. Thank you for taking the time to testify.
Thank you, Senator Chigarella. Representative Turco.
Thank you, Mr. Chairman, and thank you, David, for your testimony and sharing your personal story. I did read on Time Magazine online where they wrote all about your story. So that was great that you were able to get that out there to the public. You brought up the Synchrony Bank, which is located here in Connecticut, and the amount of lawsuits on residents. Can you explain a little bit about what's going on there and why there was so much litigation by the bank against consumers?
Sure, and thank you for your question. These lawsuits occur when folks allegedly default on their cards, either because they get trapped by the deferred interest provision, which they weren't aware of, and suddenly can't keep up with the ballooning payments. Or sometimes folks literally don't even know they had a Care Credit card opened for them because they weren't explained. They thought it was just a payment plan to the provider and not to the bank. And so ultimately they get sued when they don't make their payments. And Synchrony Bank is quite litigious. It will sue consumers directly for these lines of credit if they're not paid, or they will oftentimes assign the lines of credit to third-party debt buyers or debt collectors that will sue on their behalf or sue separately these consumers. These lawsuits oftentimes result in default judgments because folks are unrepresented here. Over 90% of debt collection defendants are unrepresented. And these lawsuits, when Synchrony wins them, result in wage garnishments, home liens, and bank levies. So people literally have money taken straight out of their bank accounts or start getting cuts of their paychecks taken away by the bank.
And David, you said something really important there. You said that sometimes patients don't realize they've signed up for the Care credit card. How is that possible?
Sure. So I'll give you an example. Sonia Romero, one of my clients, was told that she was being checked for an eligibility for credit. So she was told that she could sign up for a credit card, but the forms that she was signing were just to check if she would be eligible. And so she filled out the forms. This was while she was in the dental chair, so she wasn't given a lot of time to think about it. And it ended up that they actually just fully signed her up for the card, and she walked away from that appointment, didn't even get treatment, didn't think there was anything to pay for, and hadn't even been told that this was, a Synchrony Bank product. And so when she started receiving mail from Synchrony Bank, she had never heard of this bank. She didn't know she had a card. And just like any random bank or credit card that gives you mail, you just kind of throw it out, right? You're not going to open the envelope. And so months went by. She wasn't aware that these were billing statements. And ultimately, she was sued by Synchrony Bank, or she was sued by a debt collector that had been assigned the debt. And so that's an example of someone who wasn't even aware they had the card because of the way these banks and providers have this sort of nebulous relationship.
Thank you, David. I know you're not a financial advisor either. You're an attorney, but I'm just wondering, based on some of my colleagues' comments, that, an individual might not be able to receive care if they aren't able to have access to these cards. It seems to me that from my research, and you can tell me what you found because you're more of an expert, the starting interest rates for these products are usually about 33%. They can go up to 40%. Then, of course, you have that deferred interest scheme. If there's a penalty, if they miss a payment, it automatically goes up to that 40%. And the average interest rate for a credit card in the U.S. right now hovers around 20%. Depending on somebody's credit rating, they may get an interest rate a lot lower than that. So it seems to me that individuals would be much better off using a normal consumer credit card they may have in their wallet. I got my Amex Delta card here. Then signing up for a new medical credit card, which is under the disguise of the word medical, but really it's just a super high interest credit card. Is that accurate, or can you provide some more light on that?
Yeah, that's accurate. And I think that's why it makes sense to regulate these medical credit cards directly and give people time to think about whether they want to take on a medical credit card by making them make that decision outside of the medical office, because there are other ways to pay for medical care. Even if you are uninsured, you could use a general credit card. You could get it directly billed to the provider. You could look for alternative forms of lending from credit unions locally near you. These are things that I suggest to my clients. But because the credit card is given right there to the provider by Synchrony Bank, it's oftentimes the only thing that the provider thinks they can offer the client to afford the care. Or sometimes they'll actually jump to the card instead of doing an appeal with the insurance provider, or even checking if there's alternate treatments that would do something similar that are covered by the insurance. And so I think, to another member's question earlier, the fact that this medical credit card is an option and is oftentimes the first option for providers, and that there isn't this sort of buffer room where people can make a rational decision with other alternatives, results in stories that I've shared.
Yeah, thanks, David. I think that's why this legislation says that the provider needs to check that this service isn't covered by, Medicaid, Medicare, or private insurance, because you're saying often it's the first go-to by the provider. This legislation is trying to prevent that. My last question, David, my colleague mentioned that, going to TJ Maxx, you're offered a card. It seems like that these medical credit cards by providers in their offices are being promoted the same way I went and bought this Brooks Brothers suit here, and I was offered the credit card to get 20% off when I bought the suit. It seems like the medical offices are operating in the same way as a TJ Maxx. And by looking on their website, I saw that offices are offered prizes and rewards for helping to promote these medical credit cards to their patients. Do you have any information on that?
My understanding, based on what I've seen in litigation and Synchrony's own earnings reports, is that there's no clear kickback with these contracts between Synchrony Bank and providers. I would be really curious. I've never seen a copy of one of these agreements. They've been unwilling to disclose them in discovery or litigation that we've been involved in, if there is actually things like rewards and kickbacks. But I will say the financial benefit for providers is very obvious in that they can immediately get paid by the bank. And so that's oftentimes why they will resort to these cards first and foremost over other alternative forms of payment that may be more affordable to the patient. So they don't have to deal with insurance, or they don't have to deal with going after the patient with collections.
Well, thank you so much, David. Appreciate all of your answers. Thank you, Mr. Chairman.
Thank you. Thank you again for your testimony, David. We're having a pretty robust conversation here about how to handle this. You raised some really salient points that I think demand attention, and we're excited by your willingness to engage the committee. We might be reaching out to you for further exploration on this topic. Thank you again. Next, we have Rufus Duram, followed by Miriam Hakamzager. Again, if I get these names wrong, do not hesitate to correct me.
Good morning, committee. It's Rufus Duram, but Duram is, I answer to all. My name is Rufus Duram. I'm the interim executive director of the Connecticut Arts Association. I've seen some of you testifying in front of appropriations. General law is not my usual committee, but we are a statewide cultural advocacy organization in Connecticut. I also serve as the regional chair for advocacy for New England and the state chair for federal arts and culture advocacy through Americans for the Arts. I'm here to oppose HB 5125 as currently written. In my previous role, I was the executive director of the Warner Theater in Torrington, and we saw predatory ticketing practices impact our audiences at almost every show. Tickets sold for much higher than face value, tickets sold on third-party websites that didn't actually exist for like row triple Z, which we don't have. Single tickets resold multiple times to multiple people. It led to conflicts at our box office and forced us to actually station a security guard in our box office at every show because of the anger, the rightful anger of people that were duped by these practices. So that being said, I appreciate deeply this bill and agree with almost all of the policies presented, but I am concerned about this concierge seat saver loophole that's created with lines 9 through 54 of the bill. This allows, sort of enshrines the ability for people to sell tickets they don't actually possess as long as they enter into a written or oral agreement with a buyer. And in my experience, I think this is just going to further exacerbate fake ticketing problems and sort of enshrine sort of speculative ticketing or fake ticket selling in law. The bill's ban on deceptive URLs, fake ticketing websites, all of that I strongly, strongly support. And I'm urging the committee to just, strike lines 9 through 54 and pass the remainder of the bill. I think that legislation should ban fake or speculative tickets, full stop. I mean, what other industry? You can't buy a car. I can't go into a grocery store and like speculatively buy a gallon of milk. And so that basically my concern is if it's passed as is, it would just create loopholes for dark design practices where they've provided disclosure, even though it's not clear to the consumer that what they're agreeing to. And then box office employees across the state get screamed at by irate customers. Many New England states, including Connecticut, are working on legislation to address our broken ticketing practices. If we pass the bill as is, I feel that Connecticut would be the wrong sort of exemplar. There's a wide bipartisan support to try to fix these issues and fight against deceptive ticketing and price gouging. I would also strongly support this committee to consider either within this legislation or future legislation, price cap on reselling tickets. Maine, for example, just passed a ticketing legislation with 10% price cap on resales. Thank you so much.
Thank you for your testimony. I really do appreciate it. I think there's some confusion over you highlighted like broad support for the bill with the exception of lines 9 through 54. I would encourage you to reach out to us because that is not the interpretation our attorneys and the Attorney General's office has of what that section allows for. And I think there's broad disagreement in the industry now about what that is. That was largely written for folks who say you have, for an example, I know it wouldn't be applicable. I have season tickets to the Boston Red Sox.
Sure.
I have a contractual right to seats D4 through D8, but the Boston Red Sox don't actually give me my tickets. I'm not in physical possession of them until 3 weeks before. This would suggest that you could sell your tickets before you had physical possession because you have a contractual right to those tickets. And that was what this section was intended to allow for. I can see by how you think this could be misapplied, where maybe we need to tighten some of this language up, but it wasn't necessarily, I think, yeah, we didn't really want to allow for this speculative possession. I think we thought it was covered in that original definition right in 9 by creating that has entered into a written contract with the person who is in possession of the ticket or with the person who has a contractual right to obtain such a ticket from the person who is in possession of such a ticket. We thought we were covering the very specific scenarios that we wanted to protect for, but you having a more detailed and greater understanding of the types of practices that are occurring in this space, maybe we need to flesh that language out a little bit more.
Yeah, and I do see that from like sports ticketing. I'm coming at this from like one-off venue, like concert tickets or whatever, where there might not be like, we would get people coming in and be like, oh, I entered into this agreement. And like, they said, oh, we're going to try to, you know, we're going to buy the ticket. We're saving your seat. We'll get you this seat or better. And there's all sorts of like wiggle room in those agreements. And then you would get like obstructed view or nosebleeds or whatever. And because it's secondary market, they're much higher priced than the venue.
As currently drafted allows for that scenario.
Okay.
But I'm more than open to hearing a little bit further to make sure to protect against that very specific scenario. Because I saw a whole bunch of testimony come in opposition to the bill from folks who were in favor of it last year, and they're all highlighting this section, which our current internal legal reading does not allow for the scenario you're most concerned about. But I frankly do not have the day-to-day experience and expertise that you do. So I want to make sure that this language protects against that very specific outcome. So
yeah, and later on today, Kendall Gilver from National Independent Venue Association will be testifying. She can provide clear expertise, and she's working with multiple states and independent venues throughout the country around these things, and she can provide examples of this in practice.
Sounds great. Thank you again for your testimony today.
Thank you very much.
Any questions? Seeing none. Thanks again. Next, we have Miriam Hakim Zargar.
Yes, hi, good morning.
Good morning.
Good morning, chairs and ranking members and distinguished members of the General Law Committee. My name is Dr. Miriam Hakim Zargar. I'm a practicing orthopedist and the current president of the Connecticut State Medical Society. On behalf of the physicians and physicians in training of CSMS, thank you for this opportunity to testify on House Bill 5127, an act concerning medical credit cards. Connecticut's physicians share the regulators' concerns about predatory lending and the growing financial pressures facing our patients. However, as currently drafted, this bill targets the wrong party. It places the burden and the threat of unfair trade practices on physicians rather than on the lenders who design and profit from these financial products. If the concern is abusive lending practices, regulations should focus on the lenders themselves and not on physicians providing care. Physicians are already prohibited from charging patients for covered services under Medicaid, Medicare, and commercial insurance plans. Balanced billing is not permitted, and we operate under very strict state and federal billing rules. Strong patient protections are already in place. Portions of this bill imply that physicians are improperly charging for services that should be covered, and that implication does not reflect the reality of today's regulatory framework. More importantly, we must ask why patients feel compelled to use medical credit cards in the first place. The answer is not physician conduct. It is in the structure of the health insurance system. High deductible health plans, significant coinsurance requirements, and frequent denials of medically necessary care have shifted enormous financial burdens onto patients. Families pay substantial premiums only to discover that they must pay thousands of dollars out of pocket before any coverage begins. When insurers deny physician-recommended care, patients face impossible choices: delay treatment, forego care, or take on debt. That insurance environment has created the market for medical credit cards. Physicians did not design high deductible plans. Physicians did not create these credit products. Physicians do not receive kickbacks or profits from these cards. Yet this bill places physicians in the crosshairs while insurers and lenders remain untouched. For these reasons, the Connecticut State Medical Society has serious concerns with House Bill 5127 as drafted and respectfully urges the committee to reconsider the approach and direct consumer protection efforts towards the entities responsible for creating and profiting from these financial products. I have to agree with Gretchen Stugartz and Attorney Podolsky that when doctors are forced to collect debt for the insurance companies, it erodes the doctor-patient relationship, and that's already been happening. Medical debt is a huge problem, primarily created by insurance companies that are using high deductible plans to transfer risk to patients and the debt to doctors. Thank you very much for your
testimony.
time.
I really do appreciate your testimony today, and I anticipate a robust conversation if you have a few minutes.
Sure.
I want to start from the beginning. I think I agree with the fundamental 10,000-foot overview you have of what the problem is with the overall cost basis structure and responsibility for payment entailed in so much of medical procedures today. And I wouldn't disagree with your assessment that so many of the problems that we see in this specific area where we're attempting to regulate are not borne by the medical profession itself. I do think, however, when a product is offered in a doctor's office and recommended by someone in that office, it necessarily becomes a conversation and environment where regulatory action may be advisable. No one's, as far as I can tell, making an individual doctor's office accept a medical credit card or offer that credit card. So when the doctor themselves, the physician's office themselves, decides to make themselves a party to that transaction and provide the initial contact for or offering to a patient, necessarily legislation is going to dictate that type of relationship and what is entailed and informed and what the disclosures are and what the penalties would be if they're not upheld. I don't think anyone's looking to target doctors in so much as this product is being, in many cases, documented by public testimony, both here in Connecticut and across the country. The product itself is being marketed by doctors, so therefore they become a necessary component of the regulatory framework. So it's not like folks are out there trying to target doctors. It's trying to target the environment in which people are entering into a less than advantageous and less than fully disclosed and less than perfectly understood financial product, and that is inside of doctors' offices. So I think I don't want you to have the misinterpretation that we're sitting in the general law committee trying to go after doctors. We're trying to go after a product we think could be exploitative, and it's offered in doctors' offices. And so that's the focus of where this legislation comes from and what's originating its design of the current legislation. So with that, I'm going to turn it over to Representative Vitigliano, then Representative Turco, then Senator Ciccarella.
Thank you. Good morning. I just have a couple of clarifying questions. So does the doctor's office, do you get paid any compensation if somebody signs up for a credit card?
Not only do we not get paid, no, we don't get any kind of kickback, any kind of pay, we don't get any kind of remuneration based on these credit cards. When patients use any credit card in our office, we have to pay processing fees. So in fact, that's another, 1.5%, 2.5%, 3%, depending on what kind of credit card you're using. And off the top of my head, I don't know what Care Credit charges, probably 3% like Amex. It costs us money when patients use credit card. Ideally, they'd give us cash or check so we don't incur that cost.
Do you get compensated at all for having a display in your office? So just putting out the pamphlets or the applications or a small poster or anything like that, do they pay for space per se, like a billboard?
No.
And so you did say that you get charged the fee. So you facilitate the signing up of the credit card, but yet they're still charging you a processing fee?
All credit cards charge all salespeople a processing fee. That's
What's the
nature of a
procedure
credit card.
if a patient or something disputes a charge? How does the chargeback process work with a medical credit card as opposed to sort of a retail credit card?
You'll have to rephrase the question. I don't think I understood fully.
If the patient disputes a charge, I got charged for a bandage, or not a bandage, give me some brace that I didn't get. I'm disputing how much money this is. This isn't how much I wanted to pay for this. So they executed dispute with the credit card. What's the procedure for that? Do you get chargebacks on that? Do they remove the money from your account? How does it happen?
I am not aware of, I don't know. I would have to get back to you on that. I don't know. In my own personal practice, I probably only had patients use that credit, Care Credit, just a handful of times, and there's never been a dispute. So I don't personally know that, but we can find that out for you.
I appreciate that. I think one of the concerns is that, if you buy a pair of something and it's not right, or you didn't get it. And I think people are comfortable disputing with their credit company, using it as a vehicle to get redress their grievance. But I think the good representative thinks that because it's a doctor's office, that patients are less apt to dispute or question the amount of charges on the credit card because they feel they're in a subordinate position and that they don't go ahead and do it. So I was just curious. I don't know if medical doctors maybe use it as much as, say, dentists and other things, but I just didn't know what the process was. So I appreciate you answering that question.
I can just answer that generally. In general, it's very clear what a patient owes a doctor's practice. When they come to the doctor, they see the doctor. They have a $5,000 deductible. So in the first few months of the year before they've met that deductible, let's just say they come into my office, they see me, and then they get a $120 bill that goes towards their deductible. They get an explanation of benefits from their insurance company that says, your doctor charged $200. We only approve $120, and you need to pay $120 to your doctor. That's very clear. And we're charging them $120, and we have to write off $80 because we don't balance bill patients. That's not anything we do. We are contractually obligated to only charge the patient what they owe. So I don't think a dispute would come up, at least not in a medical practice. It's very clear what they get charged, what the insurance covers, and what the patient owes. That's given to the patient by the insurance company in the form of an explanation of benefits.
So I appreciate your answer, but I would say that I find the a transaction with a medical provider, one of the least transparent things that I go through. There's no list of price for sale. There's no menu when you walk in there. So you could say that the patient is clear about what they have to pay, but they're clear about after they've left the office. You don't even know what the bill is till later on, or you're leaving. So I think we could have a disagreement on that. I'm going to let everybody else ask questions. There's a lot of people signed up for this, but I appreciate your answers and your time, and you have a lovely day.
Representative Turkle, followed by Senator Ciccarella.
Thank you, Mr. Chairman, and thank you, Doctor, so much for your testimony and being here today. I have a few follow-up questions. First, I just want to say I agree with you that there is a major problem with how our insurance system works and the amount of out-of-pocket cost that residents have to pay to receive even basic medical care at times. And I agree with you, as your testimony states here, and as you said, that there's a major issue with the predatory lenders who design and profit from these products. I think we can agree on that too. But having said that, if the medical providers are marketing, promoting, helping patients sign up for these products, and medical providers, we know you're great at what you do, but you didn't go to finance school. There may be better options for patients to pay for their medical services than these medical credit cards. Isn't there some responsibility on the provider to protect their patients from predatory lending products rather than market and help them sign up for it?
I think that's an undue burden to put on doctors. I think we are not financial advisors. These products are out there. And I think in my practice, like I said, I've been in practice 18 years. I've used this maybe less than 10 times. And it has to do with patients saying, I have no credit. My HSA has no money. And is there anything else I can do? We happen to know about this and it's online. We don't have a kit or anything to hand patients. We just tell them, well, there is something called care credit if you want to look it up and try to use that. But these predatory lenders are allowed, like payday loans. They're allowed. They're predatory, and the government should have a responsibility to regulate them. But doctors also have to get paid for their services. So if patients want to elect to do it that way, that's what they're doing. We had an earlier testimony about somebody signing something under anesthesia. That's not even legal. You have to have a patient who can consent to something. So I'm not even sure how that happened. But yeah, we're not financial advisors. That is correct.
No, thank you. And I think we agree with that. Medical providers are not financial advisors, but they are marketing and promoting a financial product and choosing that product over other products that might be better for their patients. So I think it's something that maybe we can further discuss and come to some sort of agreement on that to better protect patients, consumers. You mentioned that it's illegal to help a patient sign up for this product under anesthesia, and that it's illegal to charge a medical credit card if a treatment is already covered under Medicaid, Medicare, or private insurance. But in both of those examples, they have happened. We heard testimony earlier today from an attorney who it happened. There had to be a lawsuit to protect the patients after that occurrence. And California has put in legislation, which has become law, to further prevent that happening. So would you be opposed if Connecticut had legislation that made charging Medicaid, Medicare, private insurance, and patients when they're undergoing treatment from being offered or marketed these credit cards, since it should be illegal anyway?
So I would recommend that the legislature look at the root cause of the problem, and that's the high deductible plans that are causing the debt to begin with. Insurance companies are already calculating how much a patient owes, how much goes towards the deductible. They could write literally 4 lines of code and put the patient on a payment plan. So let's just see the patient went to the ER and incurred $2,000 of debt towards their high deductible, $5, $10, $7,000 deductible, whatever it is that they have. So Blue Cross could say, okay, this is February, you incurred $2,000, so you should pay $200 a month for the rest of the year to cover it. Wouldn't that be easy? Wouldn't that be simple? Wouldn't that be a much better way of handling it instead of turning patients over, creating a market and an environment where predatory credit cards find a market to operate? An alternative would be to just ban these predatory credit cards.
Well, thank you, Doctor. I appreciate that last suggestion. I want to ask you more about and I'm glad to hear that, you stated you do not believe medical practices are receiving any kind of financial kickbacks. But can the Connecticut State Medical Society speak for every individual medical office, every hospital, every medical institution in the state that may have they're private businesses, so they could have private contracts and deals with the medical credit card company? How would the Connecticut State Medical Society be able to say that no medical practices are receiving any financial incentives?
So let's be clear, the State Medical Society only represents physicians, not other institutions or hospitals. I would say that we have surveyed our members, and I personally am not aware of any doctor who's receiving a kickback, and I will be very surprised if you find a doctor who's receiving a kickback from any of these products.
Well, thank you, Doctor. One of the incentives on Care Credit, which is the largest provider in the medical credit cards by Synchrony Bank, on their website is that medical, dental, veterinarian offices, for creating this partnership with them, their offices can receive prizes and rewards for promoting, maybe signing up people for the products. Do you believe that any medical office, staff, or provider should receive any kinds of rewards or prizes in partnership with these medical credit cards?
I do not believe anyone should be receiving any prizes or awards or any kind of kickback from any of these kinds of products. I would be very surprised to find any doctor's practice who's receiving some kind of substantial financial reward from these kinds of products. Like I said, I've personally, my office, maybe a handful of patients have elected to use this, not because we're promoting it to them, but because they were desperate to find something. We have not received any kind of kickback for this, no kind of little piece of bling or ticket or any kind of promotional benefit from care products. So these patients, they don't have any other credit. We know that people are living paycheck to paycheck. They don't have, the average American does not have $1,000 of savings to pay medical bills, but yet we let insurance companies design these plans where somebody's helping them. The federal government, now it's gotten pulled away, but when we had the Affordable Care Act, taxpayers were footing the bill for the premiums, but patients are still left with a $5,000 deductible, a $7,000 deductible that they don't have, and nobody's helping them with that deductible. That is risk that the insurance company is transferring to the patient and then getting transferred to the doctor. And that's unfair. That's just an unfair practice. I know that's beyond the scope of this particular committee, but these are the root causes of the problem. And that we need to address the root cause, not to do window dressings.
Well, thank you, Doctor. I think there's a lot of alignment on the position of the Connecticut State Medical Society and the language in this bill. And I'm glad to hear that a lot of the issues that we're trying to address here are not happening in medical offices, and these protections would not interfere with the way medical doctors are providing care. And I think there's a lot more conversation and work we can do together in trying to make healthcare more affordable for Connecticut residents. So thank you for your testimony. Thank you, Mr. Chairman.
Thank you. Senator Ciccarella.
Thank you. And thank you, Doctor, for coming and testifying. I just have a couple of questions. First, you stated that you do offer this product in your practice. Is that correct? Did I hear that correctly?
It's something we make patients aware of if they ask. The patients who need this, unfortunately, are the most vulnerable people who can't get any other credit. Like I said, in my office in 18 years, less than a handful of people, maybe 3 or 4 people have used it. And it's not because I offered it personally. I think they talked to my staff and my staff said, well, there is this product if you want to go look it up and use it. I think that's how it's come about in my particular practice. I can't speak for all the other practices and how they do it, but they advertise heavily so people are aware that it's out there.
Got it. Thank you. And with the individuals that use this to finance or pay for the services that you rendered, what would have they done if this product wasn't out there?
They wouldn't have been able to pay their bill is my guess. I don't know, and I can't even remember the individuals who've used it. It's been many, many years since anybody's used it in my office. So I'm going to guess these are people who didn't otherwise couldn't go to their bank and get an extra loan or get another credit card because their credit scores may be so low. I'm going to guess that, but I don't know that for sure. I mean, we don't know people's credit scores or how they're doing financially. But if they ask us, we know about this product, we'll tell them about it, but we don't in any way force them or condone them or print out the forms for them to sign and sign up for it. It's something they have to do on their own.
Got it. So, I believe, you're an orthopedic doctor, correct?
Yep.
So those surgeries are normally scheduled in advance, normally not emergency.
Some are emergencies, some are scheduled.
So if it was not an emergency and someone needed this surgery, they're in pain or whatever the case may be, and they didn't have the insurance, they could not afford the surgery, and this product wasn't there, you wouldn't perform the surgery if they couldn't pay for it, correct?
It depends on what the issue is and how debilitating it is. If, what's the problem? I mean, I take care of plenty of patients who never pay me. Some of them are illegals who come in, they need care, they're emergencies, maybe they're not emergencies, but they can't work without the surgery. And we still bill them. Sometimes they pay me, sometimes they don't. Some patients go on a payment plan. Most of my patients can go on a payment plan. Most doctors offer a payment plan. These are basically interest-free loans that we're giving patients. They can pay their bills with a delayed fashion. I think most practices, that's what we do for the most part. But some patients want to pay their bill or what have you, or maybe their bill's been outstanding for a long time. And they may opt for care credit or, I can't speak to what the situation may have been. It's not because they're not going to be able to get their care. I mean, we still take care of patients, or at least I do.
Got it. And I know there are other areas, whether it's dental or the vets, that wouldn't perform the service. So I appreciate that you do that. That's very kind for you to do that and offer those payment plans. But some people don't accept those payment plans, and then they have to find a way to get this service done for themselves, their child, or their pet. And if the product wasn't there and the doctors weren't generous enough to take a payment plan, they wouldn't be able to get the service done. That's kind of the concern that I have. I understand that this could be abused or manipulated, just like just about anything else can. And there's bad actors in every profession. So we want to find a way to address it, but also not limit options for people to get a service if they do need it. Again, if I was your patient, one of the handful or dozen or a few that utilize this credit card for your services, if I knew that I could have just went directly through you, I would have done that, not done the care. But a lot of other doctors don't offer that. Or do doctors offer a 0% interest rate for their services? Do they advertise that, or is that standard practice, or just, office by office, doctor by doctor?
I think it's doctor by doctor and patient by patient. So, each patient has a different circumstance and they can work something out with most practices. Most practices are interested in, we went to medical school to take care of patients. I mean, that's what we do for a living. So we're all interested in taking care of the public, but we also have to get paid for our services. So, there is going to be a point where somebody may have to resort to taking some kind of credit. Most doctors do offer payment plans. So most offices do offer discounts. As you know, our charges are artificial numbers because we can't collectively bargain. There's price fixing laws, etc. So we all have artificial numbers for our charges that nobody pays, except when an uninsured patient walks into my office, they're going to get my charges because I can't give them a different rate than I give anybody else. But insurance companies negotiate rates and pay me much, 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 much less than my actual charges. So there are ways and legal ways where we can work with a patient to negotiate a discounted rate, etc. So most practices have policies that help patients with their bills. So, I can't speak for every single doctor, but in my practice, we have a very clear policy on how to handle these kinds of situations. And I think most doctors have similar policies.
Interesting. I just wonder why we're hearing that business is even in place. If that is an option, I would take the 0% through my doctor's office instead of doing the credit card. So that's interesting. And I don't know if all the doctor's offices.
Well, let me just say, like I said, if there's somebody who has thousands of dollars of bills that they haven't paid in 6 months or a year or what have you, at some point, a doctor's practice has to collect. So I can imagine that might be a case where somebody's forced to then turn to a credit card product.
Got it. And that does make sense. And that's why if we were to ban this altogether, the option wouldn't be there. That's just what I'm trying to get to the bottom of. And be able to make an educated decision that's best for everyone, including the doctors, to make sure they're able to get paid. Because my understanding is, if someone utilizes the credit card, that the doctor's office would be cut a check by the company that's lending the money, correct?
Usually, yeah, it's some kind of EFT or direct deposit to a bank, but yeah.
So I can see where certain doctors, and I totally get it, they're in business, they have to make money, they have to pay their own bills as well, and their staff, that they're going to want to use this because they're going to get their money. They're guaranteed that money when the
Correct.
patient utilizes that. So,
Right. And I would say, I think, the healthcare issues in this state are very intertangled. And one of the biggest issues is the Medicaid fee schedule that is woefully inadequately pays physicians. So, some doctors are barely making enough money to keep their lights on. And pay their staff and pay their rent and pay their overhead and pay their malpractice. So yeah, some practices may be in a position where they need to get paid. They're seeing a patient today and they need to get paid today, or they need to get paid when the payment is due. So that is the case. I'm fortunate that I didn't come out with a lot of college, educational debt. So I'm in a little bit more comfortable position where I can actually take on more Medicaid patients. I can put people on a long-term payment plan. But I do admit that many practices can't afford that and can't do that. So I can't speak for every practice in Connecticut. There may be practices that need to get paid in a timely fashion to keep their lights on. I mean, we definitely have that and see that.
Understood. And I appreciate that. And again, I thank you for testifying, but just kind of one more, I guess, question. We were listening to some other individuals prior to you speak. I think one was the attorney from California, if I understood correctly, that people or doctors were getting a patient to sign something while under anesthesia, and they're clearly disoriented. And you stated that there's laws against that. So that should not be happening. And in a situation like that, that would be the provider's fault for doing that. And I'm sure that could probably be challenged in court. It wouldn't be the lending institution. Would that be your understanding of that as well?
Yeah, that's just unethical behavior. I can't speak to why that happens. And, there are bad apples, I suppose, in every profession, but that's a very unusual case, and not something that's happening commonly. I'm not aware of any case of that sort in Connecticut.
Got it. And then just last question, sorry to monopolize all of the time. When an individual is using this type of a card, my understanding is if you pay cash, you don't have insurance. Is it cheaper or more expensive if you did not have insurance?
For whom?
For the person getting the service.
I'm not understanding your question. Please rephrase it.
So your rates, so you just stated that you get paid less money for certain types of insurance.
Correct.
Got it. So the individuals that don't have insurance, you would charge essentially the full rate of your service, which I totally understand. I'm just trying to understand if that is the case.
Right. That is the case. They have to receive a bill for the full amount, but we are legally allowed to discount to Medicare. So I usually discount my patients who have no insurance to Medicare. That's what they'll get a bill for. Whether they pay it or not is a whole nother question. If they don't have any money, they don't pay it. So they don't even pay that. So it goes totally uncompensated. But I've had patients who come back, construction worker, illegal. I took care of him, operated on him, sent him his bill. And he told me, he said, I don't really have any money because he had missed about 3 months because of delayed care. It took him a total 3 months to get back to work. And then a year later, he came back and paid me. So, you know, that's what makes the practice of medicine rewarding.
Absolutely. And I thank you for what you do. And I'm sure your patients appreciate it. And again, thank you for testifying here today.
My pleasure. Thank you so much.
Thank you again. I really do appreciate it. And I just want to highlight a few things that might be lost in the testimony. Nothing about the bill as it's proposed here before us would prohibit these cards from being offered. It just regulates the very specific types of offerings that have garnered action from the CFPB, Consumer Financial Protection Bureau, that have gained regulatory scrutiny in numerous states across the country, lawsuits that have been entered into, payment schedules that have been paid by the types of card offerings that are most common in Connecticut and across the country. So we're not prohibiting the use of these cards in this bill. We're still making them available. They're still an option. Just the very specific actions and activities that have been deemed to be fraudulent, deceptive, or subject to litigation would be prohibited here. And oftentimes we hear things like, we shouldn't regulate this because only a few bad apples would do something like this. Well, that's literally what legislation is for. It's to protect against the bad apples. That's why you have litigation, not because you think everyone's doing it, but because you know a few people are. And so that's why we're here today, is to try to get to these very specific interests that have been identified in actions across the country, both at the state and federal level, in which we think there's cause for concern based upon, again, if you have a chance, public testimony that this committee has received today, both written and in person, about actions that we think demand a regulatory response. And I get that we can't solve in the General Law Committee the global insurance versus hospitals versus doctors versus everyone else marketplace that is subject to many conversations in this building and across the country. But we can regulate consumer products that we think may be exploitative in this committee. And that's what we're trying to do here today. I sincerely appreciate the challenges that you've got in your space. And I kind of want to learn more from you moving forward about how to tailor and craft a bill that would just impact the actions and not necessarily the people that you're working on behalf of. But I can't get there if I start from a place where we shouldn't touch these at all because I need them. Because it's clear as day to me that there's a problem that I've got to get to the bottom of. And I think you probably see that too. And I'm not trying to go after you or your members, but I got to get to the bottom of this problem. And I hope you'll be a partner with me in trying to get to that.
Definitely. The State Medical Society is more than willing, and myself personally, I'm more than willing. My cell phone number's easily obtained. I can give it to you. I'm happy to help craft legislation that makes this fair for everyone. You know, patients should not be placed in these very financially difficult situations. I agree. both from the high deductible standpoint and the predatory standpoint of these credit cards that take advantage of basically the most vulnerable people, as we heard earlier in the testimony as well. So thank you so much for your time and for working on this.
Thank you for your time. Next, we have Miriam Strauss, followed by Richard Engelhardt. How many more people can I rescue today?
Good morning, or I guess good afternoon, co-chairs, ranking members, and all the distinguished members of the committee. My name is Miriam Strauss, and I'm a policy advisor at Community Catalyst. We are a nonprofit health advocacy organization advancing a movement for health equity and justice. We are concerned about medical credit cards because they can increase medical debt, often for the most vulnerable patients. We support HB 5127. This bill does not ban medical credit cards. Instead, the bill addresses several deceptive practices around medical credit cards. Specifically, medical providers often sign patients up for medical credit cards. Sometimes, as we have heard, even when the patient is under anesthesia. Patients often mistakenly believe that they are receiving an interest-free payment plan directly with their provider. Patients also frequently do not understand the deferred interest terms and are surprised by the ballooning interest charges. Medicaid patients are sometimes charged for treatment on medical credit cards that their Medicaid benefits would have covered. And patients may receive so-called gift bags that are charged to medical credit cards. Often, these gift bags cost hundreds of dollars for unwanted items such as fluoride rinses and electric toothbrushes, and providers do not accept the return of these items even when they are unopened. HB 5127 addresses these deceptive practices while preserving patient choice in payment methods. This bill would ensure that patients sign up for these medical credit cards voluntarily. The bill would require disclosures so that patients understand that they are signing up for a medical credit card, not a payment plan directly with their provider. The bill would require that patients are notified of the risks of deferred interest and notify Medicaid patients when their Medicaid benefits would cover the treatment. In addition, the bill would ensure that patients specifically authorize items that are charged to a medical credit card and allow patients to return unopened items. For patients who pay off their medical credit card before the deadline, the medical credit card offers an interest-free loan. They can continue to use the medical credit card. However, for patients who are struggling to pay medical bills, the medical credit card can worsen their difficulties. In 2020, the Consumer Financial Protection Bureau found that the cost for those who were charged deferred interest was approximately 23% of the purchase price. In other words, patients who missed a payment deadline owed significantly more than the original medical bill. Today, that amount is probably higher because the APR on the leading medical credit cards has increased to 32.99%. In addition, patients who fall behind on medical credit card payments are more likely to be sued. Synchrony Bank is one of the top 10 debt filers in collection lawsuits in Connecticut. As healthcare costs continue to rise, it is important to ensure that patients can make informed choices. This legislation would ensure that patients are not misled about medical credit cards that can increase their medical debt. Thank you.
Thank you, Miriam, for your testimony here today and providing greater clarity on the issue. You've been here for a robust conversation with a number of folks who've come before us. Is there anything that you wanted to specifically highlight in addition to the things that you've heard today that might need some more clarification?
Thank you, Representative Lamar. I wanted to clarify that many of the practices that Dr. Hakeem Zargar highlighted in her own work are still allowed under this law. Patients can sign up for medical credit cards voluntarily. It sounds like her practice is not signing patients up for medical credit cards, but allowing patients to sign up on their own, and that would still be allowed under this bill. Her practice of offering payment plans directly to patients is something I think we would all encourage. But the problem is that many practices do not act like Dr. Hakeem Zargar and instead sign patients up for these medical credit cards without offering them a payment plan directly with the office. And patients don't understand that is an option to ask for a payment plan directly with the office. And then I would just like to highlight the previous testimony of Mr. Zhao, who testified about so many patients who have been signed up for medical credit cards without understanding what they were signed up for, and even charged for services that they didn't receive. This is not extremely rare. In fact, a search of the Consumer Financial Protection Bureau database will find many complaints of patients, often in dental practices, who were charged on medical credit cards for services that they never received and who have not been successful in trying to reverse those charges. So while I understand that this may be caused by a few bad actors and not the majority of providers, I strongly ask the committee to address these practices with regulation.
Thank you so much for your testimony today. Are there any other questions? Representative Turco has a question.
Thank you, Mr. Chairman, and thank you, Attorney Strauss, for your testimony today. You touched on a couple things that we haven't heard previous testimony on that I'd like you to maybe expand on. First is regarding these gift bags and how you mentioned people are being charged for them on their medical credit card, receiving them, not knowing that they had purchased them. Can you go in a little bit more detail about what's happening there? Because it definitely seems like something consumers need protections for.
Yes, thank you for the question, Representative Turco, and thank you for your leadership on this legislation. The gift bags that I have read about typically are offered in dental practices, and patients come home from the dentist with a bag of items, usually fluoride rinses and electric toothbrushes, which often cost several $100s. So the name gift is a bit of a misnomer. And these charges are put on the medical credit card that the patient opened that day. And providers are not accepting the return of these items, even when they are unopened, and when the patient comes back to the office saying that they didn't request these items and they don't want to purchase them. I don't know how frequently this has happened, but there have been numerous examples in the press, which I would be happy to provide to the committee in written testimony. But it is a problem, and I think that it's really a common sense solution to allow patients to return unopened items to the provider offices.
Thank you. And I see we have testimony later today from the Connecticut State Dental Association saying that sometimes these gift baskets include very personalized items like a custom mouth guard or something like that. But you're talking about generic products that can be included in these gift baskets as well. Is that correct?
Yes, and I believe the legislative definition of ancillary products is intended to reach products like fluoride rinses and electric toothbrushes that are not really what we consider medical products, but sort of add-ons, and that the provider's office should be able to accept if they are unopened for return because they could be sold again.
Thank you. And another area the bill mentions that it would be prohibited for these credit cards to be charged before the individual actually received treatment. Can you talk about why that's important?
This is important because there are numerous examples of patients who have been charged on medical credit cards for services that they never received. There are many complaints in the Consumer Financial Protection Bureau database of patients who visited a dentist's office, signed paperwork thinking that it was only for a credit check, and found out later that they were charged for services, even if the patient decided not to undergo those services, or even if the patient later decided to undergo those services with a different provider. And patients are submitting complaints because they were not able to get those charges reversed by going directly to their provider. So this legislation simply requires that patients are not charged until after they receive services.
Thank you for that. And you know, there has been some emphasis here today from testimony regarding the deferred interest schemes that are included in these cards, but are other medical credit cards that do not offer deferred interest rates, are they a problem too for consumers under your opinion?
I think it's a problematic practice for providers to sign patients up for any type of credit product. Patients can always sign up on their own. Most patients today have a smartphone, and so they can sign up. They can go out of, in the waiting office and sign up for a credit product if they choose to. But I think the problem is that there is an inherent trust in the doctor-patient relationship, and when Providers or their staff are signing patients up for financial products, often without the patient's full understanding. That's a risk to the doctor-patient relationship, and it's an abuse of the trust.
Thank you. And one of the other areas in this bill, when you're talking about that patient-provider trust, makes me think about the bill states that providers or medical healthcare institutions can't have sort of co-branded materials with their name and the medical credit card name together with a QR code and different ways that make it seem like this product is being promoted by that this product actually is being offered and is from the healthcare institution. From the consumer complaints that you've seen out there, why do you believe that language would be important?
This is important so that patients understand that they are signing up for a separate financial product with a company that is separate from the provider offices. It's very, very common to read complaints that have been submitted by patients who thought that they were receiving a payment plan directly with the provider office. So again, this legislation does not prohibit patients from signing up for medical credit cards or using any payment method that they choose. It's just meant to ensure that patients understand what they are signing up for and are not misled into thinking that they have a direct payment plan with their provider.
Thank you very much, Attorney Strauss. I appreciate your response to all my questions. Thank you, Mr. Chairman.
Thank you. Seeing no other questions, thank you so much for your testimony here today.
Thank you.
Next, we have Richard Engelhardt, to be followed by Thomas Burr.
Good morning, Mr. Co-Chairs and members of the committee. I'm Richie Engelhardt here today on behalf of Ancestry, generally in support of HB 5128. We look forward to working with the committee and AG's office to get to full support if we can align on the enforcement mechanism in the bill more closely to the Connecticut Data Privacy Act. We are proud of the work we've done on genetic privacy dating back to 2017 when the Future of Privacy Forum, a leading privacy nonprofit in DC, convened consumer and privacy advocates, medical ethicists, companies, and legislators on the Hill. Together, that group developed a privacy best practices document that includes what we believe are the appropriate guidelines for DTC genetic testing services. When states looked to regulate our industry a few years later, those best practices were translated into bill form. This approach has broad bipartisan and stakeholder support. Since 2021, 14 states have enacted similar laws, including very blue states like California and Minnesota, and very red states like Texas and Utah. In short, the bill requires that companies like ours make our privacy policies readily available in easy to understand formats, and that we must get separate express consents from our consumers for any collection, processing, use, or sharing of their genetic data. Additionally, this bill affords consumers with the right to have any biological samples or data that we have stored at their direction deleted at any time. They retain control over their genetic information at all times and always have. These have been Ancestry's policies since we began offering genetic testing services in 2012. Regarding enforcement, we oppose a private right of action in favor of exclusive AG enforcement for several reasons. First, consumers frequently download and share their raw genetic files with third parties or law enforcement. Agency enforcement allows for expert investigation to identify the actual source of misuse, which may occur outside of our ecosystem, preventing companies like ours from being unfairly targeted for third-party actions. Additionally, genetic data cannot be collected incidental to a consumer's use of our services. They make an active choice to submit a biological sample for lab analysis. Because this involves a small, highly regulated group of companies, agency oversight is more efficient and highly manageable. Similar laws in 14 states operate without a broad PRA, and we have seen zero enforcement actions. Furthermore, despite being under a narrower genetic privacy law in Illinois since 2008, no successful actions have been brought against these companies, although several frivolous cases have been brought and dismissed. Excluding a PRA aligns this bill with HIPAA, the Common Rule, and similar legislation supported by consumer and privacy advocates in other states. This bill codifies existing industry best practices. We ask Connecticut to align the national consensus by focusing on agency enforcement while protecting companies from meritless litigation. And with that, I'm happy to answer any questions the committee may have.
Thank you, Mr. Engelhardt, for your testimony today and for joining us. Briefly corresponded with Mr. Shortell. We're going to set up a time to kind of go over what you think the preferred way of handling this versus what the Attorney General's way is. And so I'm going to set up a time probably in the next week or two to kind of walk through some of those issues with him and you, hopefully, and we can get to a place of closer consensus, perhaps.
Yeah, absolutely. Look forward to that discussion.
That's terrific. Are there any questions? Representative Ackert.
Thank you, Mr. Chair, and thank you for your testimony. You had mentioned, I believe, and maybe I didn't catch it right, but you had mentioned about there is legislation, but not somebody actually enforcing that. Is that what you had said?
So the legislation's on the books in 14 states. We haven't had any enforcement actions, right? Because these largely codify our current practices that we've had in place since 2012. And even when you look at the situation with 23andMe, when they experienced a data breach, they did not commit any privacy violations. They had a data breach where, a third party mounted a credential stuffing attack. That was unfortunate, but the company's privacy policies were still in line with what's in this bill.
Okay, so you're saying that your company didn't have any violations. Is that what you meant? Is that what you're saying?
Correct. And 23andMe hasn't had any enforcement actions brought against them under the privacy provisions in this bill. They did have several actions brought against them under state data breach laws because after they experienced a data breach, they did not report it as required under various state laws across the country.
Okay, thank you for that clarification. Thank you, Mr. Chairman.
Thank you. That was a distinction I was trying to find in my recollection as well. So I appreciate you highlighting that and appreciate the question. Are there any other questions? Seeing none, thank you so much for your time, and I look forward to reaching out with you and your representation soon.
Thank you so much.
Next, we have Thomas Burr to be filed by Ian Corby.
Good afternoon, Representative Lamar and, members of the General Law Committee. My name is Thomas Burr. I'm the Public Policy Manager of the Connecticut chapter of the National Alliance on Mental Illness, otherwise known as NAMI Connecticut. NAMI is the nation's largest grassroots health organization dedicated to building better lives for the millions of Americans affected by mental illness. NAMI Connecticut and its 9 local affiliates provide support groups and educational programs for people with mental health conditions and their loved ones, provide public awareness events and activities to communities throughout Connecticut, and advocate for policies to improve the lives of people affected by mental health conditions. If you are unfamiliar with us, I did include some information at the end of my testimony, the written testimony. So today I'm here in support of HB 5037, an act promoting the safety of minors on social media platforms, and HB 5038, an act prohibiting predictive market platforms from allowing use by or advertising to consumers under the age of 21. Regarding HB 5037, at NAMI, we have been warning parents and caregivers for years about the pitfalls and harms that can be experienced by youth who engage with others on social media platforms, whether through cyberbullying, online predators, addictive games and gambling apps, unrealistic views of the world, or just interfering with sleep. We have been seeing far too many youth and young adults who experience mental health problems such as depression, anxiety, aggression, eating disorders, and in some cases, even suicidal ideation. And the research has been backing all this up. So certainly, I think that HB 5037 is a good thing to try to address some of this. Regarding HB 5038, at NAMI, we understand all too well the potential for addiction to any sort of gambling activity, especially on younger individuals whose brains don't fully developed until the age of 25, and recent research is indicating that could be as old as age of 30. As such, we echo the concerns and recommendations of both the Connecticut Department of Mental Health Services, as outlined by the written testimonies of Commissioner Navarretto, as well as the Connecticut Council on Problem Gambling, as outlined by their Executive Director, Diane Good. So in conclusion, again, we support both HB 5037 and HB 5038 as both important steps in protecting and improving the mental health of Connecticut's youth and young adult populations. So thank you, and I'd happy to answer any questions.
Thank you so much for your testimony. Both of these bills are important bills, priorities for our committee. With respect to social media, you've seen that this is a challenge that states are trying to confront across the country. We go up against some fairly well-funded opposition in those efforts, but it has bipartisan support last year. I anticipate bipartisan support again this year. I think there's a growing consensus on the role that legislators need to play and sort of providing safeguards for the most at-risk individuals in our community. So I do appreciate your willingness to weigh in on this and lend the social science background that you have to this conversation. It is vitally important, and I appreciate hearing from you.
Thank you.
Are there any questions? Representative Ackert.
Thank you, Mr. Byrd. Thank you for being here. Thank you for the work that you do. You had mentioned, because I'm 5038, so I'm going to focus on that question. I believe you were in the room at the time that I made the comment. I think that this is just a product that is just wrong to have, period, not just for the youth. And you had mentioned that you see addictive tendencies when people are actually older than their youth, or up to in the 30s, in the work that you do.
Certainly.
Is that a concept that we should be kind of not just regulating it, just think, hey, let's put this to bed and just ban it? What are your thoughts on going that far?
Oh, that's a great question. Hadn't really thought about it in that regard. And again, I appreciate that. I would say that might be a genie you could never get back in the bottle. But yeah, it always seems like, you're stuck in the position of always having to react to what happens in the world around us. And the devil always seems to get the upper hand on a lot of these things before it ever gets to this body or any other body here at the legislature. So, if that was doable, I wouldn't say no, because I don't think it provides any real value to this world. But again, that might be a big thing to accomplish.
Thank you. Yeah, I have a little libertarian tendencies at times, and you control your own life, but there's sometimes it's just so predatory that it goes beyond what the average person or anybody should be doing. But thank you again for your time. Thank you again, as always, Mr. Chair.
Thank you. Seeing no other questions. Thank you again, Thomas, for your testimony.
Thank you.
Ian Corby.
Chairs and committee for allowing me to speak on communication. I speak to you from the UK and I've learned a lot about care conversation. So allowing me to be grateful we have free healthcare over there. But getting back to age verification, I run the Age Association. We have 35 members to provide different ways of proving your age, identity, your age, line, privacy preserved methods, and these are used by governments, online platforms, retailers around the world. And these are widely used. We've done over 1 billion age in Europe, Australia,
Mr. Corby, hold on.
Verification, particularly.
Mr. Corby, just so we're having a hard time understanding you. The free healthcare is great. The poor Wi-Fi is preventing a bit of a problem for us to
Just 1 second.
understand what's happening. What's that? Yeah, Mr. Corby, why don't you try to turn off your video? That could.
Yeah.
help.
I've also changed Wi-Fi. Is that any better right now?
That's so much better. That's perfect. Thank you.
I have to have two methods here in the countryside. So we've done over 1 billion age checks across Europe, Australia, and North America. We're politically neutral, so we won't be saying whether or not it's you should be age restricting social media or even betting with the other bill. But what we'd like to do is inform you about the technology that's available to do age checks in this reliable, privacy protecting way. So I think the bill is very well structured compared to those that I've seen in many states. We like the fact that you suggest using commercially reasonable and technically feasible standards, because it gives plenty of choice to users, to consumers, as to which way they want to prove their age, rather than being very prescriptive about a single method. Obviously, the sort of methods we offer include government issued identity, facial age estimation, how you move your hands on a camera can prove your age, We can do it with your email or your cell phone number. We can check with your bank or a credit report. And people are increasingly having digital IDs on their phone where they selectively just disclose their age. So there are plenty of different ways for people to choose to prove their age. There were a couple of points I noticed as I was reading through the bill, which obviously I don't want to undermine the bill, but I would share some concerns I noticed when looking at it. The main one was that there's presumption that if you cannot determine somebody's age, you would actually assume that they are an adult. That is very unusual in all the legislation I've seen. I've seen this operate the other way around. So there's a sort of a safety first attitude that you assume somebody is a child unless they can prove that they are an adult. We also have to be very careful on geography. The bill talks about users who are in state, but what we've seen with other legislation is people are therefore using virtual private networks to pretend they're not in the state. And it may be worth amending the bill to be really clear that actually it covers everybody in the state, not everybody except those using a VPN. We've seen this in Australia, an example, where they've been very clear with social media platforms that they need to see through those VPNs. They need to monitor the users and identify underage users in Australia. And we would suggest doing something similar. The element of parental consent is fine and well understood. It obviously pays to respect parents' rights here. But there is a provision that you have to immediately delete the data having done parental consent, and that could create some problems if parents wish to withdraw their consent in the future. There is a trade-off really between the anonymity which we would normally offer for age verification and the parental consent process, where you need to get back to the consent and be able to find the record of it in order to withdraw it if the parent wishes to change their mind. And finally, there's a piece in there around mandatory warning language, and we have seen bills be challenged in the courts elsewhere on constitutional grounds, as that may be seen as compelled speech. But I'm sure you have better attorneys than I do to consider that, and it wouldn't be fatal to the whole bill. You just might find that that piece of it doesn't get through. We'll send obviously detailed written recommendations on those small amendments, but overall we think the bill is workable and feasible, and our technology will allow people in Connecticut to be able to prove their age anonymously and highly effectively. Happy to take any questions you may have.
Thank you. I appreciate it. It's really interesting having a chance to go on to even your website while you're speaking to kind of get a sense for the types of products. I'm fascinated the idea that how I'm moving my hand currently on camera can be used to identify that I'm 50 years old. I didn't realize that. But also, I think we're struggling with the nature of the lawsuits that states have won and lost in crafting this legislation, trying to create a framework that stands up to constitutional scrutiny and judicial scrutiny. So that's where some of the policy choices have been made, but there's a good chance I might reach out to you in the coming days and weeks to kind of get a sense for, in your experience, other opportunities for us to reform and make this legislation more certain to capture the population that we're seeking to protect. So I appreciate that.
If I may say, obviously you have to avoid content-based regulation. So it's got to be focused on the functionality, and that it's limiting the dangerous functionality for children, which is much more likely to survive judicial scrutiny.
Right. That's right. Right. Well, thank you very much. Are there any questions for Mr. Corby? Seeing none, thank you, Mr. Corby, and please don't hesitate if I reach out to you soon.
Thanks.
Next, we have Judy Cole. Judy, if you want to accept the invitation that our clerk is sending you, you need to accept that before we can welcome you into the Zoom. So Judy, if you're available, just accept that invitation. We'll get back to you on follow-up. Next, we have Heidi Olson.
Good afternoon. My name is Heidi Olson, and I am testifying in support of House Bill 5037. I'm a pediatric sexual assault nurse examiner, which means I provide medical care and collect evidence from kids who've experienced sexual assault, exploitation, and sex trafficking. Over the last decade, I've taken care of hundreds of kids who've experienced sexual harm and have collected data on real-time trends of how kids are being impacted online. As technology is rapidly changing, so are the ways that kids are being preyed on. The vast majority of grooming, sexual abuse, and exploitation has moved online to apps where kids are spending their time. Unfortunately, most parents are unaware of the potential harm that can happen when they hand their child the device. 1 in 4 kids report that an adult has attempted to engage them in sexual activity online. And these solicitations are occurring on apps like Instagram, TikTok, Roblox, and Snapchat, where parents assume it's safe for their kids to be. These apps and many others are anything but safe. They're inundated with predators and traffickers who are looking for vulnerable and unsuspecting kids. I took care of a 12-year-old who disclosed nearly 20 sexual assaults in 1 year. She met all of her abusers on Snapchat, with her caregivers being completely unaware that she was being groomed by strangers online, who then talked her into meeting in person. Her story is not an outlier. I've taken care of many teenagers over the last few years who've met their abusers on social media, which is becoming increasingly common. Kids are also experiencing exploitation online. Recently, Grok, an AI chatbot, was embroiled in scandal when it added a feature that allows users to create deep fake pornography. All that's required is uploading a fully clothed photo of someone, and the tool can generate extremely realistic pornography of that person. 1 in 10 kids say they've already used AI to generate nude images of their classmates. Grok was rated for kids 13 and up when this new to 5 feature was added. Clearly, being able to create pornography of one of your peers is not a child-friendly feature in an app, which is why age verification is so important. Not only are kids experiencing bullying and numerous mental health harms from social media, but they're also being exposed to violent pornography in unprecedented numbers. This phenomenon is contributing to the skyrocketing rates of child-on-child sexual assault across the country because kids are imitating what they're seeing online. I recently talked to a therapist who was working with a teenage boy who downloaded an AI chatbot that was teaching him how to rape young girls. I've spoken with numerous teens whose sexual abuse has been filmed and shared on social media and viewed by peers. Unfortunately, without better regulation, many quote-unquote child-friendly apps are not child-friendly at all, and it's our responsibility as adults to ensure our kids are safe online. So I commend the committee for considering protections for children as it's desperately needed, and I'm open to any questions you may have.
Thank you, Heidi. I appreciate your testimony today, and frankly, the work that you do. Thank you. Thank you.
Absolutely.
You reference a number of the concerns that we as a committee are dealing with, and trying to get a handle both locally and nationally, a way to approach the very challenging environment you find yourself. I'm sorry, I'm struggling just like I'm the father of 4 children, and the things you raise are things that even my own kids will share with me happening in their schools and amongst their friend networks. And I'll just say thank you, Heidi, for your testimony today. Are there any questions? Representative.
Thank you, Mr. Chairman, and I completely understand. Heidi, I wanted to thank you, Ms. Olson. I wanted to thank you for your testimony. I don't necessarily have a question. I thought it was important and impactful, and I can't tell you how much I agree with you. And I hope that we could do something meaningful to at least start the conversation or stem the tide of what's going out there in the world. So thank you very much for your time. And we all have kids. We all see what's going on in the world, and your voice was powerful, and I appreciate it. Thank you.
Thanks.
Any other questions? Seeing none, thank you so much, Heidi. Next, we have John Murphy, followed by Monique Ferraro.
Good afternoon. Representative Rutigliano and distinguished members of the General Law Committee, thank you for the opportunity to testify in support of House Bill 5037, an act promoting the safety of minors on social media platforms. My name is John Murphy. I teach digital media strategy at the University of Connecticut. My students will be going into this industry. Naturally, I want them building products aligned with human development, not exploiting it. But I'm here today for a more immediate reason: protecting minors in environments they are not developmentally equipped to navigate alone. I write and speak regularly on the societal and psychological impacts of digital media, and I've spent the last decade studying how these platforms shape attention, identity, and behavior. To be clear about what this bill is and what it is not. This is not about banning technology. It's not about restricting free speech. It's not about a moral panic. It is about developmental reality. Children and adolescents do not have fully formed executive function. The prefrontal cortex, responsible for impulse control, long-term reasoning, and emotional regulation, is still developing well into the mid-20s. Meanwhile, social media platforms are engineered by teams of behavioral scientists, data scientists, and machine learning engineers whose explicit job is to maximize engagement. Engagement means time. Time means more data. More data means profit. These platforms are not neutral communication tools. They are predictive systems trained to learn what keeps a user scrolling and then deliver to them more of it. For adults, this is already destabilizing. For minors, it is and can be combustible. We are running a mass behavioral experiment on children at scale without any guardrails. Rates of anxiety, depression, body image disorders, sleep disruption, attention span reduction, and compulsive use patterns have risen in direct correlation with smartphone-based social media adoption. This is not speculation. The data is now consistent across all studies. The bill's provisions are modest. Parental consent for minors, private accounts by default, no push notifications between 9 p.m. and 8 a.m. The last one alone matters more than most people may realize. The most neurologically vulnerable hours for adolescents are late at night. That is when comparison spirals, social exclusion anxiety, and algorithm amplification are most potent. Removing push notifications during these hours is not radical. It is basic harm reduction. And to be clear, parents are not failing. Schools are not failing. We have handed children a device that contains a casino, a broadcast studio, a popularity contest, a pornography distributor, and a behavioral laboratory, and we've told them to just manage it.
Professor Murphy, can you just summarize? You reached the time limit.
I'm sorry.
That's okay.
Sure. In summary, I just wanted to say we regulate tobacco, we regulate gambling, and House Bill 5037 recognizes this reality and that Connecticut has an opportunity to lead with this regulation, and I am fully in support of it.
Thank you so much, Professor Murphy, for being here. Sorry I had to cut you off at the time, but I think there might be some questions for you, and you'll
Sure.
have an opportunity to add to your testimony.
Happy to.
Representative Ritigliano?
Thank you, Mr. Chair. Thank you, Professor Murphy. I got to tell you, you deserve a lot of questions. The problem is I agreed with just about everything you said, so it's tough to come up with questions. But I did, as you were talking, the description of the device that we've handed them as a casino, as a Fortnite, it's so true and so impactful. And the fact that they're using algorithms, we've sort of all become slave to the algorithm, and the notifications at night, I thought was important. But I thought I'd take this opportunity to ask you a separate question on a different bill. And what are your thoughts on the bell-to-bell ban on smart devices in schools? And does it go far enough?
I'm fully in support of that. I've spoken on NPR in support of that bill. I think one of the reasons I'm in support of it is it gives teachers backing. It's very, very difficult to ask students, especially before college, to put their phones away, and to know that there's a regulation, there's a law in place, gives them support. And it also shows, I can see in the classroom, Representative, the students now that they're in college, they're okay with putting their phones away. Age 21, 22, they know the damage that's been done to their attention spans. And when I even voluntarily say, hey, can we put our phones down? They say, not only do we want to put our phones down, we need to, because I had an internship last summer. This is one story I heard recently. And I realized that I was in meetings with my boss and my client. I couldn't pay attention more than 5 minutes without checking my phone. I need to get a handle on this, and anything we do in the classroom to put our phones down, I know I need to do.
Do you think that we struggle with these conversations in my town and in my family? Do you think it goes far enough? I'm concerned that it's not just the smartphone, it's internet connected devices. When did we think that it was a good idea to hand grammar school and middle school kids a Chromebook that connects to the internet that, oh, they say is protected, but every kid could get around it, right? Do you think that we should do away with those also?
Well, that's an interesting question. I know that in Sweden right now, they're going back to pencils and paper in elementary school learning. They're getting rid of the Chromebooks. I think the fact, and I'm not an expert on this particular area, but I think the fact what I'm seeing from my students sharing with me, being on screens too soon is damaging. They need to learn hand to pencil or pen to paper. They need to learn social skills. They need to spend time with their friends, interacting, and too much time on screen is damaging. So anything we can do to promote that and encourage that is probably a really good thing.
Yeah, I totally agree with you. Anecdotally, you know how we have the Read Across America where you go into class, you start reading. And I thought the Chromebooks in my town were just for middle schoolers, which I don't agree with. So I'm in there with a 5th grade class. I walk in with my book that I'm supposed to read that day, and every single one of them is staring at a Chromebook. Nobody's talking. I never seen an elementary class that quiet my entire life. And I'm like, this can't be good. And I looked at the teacher. I'm like, what's going on here? She goes, well, that's where all the lesson plans are. And I'm like, there's got to be a better way to do this. I mean, I don't even think our educational outcomes have improved since we decided to do all this stuff. And I know it's a little bit off topic, but I think when we give these kids devices for school, it makes them acceptable, right? They're on them too much already, and they all figure out how to get around whatever Wi-Fi firewall they've done in school, and they go out and do whatever they want anyway. So I really appreciate your testimony. I'm glad I have a copy of it. And I appreciate your support in the issue, because I know, listen, some of us have always resisted mandates and things to place on our schools, but this issue is just too important. It's too important because this all turns into, now all of a sudden they're gambling. Now all of a sudden they're over past the age of consent where they could do these things on their own. They're all getting in financial trouble. It's a spiral. It really is.
And the evidence is in the college students who are coming of age 21 and 22. They are openly telling me in class when they have kids, they hope these rules are in place.
Yeah.
They know the damage it's done.
Thank you for your time and thank you for your indulgence, Mr. Chair.
Representative Ackert.
Thank you, Mr. Chair, and Professor, thank you for your testimony. I don't have a copy of it, and I'm not sure if it's online, but I'd like to get a copy of that. But, you know, and I like your point, you know, we hand them, you know, we don't have to do that though.
Right.
I was one of those parents. My wife and I did not allow our kids to have any gaming platform as they were growing up. We just didn't have it. And their cell phones were only when they finally got a car and needed to call us in an emergency. That's a little older though. But do you see anything in this legislation that needs to be changed or input, or you like the way it's submitted now?
The social media
The
bill.
one that 5037. Yep.
Yeah, I like the way it is right now. It's moderate. It's right down the middle. It's focused on safety. I know a lot of countries, you know, Australia and some European countries are banning social media for under age 16, and I understand that. I think that's difficult to pass here in the United States. So I think what Connecticut's bill is, as it's currently written, is focused on safety and putting the pressure on the platforms to create to design a platform that's safer for children and gives parents some further control. So I like the way it's written.
Right. Thank you again, sir. Thank you, Mr. Chair.
Just real quick.
Representative Ritigliano for the second time.
I was on the page for the testimony, and I don't believe, did you submit testimony to the committee?
I didn't email.
If you can email it to Betsy, then everybody will have a copy of it and we can memorialize.
I've been in
Thank
touch
you.
with Betsy. I'm sorry I didn't submit it.
Any other questions from any other committee members? I'll just end with Professor Murphy. I thought, you know, really interesting what you said. Time plus data equals profits, and the way the algorithms work to keep youth on the platforms to get more of that data to to then result in profits. And I know you had mentioned when I was on a panel that you were on talking about this topic, that you have your college students do a test and grayscale out their phones so it won't be as attractive to use the device. Is there anything like that should be done for children, even when this bill passes and becomes law, to further not make the actual product as attractive for them to use?
The platforms themselves can design these products to be safer for kids. They just choose not to. What I think is important is that grayscaling your phone, and anybody can go online and figure out, ask ChatGPT, ask Google how to grayscale my phone. It immediately turns your phone into a black and white TV, and it becomes very boring. My students and I are actually doing a test right now where they did an audit of their attention spans for 3 straight days. How many times per day did they check their phone? The average was 400 to 700. The next test we're going to do is when we grayscale it, what's the result there? When we turn off all notifications, all the buzzes and the bingings and the lights, what happens then? There are things that we can do, and there are products coming to market that can help us control our phones for our kids. I have a student right now who has ADHD, and he uses a product called Brick. He turns his phone into a brick for certain hours per day so he can focus on school. So there are products coming to market that will help parents, and I would encourage all of us to pay attention to those, because I think that's going to be a huge lift to parents.
Well, thank you so much, Professor Murphy. We really appreciate you being here and your testimony and advocacy on this issue.
You're very welcome.
Thank you. And I will turn it back over to Mr. Chairman, and we are at number 18, Monique Ferraro, Mr. Chairman.
Thank you very much. And thank you, John, for your testimony. I've had 3 people tell me while I was grabbing lunch that you were outstanding, so I can't wait to review your testimony online. Next, we have Marique Ferraro. Monique, if you come on, you just need to accept the link that the clerk has sent you so you can be entered into the Zoom. If you do accept that link, we'll call you back out of order. Sarah Frixell is unable to join us today. William Martinez.
Good afternoon, Co-Chair Lamar, Vice Chairs, and members of the committee. My name is William Chanis Martinez. I'm an associate attorney with Mariner Strategies, where I serve as counsel to the State Privacy and Security Coalition. SPSC is a New England-based multi-sector coalition of more than 30 companies and 7 trade associations. We work with legislators and regulators across the country to develop data privacy frameworks that protect consumers, drive consensus amongst stakeholders, and promote interoperability across states. I'm here today to testify in opposition to SB 117. I want to start at the outset by thanking the committee for your work on this bill. Our members share the goal of protecting Connecticut residents against data breaches. We actually had a productive meeting yesterday with the Attorney General's office where we raised some concerns with the language that's currently in the bill. We provided written testimony, but I would just like to briefly highlight 3 specific concerns that we had. First, the bill requires companies to hire an outside forensics firm at the very beginning of a massive breach, even though that determination that a breach occurred is itself the result of an investigation. So when suspicious activity is detected, companies immediately begin investigating using trained internal security teams and established incident response protocols. That investigation is what determines whether or not there's unauthorized access or whether a breach must be reported. We believe requiring an outside forensics firm before that determination is made creates a circular situation and may create duplicative work that is already, that is already underway. Second, we think the 90-day deadline to submit a full forensics report may not reflect the realities of large-scale cyber investigations. Given the definition of massive breach relates to the 100,000 Connecticut residents. We're talking about a very complex data breach. Likely will involve coordination with federal law enforcement and outside experts. An investigation of this nature, the facts develop over time, and a fixed 90-day deadline may require companies to submit reports before an investigation is complete. And finally, the bill does not provide protections for the confidentiality of forensics reports. These reports often contain highly sensitive technical information, including details about system vulnerabilities and security controls. We recommend borrowing language from the state comprehensive privacy law that would shield from public disclosure these types of reports. And we would believe that clear confidentiality and privilege protections would help ensure that sensitive security information remains secure while allowing the Attorney General's office with appropriate oversight. So again, we believe that these issues can be addressed. We remain committed to working with the Attorney General's office and the committee to find a balanced approach that promotes accountability while supporting effective incident response. Well, thank you all so much for your time, and I welcome any questions.
Thank you for your testimony. I think the conversations that you've had with the Attorney General's office are vitally important for you to continue. I think that balance is exactly what we're looking to see achieved, is the sort of regulatory and oversight responsibilities that we have with the privacy concerns that you are representing. Like those are important issues, and the balance is important for us to get a handle on. Ultimately, we're tasked with protecting Connecticut consumers, and so we're gonna err more towards where the Attorney General sees the interests of our residents best protected. So if you can continue to work with the Attorney General, I think that would help inform this process and get us a better product at the end.
Of course.
Thank you again. Are there any questions? Seeing none, thank you, William, for the time.
Thank you.
Next, I have Jeanette Lopez, followed by Brianna January.
Good afternoon, co-chairs, ranking members, and members of the General Law Committee. Thank you for the opportunity to testify in the support of House Bill 5127. My name is Jeanette Lopez from Waterbury. I am a student at the University of Connecticut pursuing my master's in social work with a concentration of community organizing. I work in the Hartford community, where I know many residents are already struggling financially. Medical credit cards are often presented as a helpful way for patients to pay for care they cannot afford upfront, but in reality, they can make financial problems much worse. Many of these cards offer no interest for a short period of time. However, if the balance is not paid off in full by the deadline, high interest rate is added retroactively. This can cause medical bills to grow quickly and become overwhelming. According to KFF, a national health policy research organization, about 1 in 12 adults in the United States owe medical debt. Research has also shows that people with medical debt are much more likely to struggle with paying for basic needs like housing, food, and utilities. Instead of helping patients, medical credit cards can trap them into deeper financial hardship. This issue affects people across Connecticut. Data Heaven shows that communities in cities like Hartford, New Haven, and Bridgeport already face high rates of financial and health insecurity. When residents lose Medicaid or face high out-of-pocket costs, they may feel pressured to use medical credit cards without fully understanding the risks. Connecticut has already taken steps to reduce the impact of medical debt on credit scores, as reported by the Connecticut Mirror. But preventing harmful debt from happening in the first place is even more important. House Bill 512 would ensure that patients are informed about financial assistance options before being offered a medical credit card. This is a reasonable and necessary protection. No one should leave a doctor's office or dental office with high interest rate debt simply because they needed medical care. I respectfully urge you to support House Bill 512. Thank you for your time.
Thank you for your testimony, Jeanette. I really appreciate you taking the time today to come out and speak before us. And I appreciate the work you're doing back in Waterbury and on behalf of students across the state. I want to say that this is something that relatively new to my awareness in the last 6 months or so. Largely, this conversation has been led by my Vice Chair Representative Turco. And so I'm going to turn it over to him because I think he's got a question or two. But I just want to say thank you for coming out.
Thank you.
Well, thank you, Mr. Chairman. Thank you so much, Jeanette, for being here today remotely and testifying. I don't have any specific questions on your testimony, but just want to show appreciation. It's always great to see, and I see you have a UConn email address, so go Huskies. Good to see that you're participating in our democratic process and testifying on an issue that you found of interest to you and to help protect your fellow residents here in Connecticut. So thank you.
Yes, thank you. Apologies I couldn't make it. I'm actually about to start class in a few minutes, so.
That's much more important. Thanks again. Next up, we have Brianna January, followed by Kyle Seppi.
Good afternoon, Mr. Chair, esteemed committee. Brianna January with Chamber of Progress. We are a center-left tech trade association. Our partners, unlike traditional trade associations, do not have a vote or veto on our positions. We continue to be in respectful opposition to HB 5037. Our concerns about the bill's impact to Connecticut's most vulnerable youth, including LGBTQ kids, remains the same as what I shared last year. Respectfully to the AG's office, we disagree that this bill is content neutral. By nature of requiring age verification for the purpose of restricting access to digital content, the bill places value on some content and access to it over others. And I'll note that just this morning, the Heritage Foundation has endorsed age verification. Committee, when a group that is known publicly to not support LGBTQ youth and to push disinformation about digital content turning our kids gay endorses a method of censorship, we think that we should ask ourselves why. We also continue to have serious concerns about age verification processes in general. We're talking about two main options on the market right now, some of which you've already heard about, either uploading a government ID, so your license or a birth certificate, or as a representative alluded to earlier, using cameras to attempt to determine your age based on your facial expressions, based on hand movements. Committee, I caution that both of these methods have been proven unreliable. They have posed cybersecurity threats with data breaches, and they are a tremendous encroachment to individual privacy. In all honesty, the methods that were outlined today by a previous testifier, they require collecting more data and a lot of private sensitive data, which is contrary to Connecticut's nation-leading data minimization efforts. And I'm glad that the New York rulemaking experience was brought up. We, and myself personally, have been deeply involved both in the New York and California processes, legislative and regulatory-wise. It does seem that the New York Attorney General's office has actually significantly watered down the age verification provisions of that law as they've worked with industry and other stakeholders and have found that it's difficult to verify age in a reliable manner. And I would also like to comment on algorithms. Platforms use algorithms to serve kids content that they are interested in, their favorite sports teams, the new dance craze, whatever it might be. But they also rely on algorithms to identify and remove that potentially harmful content that we've been talking about today. Instead, HB 5037 would require chronological feeds. Imagine a kid, one of your constituents, has been bullied in school all day. They get online hoping to find community, some entertainment, some relief from that experience. Instead, they're forced to see chronological posts from the very same bullies that they experienced earlier in the day, one by one, instead of their favorite sports team, because it's a chronological based feed instead of an algorithmic based feed serving them content that they have decided that they want to see. Surely that is not the intention of the Attorney General's office or the bill, but that is how this sort of algorithmic ban works in practice. With that, this is a very complicated issue, and I do hope that the committee will think of me and Chamber of Progress as a tool and resource as we continue to discuss what we agree is very important, which is protecting our kids online. And we do think that there are things that can be done around this space, whether we're talking about supporting private-public partnerships to educate parents and guardians on the plethora of safety and guardrails that platforms already have and can develop, or if we're talking about something that I specifically think most states should look at, which is K through 12 digital literacy education, to identify how to safely interact online, to identify misinformation and disinformation, and how these platforms and tools can be used for good, but also to identify when they can be used for harm and to combat that. I'd like to just note that, as you'll probably hear from more folks, there are a plethora of judicial opinions around this space, some mixed, but most of them have decided that these sort of laws, unfortunately, do not meet First Amendment tests around speech and content. And so I would like to have the committee really think about the role of the legislature in doing things like literacy or bell-to-bell phone bans in spaces like K through 12 schools where the state has authority over what happens within those walls, but courts have decided that it's kind of a mixed case about whether or not the state has authority about what happens in private homes when it comes to accessing digital content. So all of that is to say, this is an important issue that we are looking forward to working with both you as well as the AG's office, which I've already connected with, and we look forward to continuing that conversation. Thank you.
Thank you. And I appreciate your testimony here today, both this issue, and I'm sure we've got you back a few more times before the end of session. Usually you're online, so I appreciate you being here for us.
I come when I can.
Look, governors, attorney generals, legislatures across the country are grappling with this issue right now, trying to figure out what our role is, what the limits of our role are, and ways to encourage private-public partnerships are important, ways to regulate from a macro level what types of content clearly don't pass constitutional muster, but trying to determine a way to ensure kids aren't exploited does. And so I think that's where the tension is in legislating and rule writing, and trying to figure out where the extent of our authority continues and what the right approach is something on a bipartisan basis we feel like it's important for us to identify and reach consensus on.
And we agree.
I think I disagree with you ultimately on where the extent of those roles and responsibilities end, but I do appreciate that you understand where we're coming from, where we're struggling to reach a place where the parents who are asking for protections or asking for help, they know it's not about a literacy class. Like, I have 4 kids. I can put every literacy class on the books. I can spend the next 12 hours researching everything. My kid's gonna, within 15 minutes, figure out a way around everything I tried to do. And so I think there is a role and there's a responsibility for government leaders to try to craft rational and reasonable restrictions on the exploitation of children. It's actually what our constituents are asking us to try to figure out. I agree with you that it's not so easy as just saying they're banned. But I don't think our legislation is that either. I think it is a pretty nuanced way of approaching this, and I'm more than happy to accept your thoughts about how to get to yes. But
And we're happy to continue that conversation. And I'd also be happy to have our general counsel, who's worked on these laws across the country, to literally point out where you might have weaknesses First Amendment wise, to come discuss as well. I will just note that I just encourage the committee to not forget about the youth that do stand to possibly lose under this sort of legislation. Unfortunately, a lot of LGBTQ kids do not come from supportive families, and they do turn to online spaces. And so when you require things like parental consent, what happens when a parent or a guardian says, no, you can't get online. You can't talk to your friends. You can't access the Trevor Project's space. They have like digital communication forums and things like that. What happens then, or what happens in the legal question, which we haven't had answered yet, but if there's some sort of dispute between guardians are separated or divorced, one of them says, yeah, my kid should be able to access social media, the other one doesn't. How do we handle that as the public? Who does that land with? These are all questions that should be considered when we're discussing this sort of legislation.
Thank you. I'm going to turn over to Senator Maroney.
Yeah, hi. Thank you very much for coming. I'm sorry.
to see
The
you.
first part of your testimony. Yeah, nice to see you. And as Representative Lamar said, nice to see you here in person. I just was wondering if you could point me to where in the bill it requires parental permission to create an account. I see that there's the parental permission for overriding some of the default settings, but I only read it once last night. Usually I read these bills 3 or 4 times before I would ask questions, but I don't remember seeing that in there. So if you could just reference the line numbers and
I
say,
would be happy to if I can go back and look. I don't have the bill language right in front of me. But the concern is really about that conflict between if a kid wants to access something that has to be, that's identity related, for example, and a parent says no because they don't support the kid, which can happen in that process as well. What do we do then? And who's looking out for those folks?
right. No, I share your concern. I think that's why, we don't usually ban anything here. We put in guardrails, and I have had, friends' children who questioned their identity and unfortunately didn't have as supportive of parents as they'd hoped and ended up being suicidal and admitted. And so I understand that is an issue. I don't see where in the bill this prevents. And I do not want to deny someone who needs community the opportunity
No,
to have,
absolutely. I know that that's not the intention.
whatever, whoever that may be, who needs community. It may be someone who's just different and they can't find anyone in their school and they need to go online for that. But my reading of this bill is the parental permission is for overriding the settings in regards to the times when you can get the warnings, the amount of time you can have the feeds, nothing to do with content. So I appreciate that you'll get back to me with that, but I just don't see how this bill would do those things that you're saying.
Sure, I'll take a look again. Our reading again is that through those processes, you can then have that tension between a kid who wants to access something and a parent who doesn't. I'll note, I can't speak on their behalf, but typically the Trevor Project, which is the leading anti-LGBTQ suicide organization nationally, they typically oppose these sort of bills for that same exact reason and that same exact concern. And so I'd be happy to also loop in our friends who are advocates over there to see what their reading is and whether or not there is any real risk here with how the bill is drafted. But typically they also share those concerns.
Thank you. Representative Turco, did you have
Thank you, Mr. Chairman. And yeah, I'm just following up on that line of questioning as
Sure.
well, Brianna. Yeah, our intent of the bill, and I've spoken to the Attorney General's office, and we went through this bill when we passed it on the floor of the House yesterday, would not prohibit a youth from using the product, especially if their parents didn't want them to. It's just putting those regulations, restrictions around how the tech companies can target them with the data from algorithms. And if we have that wrong anywhere, I think the intent of this committee will want to fix that. So you can help us with this. But nothing in this legislation should prohibit, and the way we are reading it, it doesn't, a youth to find the content they want to find. If you were here earlier, I asked the Attorney General's office this specific question, and they verified to me that a minor is able to go on that platform, connect with LGBTQ community and content they want to connect with, and would not be prohibited. And as long as we agree on that language, then are you okay with what we're trying to do here?
I absolutely agree that that is not the intent. And nowhere in the bill does it say that a kid cannot search for what they're interested in. However, in implementation, by defaulting to a chronological feed, the kid is forced to see whatever is posted chronologically. So one by one versus what they're interested in. So like in my example, if I'm a queer kid that's bullied at school and I've been bullied all day and I go onto social media literally hoping to just see what's happening with my favorite sports team. Unfortunately for me, that's the Baltimore Ravens. We've had a very heartbreaking year. I'm not going to see, Yeah, we have. I'm not going to see what I am interested in and what the platform has curated based on my interests using the algorithm. Instead, I'm going to see whatever my classmates have posted one after one. And who knows what that could be? That could be anti-LGBTQ stuff. That could be stuff targeting me. It could just be stuff that I'm not interested in. And so our approach at Chamber of Progress is not to eliminate the algorithms, which help both you and me and youth and all users find content that they're interested in, but instead let's hold the bad actors accountable. And so if there are posts that are harmful, that should be taken down. And the reality is that social media platforms use algorithms to help identify those posts. And so what the intricacies of actually identifying and removing truly harmful content is under a non-algorithmic feed, I think complicates things logistically for platforms to not only remove stuff, but also to make sure that kids are seeing things, kids and all users for that matter, are seeing things that they're genuinely interested in versus being force-fed something that's chronological that they either have no interest in or could actually do the opposite, which is harm.
Well, thank you for that. It's my understanding with how the bill is written regarding the chronological order is that that is based on content that the minor searches for. So they search for, let's say, Taylor Swift's new album. They watch content, a video on one particular song. The platform then goes right to the next song and video on there. It sounds like from what you're saying that you would trust the tech companies, the algorithms that they have created to show minors, which whistleblowers working for these tech companies have said have been created to make the platforms addicted for minors. We heard Professor Murphy talk about previously that these algorithms are created to make the minors spend countless hours. I think the average is 5 hours a day the average teen spends on a social media platform, because that time plus gives them data, which adds to their profits. And it sounds like you'd rather the tech companies be allowed to use their algorithms to increase their profits than the alternative, which is what this bill would do, which would be allowing the minor to just choose the content they want to see when they want to see it and not what is forced upon them by the social media company.
Unfortunately, I think that that's a large misunderstanding of what I'm saying. And to be clear, Chamber of Progress does not have any social media platforms as partners. So I'd like to state that out front. I can't speak to the addictive or non-addictive quality of social media platforms and the algorithms that they use. What I can speak to is the fact that if I open up an app right now, I know that the algorithm is going to show me what I want to see based on who I follow, what I've liked, etc. Going to chronological feed instead will show me just whomever is posting whatever, whenever, instead of what I want. I'm not saying that the bill prevents a kid from searching, okay, let me see the Baltimore Ravens. Of course you can still do that. But the way that I interact with the platform would change dramatically in that it no longer knows that I want to see the Baltimore Ravens. Instead, it's going to show me 5 things about, I don't know, a Canadian hockey team, and then 2 things about posts from my peers that maybe aren't great content for me to see as a queer person or something like that. That's where we're concerned. We're not concerned about whether or not a social media platform can further enrich themselves with algorithms. We're concerned about the actual experience of the user. And when it comes to how kids are able to interact online, all of the platforms have parental controls for that very reason. As a parent, I'm not a parent myself, but as a parent, I would and could, if I wanted to, on every single platform that exists today, set a control that my kid does not have access between whatever hours, or they can only be on for an hour, or I don't want them to have the platform at all. That's my decision as a parent. We're concerned that you're getting into the territory of the state parenting and not using tools that are in existence And then you get down the rabbit hole of what does that mean for access to content and First Amendment and free speech and all of that good stuff. But from Chamber of Progress's perspective, we're really concerned about that marginalized experience and what does that mean for the queer kid, or what does that mean for the immigrant kid who uses social media to stay in touch with family and culture and friends back home. If they're being restricted online, what does that look like?
Well, thank you for that. I'm not personally convinced that these algorithms are providing more of a benefit for children than they are harming. I'm actually thinking that it would be really great if then I didn't do the age verification and made it so that I was a minor on the platform, because I actually think adults could benefit from not having these algorithms feeds, not having notifications all throughout the night. It might be something that adults, if this law passes, just choose to say, I'm not going to even try to prove an adult because I don't want the tech companies targeting me with these addictive algorithms. So something to think about, but
we hear the opposite, that adults, and myself included, I wouldn't want to give up my personal license, for example, just to be able to go on Facebook to see what my high school friends my acquaintances from decades ago are doing. I wouldn't want the platform to have that form of government ID now in their control, knowing that there are things like data breaches. And I'll just add for further consideration, again, as a center-left organization, I'm able to say this, most of my colleagues are not, but we are working in a context in which we've seen the Trump administration pull personal data from agencies like Medicaid, for example, without court orders. What prevents them from doing so if a platform is collecting personally identifying material, a driver's license that maybe it's not a full driver's license because it's just the government ID issued to folks that aren't full citizens? What prevents the Trump administration from doing that and saying, you already have all of the information, we're going to use it for immigration enforcement? These are conversations that we're having internally as a center-left organization and that I feel comfortable sharing with this body, but they are important considerations that when we're trying to do good for the greater population, Connecticut's youth, we have to think about if there are unintentional harms as well that we might be missing.
Well, thank you so much for answering my questions. Thank you, Mr. Chairman.
Thank you. All right. Next on our list is Kyle Seppi, but we had someone who has an emergency, needs to go a little bit earlier. So we're going to call Michael Shelby.
Thank you very much. I really do appreciate that. Good afternoon. I'll keep it really short. Good afternoon, Representative Lamar, Representative Turco. Good to see you again, and the distinguished members of the committee. I am here to offer my full support for Bill HB 5037. A couple of weeks ago, Representative Turco, John Murphy, who is gone, and I sat on the same panel dealing with this issue. My name is Michael Shelby. I am a licensed professional counselor, psychologist, and a primary therapist at the Technology Addiction Center. I have been working in the field of technology and behavioral addiction since 2002, alongside Dr. David Greenfield, who published the groundbreaking book, Virtual Addiction, back in 1999. He saw something. I have authored 2 books of my own, one in 2002 called Technology Addiction Manual, and the other one is 25, very fresh, focused specifically on this issue, social media, our children, mental health, and the impact on families. I'm a father of 2 millennials, married very happily for the last 38 years to the same woman. And I'm not here speaking theoretically. I'm speaking from 24 years of clinical experience and 26 years of personal recovery experience. Today, even as we sit here, Mark Zuckerberg is testifying in Washington, claiming that social media is not addictive. That is simply not true. Mark has a gigantic financial empire to protect. Social media is addictive. It activates the same dopamine-driven neural pathways as drugs and alcohol does. Addiction works very simply. We engage in pleasurable behavior, dopamine is released, the brain reward circuit, and it feels great. The brain remembers that it wants more. Over time, tolerance develops, and the user needs more stimulation, more novelty, more intensity, and the prefrontal cortex, the part responsible for judgment and impulse control, becomes less effective. That is an addiction. There is no meaningful neurological distinction between substance addiction and behavioral addiction. The brain doesn't care where the dopamine spike comes from. It comes from heroin, alcohol, gambling, or algorithmically optimized social media feed. In my own practice, I have tracked the data for 2 decades. Year over year, I have seen exponential growth in young patients struggling with anxiety, depression, sleep deprivation, attention dysregulation, and compulsive platform use. This acceleration directly parallels the rise of AI-driven engagement algorithms, systems designed to analyze every click, pause, scroll, cross-platform search, etc., to make content more and more and more compelling, more personalized, more irresistible. Social media is free, but when we don't pay for the product, we are the product. Our children are the product. Other countries are recognizing this. Australia has passed legislation banning social media access for children under 16. Governments around the world are acknowledging what clinicians have known for years. This is not a parenting failure. This is a public health issue. And you, as our elected lawmakers, are in a unique position to address this growing health issue. We're not Luddites. HB 5037 is not anti-technology. It is pro-child, it is pro-brain development, it is pro-family. If we fail to act now, we're knowingly permitting corporations to hijack the neurological development of our children for their profit. As a therapist who sits with these families every day, I can tell you, this damage is real. The suffering is real. The addiction is real. Please pass this bill and make it bulletproof. Our children cannot compete with advanced artificial intelligence designed to outsmart their still developing biology. Thank you, and I will be happy to answer any of your questions.
Questions? Thank you so much for your testimony, Dr. Shelby. I really appreciate it. I know you're on a time crunch.
I appreciate that.
We might reach out to you subsequent to this meeting today.
Many people here know where to reach me.
Thank you.
Thank you. I appreciate it.
Kyle Seppi, followed by Jonathan Earl.
Good afternoon. Can everyone hear me?
Yes.
Good afternoon. Good afternoon, Chair Maroney, Chair Lamar, and members of the committee. My name is Kyle Seppi. I'm the State Policy Manager at the Computer and Communications Industry Association, also known as CCIA. We're a trade association representing communications and technology firms. I'm testifying today in respectful opposition to HB 5037. First, CCIA believes that children are entitled to security and privacy online. And to echo something that the previous witness had mentioned, our members have designed and developed parental tools to individually tailor younger users online to their developmental needs. However, protecting children from harm online does not include a generalized power to restrict ideas to which one may be exposed to. Lawful speech cannot be suppressed or compelled. This is also why CCIA supports implementing digital literacy curriculum in schools. We've seen multiple states roll that out, including New Jersey and Virginia, which have can provide great examples for Connecticut to follow. And I understand the committee's intent on this bill, but as we look at HB 5037, it's important to note that the vast majority of lower courts have ruled on the issue of speech regulation. Most recently, in December of 2025, a Texas law had held that the First Amendment, or the court had ruled that the First Amendment does not permit states to require age verification to access protected speech. In shifting gears to another provision in the bill regarding warning labels, mandating warning labels raise First Amendment concerns that have also been ruled as compelled speech in federal court. In looking at a specific Colorado legislation, this is important to note, especially as many federal courts have ruled against state-imposed content regulations on digital services. A warning provided too often can also be ineffective due to a phenomenon which is called alert fatigue or alarm fatigue. The constant repetition of warning can lead users to be more likely to completely ignore a warning. Again, while there are laudable intentions of this bill, age verification mandates inherently require very sensitive data about users and adults. Such policies run contrary to the data minimization principles underlying federal and international best practices for privacy protection. requiring individuals to share sensitive information to third parties, such as we've mentioned them in the committee, whether it's an ID, a passport, biometrics, that can make recipients a prime target for identity theft or data breaches. I would also like to just add to what Brianna had mentioned. If age verification requests, biometric identification or ID for a younger individual, let's say in high school, that would also risk their anonymity in certain platforms for minorities who might be disadvantaged. So there's also that concern. And to clarify what the previous witness had mentioned about other countries, I think it's very important for Connecticut to just look at the fact that there may not be the same First Amendment rights and protections that are enshrined in the United States Constitution. So for those reasons, we oppose HB 5037.
Thank you for your testimony, Kyle. I appreciate it. Look, I think everyone here understands that comparing us to what other countries can and can't do, we all serve in Connecticut state government. We all know what our limitations are. We struggle with what the bounds of those limitations are. And a lot of this is new and generative ideas that are being that are arising on a daily basis. And if we don't test those, if we just sit in a conference room and say, well, someone told us that it might be unconstitutional, so therefore we couldn't do anything. That's not how we measure that. We try to determine what the appropriate guidelines are. We take the instruction that provided to us with judicial insight and oversight, and we craft legislation that intended to specifically stay within the guidelines and structures of our governing documents. That's true of all laws that we pass. If someone wants to challenge any of the laws that we pass, they can bring a suit and say, hey, we think that potentially violates the Constitution. And then it's defended by the Attorney General, who just so happens to be the one who's chiefly proposing these bills and believes they strictly fall within both Connecticut and United States constitutional constructs. So I think we're moving forward with respect to those limitations that you rightfully highlight, but we are going to continually come to a point where the advent of technology, the use of that technology, the appropriate or inappropriate targeting of protected classes is something that we've got to find a way to regulate. Now, right now, we can't pretend that we know the next 20 years of technological evolution. What we try to craft towards is the protections of individuals along constitutional guidelines. So I'm willing to take your advice and thoughts about how to adhere to that. To say, no, you can't do it because we don't think it will work and we think it might violate the Constitution. Well, look, we've got our Attorney General whose team is working closely, who's taking the advice from other attorneys general across the country, who's working with governors, who's working with constitutional experts across the country to try to find those bounds and try to craft appropriate legislation. So I think that's the tension that you might see from me when I don't immediately respond well to someone saying, no, you can't do anything because the Constitution says you can, or the First Amendment says you can't. Like, no, we test that. We try to figure out what the new rules and responsibilities are. We try to understand what the limits of that is. And we take the advice of our attorneys who are specifically tasked with defending the rights and protections of Connecticut residents. So that's where that tension lies. I don't know what the next 5 to 10, 20 years of technological evolution looks like. I do know that parents, citizens, even children are asking for some certain protections, and we're going to try to figure out what those can and can't be. I'd appreciate your help in getting to that point, because the no, you can't do it approach just isn't working for anybody. And I think that's where our attention is gonna evolve. Senator Maroney?
Yeah, thank you very much. I also want to push back a little on the warning labels as compelled speech. I think that we frequently see warning labels in various industries, right? You see them on cigarette packages, you see them on alcohol. I think what you're saying, the warning labels as compelled speech, was requiring graphic pictorial warning labels on FDA, which is different than saying that this is known to the Surgeon General or by the Surgeon General to cause mental health issues. The other thing is there's nothing requiring a government ID. It's just to use commercially reasonable methods for age to determine the age, which could be any of a number of methods. We're seeing, as people have comply with the EU laws, which as you point out, they don't have the First Amendment, but there are the Age Appropriate Design Code, the UK and in the EU, requiring age estimation and other tools. So the companies are able to comply in those other countries, so they can definitely, they have the tools to be able to comply here.
Thank you. Next up, we have Jonathan Earl, followed by Joseph Garba. We're going to move on to Joseph Garba, to be followed by Charles Bell.
Good afternoon. Can you hear me?
We can, thank you.
Thank you. Good afternoon, Chairs Maroney and Lamar, Ranking Members Ciccarella and Rutigliano, and the distinguished members of the General Law Committee. I'm Joseph N. Garba, and I serve as Senior Manager, Government Relations at StubHub. On behalf of StubHub, the world's leading ticket marketplace, I'm testifying in support of HB 5125 with amendments. While we support the intent of this legislation, which is to provide additional consumer protections for Connecticut live event fans, we respectfully urge the committee to consider technical amendments to ensure the bill achieves its goals without creating unintended harm to the fans it seeks to protect. I've submitted my testimony, so I will not read the whole thing. The legislation before the committee today would establish and modify certain requirements for the sale and resale of live event tickets, including a prohibition on the sale of speculative tickets, a ban on the use of deceptive URLs and websites, enhanced disclosure that secondary marketplaces are not the primary seller, and refund guarantees for canceled events. StubHub supports many aspects of these proposals, but requests the committee consider technical amendments to Section 1 of the bill that would, 1, clarify the definition of a ticket reseller to be the person who actually resells or offers a ticket for resale. 2, broaden the standard for ticket possession to address the practical limitations of issuer-imposed delivery delays and contractually protected allocation rights. And 3, clarify the technical arrangement between the buyer and seller of a live event ticket. These requested amendments would ensure that the appropriate parties are required and able to comply with the provisions of this bill. In closing, StubHub's mission is to continue to be a platform that provides a safe, secure, and transparent marketplace for fans throughout Connecticut. We appreciate and share the committee's desire to protect consumers, but believe technical amendments are necessary in Section 1 of HB 5125 to avoid unintended consequences. As the General Law Committee and the entire legislature considers this legislation, StubHub most respectfully submits language and requests an amendment to provide greater clarity regarding ticket possession and reselling. We ask for your favorable consideration of these technical amendments and remain available to you at your earliest convenience to discuss this request. Thank you very much.
Thank you very much, Joseph. I really appreciate your testimony. I've had a chance to talk to your team in Connecticut in advance of this public hearing. They made it clear to me that they thought that there were some technical amendments that were necessary. We had made a determination to just have this public hearing based upon the legislation that passed last year. I don't want you to read into it that we dismissed it. I talked closely with your team. I think you've raised some good points here, and we'll continue to work with them moving forward. So I'll reach out to them pretty soon after this to continue that conversation. They've been at my door pretty frequently to let me know.
That's good to hear.
And so I'll be with them soon to try to get to these points. So
okay, thank you, Chairman. And I've submitted the amendments in my testimony. It's at the bottom of my testimony.
I appreciate it. Any questions? Seeing none, thank you.
Thank you very much.
Next, we have Charles Bell, followed by Christine Minorowicz.
Good afternoon, Co-Chair Maroney, Co-Chair Lamar, and Ranking Member Rutigliano. My name is Charles Bell. I'm Programs Director for Advocacy for Consumer Reports based in Yonkers, New York. I have submitted a memo of support for the bill relating to the medical credit cards, HB 5127, and also for the bill relating to auto warranties, where we agree with the positions of Connecticut Legal Services and the Attorney General. We think that's a great bill for consumers and commend you for bringing that forward. On the medical credit cards issue, I broadly agree with concerns that have been expressed by other advocates. I commented on the CFPB request for information in 2023. We collected stories from some of our members about medical credit cards. I attached a few stories to my statements where we saw evidence of the problems that the other advocates have identified. And a large survey was carried out by National Consumer Law Center of Legal Services offices and medical billing assistance programs, where they found many of the problems that are targeted by the bill were real things that people are really struggling with. At the more macro level, as you know, we have about 100 million Americans with $220 billion in medical debts that they're paying off. Including, I've read that 1 out of 4 Connecticut residents have outstanding medical bills that they're paying off. And to me, as a public policy advocate, it's highly concerning to have 285,000 providers in the system promoting high-cost deferred interest credit cards to patients. And so I feel like the protections in your bill are just like absolutely essential. And even with them, we have some pretty significant gaps for coverage in the healthcare system. As for example, the Medicare program doesn't really recognize that eyes and ears and are part of your body and your teeth. So you have like many parts of care, dental care, not covered by Medicare. So many people at the very time in their life where they need expensive procedures like root canals can't afford to pay for it out of pockets. We have about half the population living paycheck to paycheck. So having a 33% APR credit card is not something a lot of people can manage. I'm sure a lot of us in this room pay our balances off dutifully every month. We've got them set to auto pay on the checking account. Well, a lot of the rest of the state is not like that, and people cannot afford that. And so I agree with the concerns that were raised by the head of the Connecticut Medical Society that the proliferation of high deductible health plans are part of the problem here. I was heartened to hear that some physicians have low cost payment plans. That's what you should get access to when you need help. That's the minimum we could do. The Federal Reserve provides its discount window to banks like Synchrony so they can get discount money at 3 to 4%, that the federal funds rate. When we build hospitals, we give them a construction loan of 5 to 6%. And yet here we are charging these top shelf rates to consumers that people literally will not be able to handle. They will face bankruptcy and medical debt collection lawsuits. And so I think we should not be embracing these products. We should really be discouraging their use. And I would encourage you to consider whether the state can do a survey of dentists, for example, and medical providers. How many of them do offer a low-cost payment plan? And is there a way we can lift those payment plans up so that they would become the first and preferred option rather than a dangerous financial product like a deferred interest credit card? Thank you very much.
Thank you. No, I think this has been a fascinating conversation for me for the last few months, actually, learning more about this product that's being made available in Connecticut, understanding the nuances of the offering, who's offering it, where it's happening. I was disheartened to hear from folks suggesting that this wasn't happening, and none of these horror stories are real, like they're all made up or something. And then you kind of go through the process of hearing where it's happening, and maybe it's not happening in one doctor's office, and maybe the folks who are engaging with an association aren't the people who are doing this, but it is clearly happening routinely in the state of Connecticut. It's happening routinely across the country. Your ability to expose that and raise awareness of it, I think is vitally important. Representative Turco has taken the lead over this for the last couple of months and really highlighted this issue for this committee. So I applaud him, and I just want to say thank you for your work helping to raise general public awareness about it. That's the reason we're here, right? Is because the public has started to push back and recognize the exploitation that they're suffering. And so I think trying to get a handle on legislatively what our response is the work of the next month and a half. Are there any questions? Representative Turco?
Thank you, Mr. Chairman. And just more of a comment. I really appreciate you being here. Consumer Reports, to me, is a very trusted source of information on protecting consumers and what consumers need to know about certain products before making purchases. And I think your testimony was very interesting when you said, with these products, there's a big concern that the healthcare providers, they're steering their patients towards them versus other products. Do you want to talk a little bit more about what you mean by that?
Yeah, I mean, I think if you look at the Care Credits website, and they are the largest provider. They have about 80% of the business. There are new medical payment plans coming in that are buy now, pay laters that pose some similar issues. But what I would say is the value proposition for the providers who sign up for this is very clearly outlined that this is a way to outsource your medical payment operations. You will get fewer patients walking out of the office refusing treatment if you offer these cards. You'll get more prompt pay up. We will handle all the debt collection functions on the backside. So I think we have gone down a road as a society towards maybe taking the path of least resistance here. And we really need to consider what is our responsibility to people who are getting care. You know, under the Hippocratic Oath, we say, do no harm. I think we have a responsibility to patients who are in the medical and dental ecosystems to come up with affordable repayment terms, especially where we know we have coverage gaps. And so I don't want to go to my grave with like Americans owing $220 billion in medical debt. I do fear it's going to get a lot worse with the recent cutbacks in Medicaid and coverage. So I think we can do better as a society to anticipate this problem and really fill the gaps to help working people who want to stay on track with healthcare. They want to stay on track with their other bills that they have, but we've got to make it possible for them to do so. And so having the equivalent of 300,000 credit card kiosks around the medical system is not the way to go. I remember earlier in my career that we set up credit card kiosks on campuses. And when you reduce the friction for someone to get a high cost credit product, you predictably get a lot of people who get in way over their heads, who face bankruptcy and ruined credit and so on. So we don't want to see that here in the medical system.
And I appreciate you as well, including your testimony, numerous patient stories about how they were affected by these products that you've received the Consumer Reports, because we've heard a lot today from advocates. We've heard from individuals that have told some of those stories, but to see the stories actually printed here that you received, this is a real problem. This isn't something that advocates are trying to solve that doesn't exist. It's affecting thousands of people.
Yeah, and you could go, I mean, the comments I gave to the CFPB included a lot of consumers who liked the product. And I'd be clear about that. If I get a 0% interest grace period for a certain amount of time and I can handle the repayments, it's a great product for those people, but it's a two-sided business model where the people with super prime credit are getting the greatest benefits, and the people who are working class people with subprime credit are most at risk of missing a payment. Like 40% of low-income borrowers could miss a payment on a deferred interest credit card. So they're almost guaranteed that a significant segment, the most vulnerable segment, will get into trouble with these, and that's why I think we have to speak out about them.
Thank you so much. I appreciate that. Thank you, Mr. Chairman.
Thank you. And I think that's right, right? For me, a 0%, $12,000 loan for a year, outstanding. I'll take it every time, right? And but like that's clearly not what the target market is for this. And like who falls prey to something like that, maybe don't understand the financial product they're signing up for, don't understand what deferred interest means.
Totally.
The definitions are difficult to comprehend. It may be an unfamiliar product in general. Like I think you've been able to highlight some of the problems and like what is most in need of the reforms that we're talking about today. So I do appreciate that.
Thank you so much.
Any other questions? Seeing none, thank you again, Charles.
Thank you.
Christine Minorowitz, followed by Anthony McDonald. Christine, please don't be shy about correcting if I didn't get the name right.
Thank you. Good afternoon, Senator Maroney, Representative Lamar, and members of the committee. I am Dr. Christine Minorowicz. I'm the immediate past president and current secretary treasurer of the Connecticut Society of Pathologists. On behalf of the CSP, we oppose Raise Bill 5128 unless it is amended to include two critical provisions. We support the goal of Raise Bill 5128 to regulate direct-to-consumer or DTC genetic testing. However, as currently written, the bill does not clearly distinguish DTC testing for non-medical purposes from genetic testing ordered by authorized healthcare providers for medical purposes. Without clarification, the bill could inadvertently apply to physician-supervised testing, creating conflicts with federal CLIA regulations and disrupting essential diagnostic testing in Connecticut. We urge the committee to amend the definition to explicitly exclude testing that is ordered, performed, or supervised by a physician or authorized provider and subject to CLIA. This ensures that medically necessary testing continues uninterrupted, protecting patient care. Second, DTC testing must meet meaningful quality standards. It should be subject to proficiency testing in the same manner as CLIA-regulated laboratories. Proficiency testing ensures laboratories perform tests accurately, which is critical because genetic information carries significant legal and personal consequences. Under the Federal Genetic Information Non-Discrimination Act, or GINA, genetic information is protected from misuse in health insurance and employment decisions. GINA underscores that genetic data is sensitive, consequential, and legally protected. If genetic information is important enough for federal protections, it is equally important that results provided to consumers are accurate and reliable. Inaccurate testing could lead to unnecessary medical decisions, anxiety, or unintended legal consequences, undermining the protection GINA provides. Without proper oversight, Connecticut risks real harm from inaccurate testing. Other states have acted. You heard earlier there's one person cited 27 states. New Hampshire has enacted legislation requiring laboratory safeguards for DTC testing, and Massachusetts currently has similar legislation under consideration. We propose an amendment requiring DTC genetic testing offered to Connecticut consumers be performed in laboratories that routinely participate in proficiency testing approved by the Centers for Medicare and Medicaid Services when and where available. And we have language for amendments in our submitted written testimony for both the proficiency testing and for creating an exclusion for medical purposes. These amendments achieve two critical goals: protecting access to medically necessary physician-directed diagnostic testing and strengthening consumer protections for DTC testing. We respectfully urge the committee to adopt them. Thank you for your time.
Thank you for your testimony, Christine. I do appreciate the suggested edits. It's really helpful for us as we proceed. Is there any questions at this point? I don't see any, but definitely as we progress during this process, like your ability to be available as we contemplate those suggested edits, it would be really helpful to us.
Absolutely.
Thank you.
Thank you.
Next, we have Anthony McDonald, followed by Tom Feltner.
Hello, everyone. Hello, chairs, co-chairs, ranking members, and members of the General Law Committee. My name is Anthony McDonald, and I'm the Executive Director of the Schubert Theater in New Haven, Connecticut. We are a performing arts center that brings in some of the most sought-after artists around the world, in addition to some of the most talented artists who live right here in New Haven and Connecticut. It was important to me to not only provide written testimony in opposition of Bill HB 5125 in its current form, but also verbally oppose it. And I want to be clear, we do not oppose many factors of this bill that are truly protecting the public from deceptive sale practices and tactics. It's a specific section of this bill, lines 9 through 54, which creates a massive loophole and in essence will codify the deceptive behaviors I believe this bill was meant to stop. The current language that allows resellers to sell tickets they do not possess, so long as they disclose that they are operating as a concierge or a seat saver, is the exact issue we need this body to help make illegal in order for our customers to not be price gouged by faceless entities that are merely looking to profit off of the hardworking, everyday Connecticut citizens. The issues that plague venues like mine are when these third-party sellers who have not purchased a single ticket as of yet are selling tickets for often 3 or 4 times the amount the ticket is actually on sale for by the primary ticket seller or the venue's website. In addition, they then only sell a level and a row. However, no seat number attached. For example, they'll sell Orchestra Row V for a specific day and already have it priced and everything. And yet, that ticket may not even be available anymore, or the real price is far less than what they've stated. There have been far too many instances when patrons arrive at the theater and they go to will call, and yet we do not have their ticket or any knowledge of them because they did not purchase them from us, but a third party. They then will show us their confirmation page, and once again, we will only have a row and a level to work with. There could be 41 seats where their seat could potentially be, and the only way for us to figure out where they're supposed to be is by seeing if all the other seats in that row have been scanned in already, and then we can figure out, hopefully, which seats are still open. This takes time away from customers who have legitimate tickets, or patrons who want to purchase tickets, or patrons who actually have tickets at will call for pickup. This also creates a bad impression on the show and the venue that they may think that we don't know what we're doing, and yet it's not our fault as they didn't purchase the ticket from us. Our hope is that you all will amend the language to finally put an end to allowing speculative ticketing selling in the state of Connecticut, which would ultimately protect the Connecticut citizen from bad faith actors. Thank you.
Thank you very much for your testimony. I really do appreciate you coming here and explaining the opposition on that section. That is not the intent of that section. That section was largely to protect a situation we thought had merit, which is if I own season tickets to the Red Sox, but the Red Sox don't release each individual game tickets until a few weeks before said game, but I have a contractual right to those tickets, even though the tickets weren't physically in my possession. I don't technically have them yet. When I purchased season tickets, I purchased season tickets that weren't even in my. So it was intended to address that situation. You highlight a very specific situation that I don't think was before us really in full earnestness last year. So I'm probably going to have to explore this a little bit more, because the very situation you highlight, we want to ensure does not happen. And if that's somehow contained in this language, our attorneys don't think that it is, but if we can clarify that further, I think it's important both to you and to us to get to that, because I think we're on the same page there.
Believe me, we would love to work with you on kind of trying to find the way for that language to do what you're saying, to protect those that have those season tickets, and who then have a right to sell it for whatever reason they have. Yeah. The problem is you can go online right now, see any one of my shows on lots of random websites, and they're selling and they're saying, tickets are going fast. I could have 1,000 tickets still left right now, but yet on their website, they make it seem like there's only 2 or 3 things left at 4 to 5 times the price. And even just today, I was looking at one of my shows coming up. They said row V, on once again, orchestra row V, no seat, just orchestra row V for sale for literally 4 times what I'm selling it for. And when I even went to my own website to now check, we don't have a ticket available in row V right now that they're selling. Right. Now, once again, maybe they did buy it, but more often than not, they haven't. Because if you do have the ticket, why are you then not telling the customer row V, seat 2, seat 4, seat 6, seat 8? That's the issue, because they don't actually have the ticket in their possession at all. They have not come to us yet to actually buy it. They're just, once again, trying to get folks that unfortunately find them first. No matter how much advertising we do, no how much social media posts we say to come, Schubert.com only, they find them and they go there, they buy these tickets, and they come to our theater now, and they'll see that the ticket that they bought for $200 is only worth $50. Yeah,
and no, you're right. You're right. We got to figure that. I mean, I see where you're coming from. We spoke a little bit last year with Brandon from the Bushnell, and he highlighted a similar issue, and we try to get on top of that. We thought we got there with the deceptive URLs and stuff like that, but I can see the situation and how it would play out. So yeah, let's spend some time working through that language and making sure we're closing that loophole.
We appreciate it.
Congratulations on a great season. I was at 7 with my family. We're going to see Les Mis in I think it's early summer, right?
Top of June. Yep.
Yeah, that's right. So my whole family's going out there. We are frequently at the Schubert. So, congratulations.
Well, believe me, we appreciate your support. Thank you for that. And we look forward to having you and your family back in the theater soon.
Oh, so see you soon. Thanks again.
Thank you.
Tom Feltner, followed by Lawrence Queso.
Good afternoon, co-chairs, ranking member, and members of the General Law Committee. I want to thank you for the opportunity to express my support for House Bill 5127 on medical credit cards with amendments. My name is Tom Feltner. I'm the Associate Director of Consumer Policy at Americans for Financial Reform, and I previously served as a policy advisor and senior fellow at the Consumer Financial Protection Bureau. I wanted to use my time today to share some information that hasn't been raised by prior witnesses, and will of course submit written testimony after the hearing. First, medical debt is eroding families' financial security. 15 million consumers have medical debt collections on their credit reports, and this debt erodes savings. It causes families to cut back on essential expenses, and it causes stress, anxiety, negatively impacts credit scores, and more. And of particular concern, medical debt has been shown to contribute to over 500,000 medically related bankruptcies each year. My second point is this: medical debt is disproportionately impacting families and communities of color. Discrimination inherent in housing, employment, and healthcare policies alone and in combination have contributed to Black and Latino families having lower incomes, household wealth, greater healthcare needs, less insurance coverage, and less access to affordable quality care, all of which is leading to higher levels of medical debt. In fact, Black families are nearly twice as likely to have medical debt as white families, and Latino families are 14% more likely. Now I want to turn to medical credit cards. These were first marketed for elective procedures before expanding into a multi-billion-dollar industry covering everything from primary care to emergency care to veterinary bills. The shortcomings, all of which have been described by prior witnesses in the healthcare and the health insurance systems, mean that patients can essentially be captive consumers and extremely vulnerable to unfair and expensive credit products. Lastly, the size and the scope of the problem here. The CFPB found that people used medical credit cards or loans with deferred interest payments to pay for almost $23 billion in healthcare expenses for more than $17 million in medical purchases from 2008 to 2020 alone. Over that time period, they also paid $1 billion in deferred interest. So these cards carry with them huge financial risks, and I'd like to reiterate just a few of them, many of which have already been raised. The 0% deferred interest model can become a debt trap. It can trigger retroactive interest rates exceeding 25% if that balance is not paid in full. High-pressure marketing in clinical settings can push vulnerable patients towards medical credit cards or emergencies when they are least likely to understand them. Healthcare providers may prioritize immediate payment over informing patients about legally mandated financial assistance or charity care. And once these cards get used, patients frequently lose their ability to dispute billing errors or negotiate costs directly with the provider. I will also note that consumers frequently complain to the CFPB about these cards even after the 2013 Care Credit Enforcement Action that prior witnesses raised. Next, I think particularly of interest to this committee, medical credit cards are sidestepping the limited protections against medical debt abuse already in place. These cards are not subject to Connecticut's prohibition on reporting medical debt to credit reports because they are treated as general purpose credit cards, not traditional medical debt. And these charges on these cards are already covered or are not covered even by the voluntary medical debt protections put in place by the credit reporting agencies for balances under $500 or for those debts that are paid in full for the same reason. So AFR supports 5127 because it addresses many of these harms by decoupling clinical care from high-cost financial products. And that is worth repeating. We are seeking to decouple, not prohibit. And the best way to do this is by targeting the point of sale marketing for medical credit cards and prevent providers from acting as financial product recruiters during medical visits. This bill does that. I want to use my remaining time to discuss how 5127 should be strengthened.
I apologize. Your time was up.
Okay.
The bell was your 3 minutes. I do have a question though, before I open it up to other questions. You mentioned you support with an amendment that you haven't submitted your written testimony. Can you describe the amendment you would like to see?
Sure. I think there's two changes that are necessary to prevent evasions. First, the bill currently exempts providers from charging a medical credit card for healthcare services if certain disclosures are provided. Those pre-charging prohibitions and the protections provided to insured patients are the primary mechanisms here that this bill uses to decouple care and financing, and there really shouldn't be any exemptions. The second is that the bill should also allow providers to disclose financial information concerning a medical credit card to a consumer in response to an unsolicited request. We are concerned that those written materials that ostensibly provide information about medical credit cards could easily contain exactly the kind of marketing materials that this bill is designed to prohibit. So that exemption should also be removed. Thank you.
So just you're saying you feel it should be stronger. We should be eliminating some of the exemptions within the bill.
Yes, and I can provide exact language in my written testimony for that.
Okay, great. Thank you very much. Are there questions? Representative Turco.
Thank you, Mr. Chairman, and thank you, Mr. Feltner, for your testimony. I just have a question on that last point. The current bill reads that because the bill doesn't prohibit consumers from using these medical credit cards when they choose to, and the bill says that when they want to use when they ask for information from the provider or the provider staff about these cards, that and there should be disclosures provided. But you're saying that the provider should not be able to give any information about these products, even when the patient asks the provider, if I'm being clear there?
Yeah, the concern here is that those disclosures are going to be very difficult to enforce unless each and every one of those was reviewed prior to being approved to distribute. Yeah, I think that without doing so, those disclosures could very easily, rather than provide informed, a description of the product, could also be the same kind of marketing materials that the bill designed to prohibit. Also, they would have to provide all the information that you just described for every single provider. And if they didn't do so, we would be concerned about possible anti-competitive effects.
Just to butt in with his permission, are you talking about basically even the pamphlet that might be in the doctor's office? Is that what you were referring to? Like an application or a pamphlet that.
Yes, correct. I think, because this bill is already prohibiting the marketing of these products, though, providing under the desk additional disclosures, we think would be a very limited value unless you had that available for every single possible type of financing product. So I think that overall we see that disclosure for one or many different medical credit card options to be a significant loophole to the marketing prohibition that this bill proposes.
Okay, so I think if we're understanding you correctly, you're suggesting even if the patient asks the provider's office, hey, I heard about this care credit or any medical credit card product they happen to hear about. Do you know anything about it? You're suggesting the provider should not, in their offices, give any information about those products, even when the patient asks?
Correct.
Okay. Thank you so much for that.
Thank you.
Great. Thank you. Are there any further questions from the committee? All right. Hearing none, thank you for coming to testify, Mr. Feldner.
Thank you.
Next, Lawrence Queso, Klein Memorial Auditorium.
Thank you, Mr. Chairman and members of the committee. I very much appreciate and commend you for sticking with this issue. I was here last year and I expressed some concerns. I have far fewer concerns this time, and I really appreciate that. The doing away with those deceptive URLs mitigates most of the concerns and experiences the client has. I've been tracking this, as I put in my testimony. I don't understand how anybody can sell a ticket from the Klein to somebody before they own it, before they have purchased it from us. And that's the dynamic that happens hundreds of times a year in our theater. And then you have confusion because there's no guarantee that the patron's going to get that ticket. And then we have confusion because we never know who the actual purchaser was, how to contact them if there's a cancellation. So you've cleaned up a lot of that problem. I think this, as I talk to the performers who come to our theater, they're very concerned because this is an issue that impacts them. And they're actually putting more of their efforts in their social media to educate their patrons not to fall for these deceptive practices. I've appreciated sitting here all day and hearing different testimonies about this, and I absolutely understand the illustration about the Boston Red Sox fan. Not my favorite team, but I was born and ruined a Yankee fan. But anyway, there's still a lack of transparency on all of that can be harmful. I mean, we have the Greater Bridgeport Symphony at the Klein, and they do 5 concerts a year. They sell a season ticket, but in September, that patron gets all 5 tickets. If they turn around and resell it, the symphony will never know, but that is more understandable than somebody who deliberately is buying something that they don't yet own and trying to sell it at whatever price the market will bear. I think that has to be addressed. And If that can be done, I'm a happy clam. And I'll root for the Red Sox.
Wait a second.
You get,
Thank you for your testimony, Representative Ritigliano.
thank you, Mr. Chairman. And thank you, sir. I wanted to let you know, I'm speaking for myself, but probably the committee, that we really listened to what you had to say last year and we took it to heart and we understood completely. And we did our best to craft this bill with you in mind. So I know there are certain tickets that you don't get when you first buy them. They sort of release them 2 or 3 weeks before the event. So I think that's what the bill is going for. But we want the bill to fix the problems that you were having because we understood it. So if you think we missed anywhere in this bill, because this is essentially the same bill we actually passed it out of the House last year, and then it got stalled in the upper chamber. Well, we try not to say the Senate. You have to talk to these two guys. But no, we're willing to listen. We think it's an important issue. We think we solved it in a way that was pragmatic and practical for everybody. I have to let you know that I was in a lot of meetings after the public hearing last time with the chairman and other members of the committee, and we took in information from everywhere and tried to come up with the best solution we could. So if you think we swung and missed anywhere, I would love for you to tell us where it is, and I think we'd be open ears and willing to listen.
Well, you really did address it, and I so appreciate it. The still sticking point for me is the lack of transparency that is possible by this practice of allowing somebody to buy a ticket from somebody that doesn't physically own it yet. It's almost instantaneous, I understand that, but that is where you can have real problems down the line, and you're going to have patron frustration where they show up to a venue. I have a board member that when I told them about this issue, he goes, well, I'm a Neil Young fan and I did this very thing. And a guy met me at the gate and gave me my ticket. Well, he shouldn't have had to wait all the way to travel to Las Vegas to get a ticket, but he didn't have assurance he was getting that ticket. So that's where the problems are. I don't have the easy solution to it other than to really nail down the definition of reselling.
Do you think that by us sort of cracking down on the fake URLs and the fake ticket speculators, which I think the bill does a decent job of doing, do you think that would tamp down some of the issues that you were having? I remember you telling us last year that they were selling full rows that they didn't even own, of tickets.
Yes, you have really addressed that issue. And that is going to clear up most of what we encounter. And I keep an Excel sheet on every bogus transaction that takes place. That's how I uncovered this, because I get on my cell phone or on my computer. The moment a sale is made, I see the confirmation that goes to the patron. And when I started to see that so many sales were going to a fake address in California with phony names, I suddenly realized these people haven't bought this ticket yet. And now I don't know who it is. And I've talked to the patrons because I track them down by seat number, and I talk to them when they come to the event. They had no idea they'd been duped and had paid the kind of prices that they
paid a lot more than what the list price was.
Much more.
Yeah. I remember. Well, please keep us informed. I'm sure I'm speaking for everybody, but we're trying to do the best we can. We hope this bill makes it over the finish line this year, and that things at the Klein are going well.
Thank you very much. Appreciate this.
Yeah, are there further questions? And just to echo Representative Ritigliano's sentiments that I think we all have the same goal. It's just we need to make sure we button down those lines, and it seems like lines 9 to 54 are the ones causing the consternation. So
Yes.
Thank you very much for coming to testify.
Thank you.
Okay, next, Maria Della Porta.
How do I change the video? Start video.
Oh, okay, we can
Hello.
see.
Good afternoon. Good afternoon, Senator Maroney, Representative Lamar, and members of the committee. My name is Dr. Maria Della Porta. I am a practicing licensed optometrist in Bristol, Connecticut. I am also the president-elect of the Connecticut Association of Optometrists. The Connecticut Association of Optometrists opposed HB 5127. an act concerning medical credit cards. We would oppose any bill that is an obstacle to receiving eye care. This bill would eliminate or restrict access to Care Credit, a financial product that many of my patients and staff use to obtain optometric services or goods, dental care, or veterinary services. My understanding of the terms of Care Credit is that extends 3, 6, or 12 months interest-free credit as long as you are current with your monthly payments. Failure to remain current results in a high interest rate on the entire amount. This is not that different from traditional credit cards that give you a 30-day interest-free period followed by a very high interest rate going forward. My patients are often faced with large health care plan deductibles and no coverage for optical hardware. Care Credit is a vehicle to obtain eye care services, glasses, and/or contact lenses to those who would otherwise not be able to access them. Thank you for the opportunity to share my thoughts on how this legislation would affect my patients.
Thank you. Are there any questions from the committee? Representative Turco.
Thank you, Mr. Chairman, and thank you, Doctor, for your testimony. I just want to clarify one thing. You said that the Optometrist Association would oppose a bill that would eliminate or restrict access to the Care Credit product. But this bill does not prohibit a patient from using a medical credit card. They can receive an application in the mail, or maybe they see an advertisement on social media. They click on it, they sign up, they get the card, they come into an optometrist's office and use it. So it doesn't do that. It would put some regulations and restrictions from the medical providers themselves promoting it to the patients. Does that make you feel more comfortable with the legislation?
Well, it does not allow us, from what I understand, it restricts us being able to have that Care Credit symbol in our office, just like we have Visa, MasterCard, American Express. And so it may limit that conversation that this is something that we do accept. Many of my patients who do use this product already have it, and they use this to make healthcare purchases. So our concern is not being able to, is that should we be able to make those patients aware of the fact that we participate in this program?
I think that's very fair, Doctor, and that's something we should certainly look at the legislation. If you have a symbol up on, the glass window in front of the billing office that shows you accept Amex, MasterCard, and you want to have a sticky that says Care Credit on there, but is Care Credit not part of MasterCard, Visa, or Amex currently?
No, it is its own. It is its own product.
Okay, so if you wanted to have a sticky that showed you Amex, MasterCard, Visa, or Care Credit on that glass window, I think that sounds reasonable to be able to do and let patients know you offer it. So I appreciate you providing that feedback. Thank you. Thank you, Mr. Chairman.
Thank you, Representative Turco. Senator Ciccarello.
Thank you. And thank you for coming to testify. So we're trying to flush out the pros and cons and really make sure the consumers are protected. And we want to make sure we're still able to do that and provide this opportunity for people to use this type of financing if it's necessary and it works for them. But we do want to address some of the concerns that we heard. A lot of people testified about the negative interactions or dealings when utilizing the Care Credit. And from what I gathered, it seemed to be that maybe the provider of said service, vet or whatever it is, may have been pushing people towards the card and maybe not giving all of the information. And that's what we want to address. Again, it seems like we don't want to take away this option. We just want to make sure consumers are protected. With that in mind, it seems like you offer or direct people to this service and care credit. What is that interaction like? If you could kind of run me through how you explain to someone this is an option.
So Care Credit, in order to be a provider for Care Credit, we have to have annual training through Care Credit on how to properly present this as an option. We are not encouraged to steer patients to any one of their products, and we must select and choose which financing terms we are willing to participate with. In my office personally, we usually select two options, which is a 12-month option and a 6-month option. The Care Credit is an independent credit card company, so we have applications for patients who are interested. In my practice, the majority of the patients already have this product as a credit card, and they use it and select one of those 6 or 12-month interest-free options to make a purchase. So we don't often have patients filling out those applications. However, the terms and disclosures are within the application that they could apply for this credit card should they be interested in having deferred interest option. So, we are not trying to steer patients toward this. However, if there are patients that have a need, and in eye care, again, the needs are going to be that they are trying to pay typically for eyeglasses or contact lenses. And so we're looking at smaller amounts for overall debt. And there are some services that sometimes certain procedures patients would certainly want to pay for with a Care Credit card. And they make that transaction on our end. They're responsible for paying Care Credit now. As a provider that accepts Care Credit, the amount that we actually have less amount that we make on a transaction with a Care Credit card versus an Amex or a Visa or a MasterCard. So there is a higher fee that is incurred from that transaction. So we actually make less money on that transaction. However, it does allow patients to receive something that they need. So if someone is in need of a pair of eyeglasses so that they can see the computer at work and do their job, or be able to drive and do those kinds of things for daily living in addition to provide for their families, then they need to have something to enhance their vision. And it allows them to provide for that and give them time to pay that off.
Yeah, I appreciate that. And so you actually make a little bit less on your service because it's a higher transaction fee than the 1.5% of an average credit card. Are you compensated in any way for offering the product?
Not at all.
Okay. And if someone is signing up right then and there on the spot, if they have additional questions, is there a 1-800 number that you could direct your customer to, or are you answering all of the questions for them or your staff?
So Care Credit does have a QR code, and they do have materials for patients to ask questions.
Excellent. Well, thank you so much for testifying and answering my questions. Thank you.
Great. Thank you very much, Senator Ciccarella. Are there further questions? Okay, hearing none. Thank you very much for coming to testify, Dr. Della Porta.
Thank you for the opportunity.
Okay, next up, Sue Bishop.
Is that better?
Yeah.
Good afternoon. My colleague Jim Nicolai is also here from our government relations team. So Senator Maroney, Representative Lamar, members of the committee, thank you very much. My name is Sue Bishop, and I'm here today as the Executive Vice President of Corporate Affairs at Synchrony, and also as a Connecticut resident. Synchrony is headquartered in Stamford, employing more than 500 Connecticut residents. And I'm very proud of the work that we do there to support our communities, our customers, our partners, the providers, some of whom you've heard from today here in Connecticut. We've also provided more than $25 million in grants to nonprofits and universities across the state, including the University of Connecticut, District Arts and Education in New Haven, the Special Olympics, and many, many more. I'm here today to oppose HB 5127, which could reduce access to care by restricting options on how Connecticut residents pay for health and wellness care for themselves, their families, and their pets. Synchrony's Care Credit Card is a credit card that can be used to help people and their pets get elective health and wellness care that's not covered by insurance, and to pay for it over time in a way that works for their budget. More than 100,000 Connecticut residents have a Care Credit Card and can use it at more than 2,000 locations across the state to pay for a variety of health and wellness services. These include LASIK eye surgery, chiropractic care, veterinary visits, massage therapy, hearing aids, cosmetic surgery, and more. Consumers can also use the card at select retail locations, including the Good Feet store, Sleep Number, Walgreens, and Walmart, just to name a few. For qualifying purchases there, I should add. Consumers appreciate our flexible financing options, and providers appreciate having another option for people to pay for care. Synchrony and Care Credit are committed to supporting consumers in making informed decisions when paying for health and wellness care because it's the right thing to do. A few facts about Synchrony and Care Credit that I think you'll find helpful. As a federally chartered institution, we are subject to the same fair lending and consumer protection laws as any other credit card. Our contracts prohibit providers from offering care credit in an emergency setting when a patient is under medical duress or is otherwise impaired. We do not pay providers to endorse care credit, nor do we provide any incentives based on transaction volume or the number of consumer credit applicants. In fact, as you've just heard, providers pay Care Credit a merchant discount fee whenever a consumer uses the card, just like they would on a Visa or MasterCard transaction. Both the cost and type of care is a discussion between the provider and the consumer. We generally do not know a person's deductible limit, insurance status, or eligibility. We're not aware of the cost of care being provided, the treatment being recommended, or the actual service being provided. Care Credit recommends providers discuss all payment options with consumers, including financial assistance. And lastly, we require, as again you just heard, that providers and their staff go through training before they can offer the Care Credit network, and they must retrain at least every 2 years, if not more frequently. We strongly support efforts to ensure that our consumers are well informed on how they pay for care, and we spend a significant amount of our resources to do our part to ensure that that happens. Just last year, we launched something called the Fair Financing Principles to establish a new standard for transparency and education for financing options. You can learn more about that at carecredit.com. However, we believe FB 5127 could significantly impact a consumer's ability to access care and limit their choices for how to pay for it. We ask that you vote no on the bill. I'd be happy to answer your questions.
Thank you very much. Senator Ciccarella.
Thank you. Just a quick question. I'm sure you've been listening to some of the testimony, and it seems like there's valid concerns with maybe bad actors who have the ability to offer this card, to offer it maybe when somebody is under anesthesia or some other narcotics possibly, or maybe in a very stressful situation like trying to save their dog. And even heard that people may have been able to utilize the insurance they have, but then were pushed towards the card. I guess the first question is, do you have any recommendations on how we could address that problem with still being able to offer your service to the people who need it?
Sure, thank you. A couple of things. As I mentioned, we are trying to do as much consumer education as we can, and that is why we introduced the Fair Financing Principles last year. We also do a lot of training, as you again heard today, with our providers. It is in our contract that they are not allowed to offer to somebody under duress, to somebody who is under any type of medication, et cetera. We do monitor our providers, and when we find, and we also take complaints, obviously, from through the CFPB or directly from our consumers, or we have talked with many of the consumer advocates who are here today, and even suggested that they could funnel their stories to us so that we can investigate those providers. We do go back out to those providers, and if we have repeat offenders, we kick them out of our network so that they may no longer accept care credit.
That's great. Thank you.
Mhm.
'Cause that was definitely a question I have to make sure that that's not happening. And if it is, we address the bad actors and still, again, be able to have this service that helps people that may not have credit or access to the credit cards. So
And in our training, I should also mention that in our training, we do, and in our contracts even, and Jim, maybe you can jump in here, it is required that they first offer, let's check your insurance. What other options do you have? That is certainly something that we are asking the providers to do. And that in our fair financing principles, that is item number 2, that we are suggesting that consumers also ask their providers.
excellent. And then last question, have you kicked providers out of your network, not allowing them to offer it? You have done that.
Yes.
Okay. Thank you.
Yes.
Yeah. And in addition to that, before we get to the point where you end up doing we try to do retraining, remediation, investigate claims. And if we find that the card holder was charged for something they shouldn't have been, we will address that.
Thank you, Representative Retigliano.
Just a quick one, because just based on your last answer prompted a question. When you said a contract, so the provider has to sign a contract with you in order to accept your credit card? Can anybody just walk in and pay with that credit card, or do they have to have a?
No, they have to, the provider has to be on what is called the Care Credit Network, just like the drugstore down the street has to be on the MasterCard or Visa network to be able to accept those cards. The provider has to be a part of the Care Credit Network in order to accept the card. And in order to be a part of that network, they have to complete a contract with us.
So the Care Credit Card doesn't have a Visa or MasterCard logo?
Some do, some don't. I will try not to go too deep on this, but some people cannot qualify for a card that can be used outside of the Care Credit Network. So some can only be used within the Care Credit Network. Some people, because of their credit score, can qualify for a Care Credit Card that can also be used anywhere on the MasterCard. I think it's MasterCard, right? Not Visa. On the MasterCard network.
How do you that in itself has lots of questions now. I have to be honest with you, because how do you, if somebody uses the MasterCard version of your Care Credit Card, I'm guessing that all the charges for medical care have that deferred interest feature. Is that an automatic feature on your Care
That
Credit
is
Card?
not an automatic feature on the card. And again, if they're using it, for example, because it has a MasterCard, we'll call it a bug.
Yeah.
Because it has a MasterCard bug on it and you went into the cafeteria here and tried to buy a cup of coffee, that merchant code that says this is a coffee shop would not allow you to use it. First of all, it can only be used for qualifying expenses that
Even with
fall
the
under.
MasterCard logo?
Yep.
Okay. So it's not an automatic deferred interest card. So if they use it at their doctor's office once a month for 10 months, it doesn't automatically, it has to be a special promotion. How exactly does that work?
There would have to be separate promotions depending on what they used it for. That would have to be arranged at the time of purchase. Jim, if you, I'm not an expert on the back end.
You or arranged through the provider?
So when they go into the provider, and first of all, any transaction that's $200 or less is not eligible for a deferred interest promotion.
Okay.
So once you get above that, at the provider's office, you would select amongst the promotions that they offer, be it 6, 12, or sometimes 18 months.
The provider does that offer, not you guys?
We're servicing the account. And so, and the reason that there are the different promotions is the provider, the merchant discount fee is based on the length of the promotion.
The merchant discount fee.
Yeah, so that's the fee that
Because
they
we'll
pay
be taking
us.
more risk
You
for
mean
the
your swipe
longer the.
fee? Or you're talking about your swipe fee goes up or down depending on how long the deferred interest is?
we call it a merchant discount fee. It's not quite a swipe fee, but it is
It's your
what
transaction. fee,
it's
a
the
percentage of
fee that the
purchase.
provider pays us in order to offer the product. The longer the term is, the more the provider will pay Care Credit to offer that, because we are then taking more risk on that consumer paying us back.
So if the 18 months, no interest, as long as you pay it off, they pay you an additional % or 2 or 10 or whatever you charge for the opportunity to do that. What happens if the person doesn't pay it off in time and they end up paying the interest? Does money go back to the provider or
No,
no? So, okay, so you get a higher percentage for giving a deferred interest purchase to somebody. And then you get all that interest that you just deferred if the patient doesn't pay it off in time. And the reason I started asking that question is because it all started with you saying contract. I'm like, I don't know why you would have a contract if it's not compensated. Why, why wouldn't you be compensated for signing a contract? I wouldn't ever sign a contract with anybody unless we get paid, to be perfectly blunt. But you're saying the contract is for the right to use your credit card. So if it had the MasterCard logo and somebody offered the deferred interest, I was curious to how you would separate a non-deferred purchase from the deferred purchase. That's where the deferred interest gets confusing to me, even to me. And I understand the deferred interest. I get it. I'm getting braces, no interest for 2 years. If I pay it off, I'm good. But what if in the meantime, I use the MasterCard for something different? Now, when I make that payment, where does it go to first? And how do you reconcile the fact that I have a deferred interest purchase and a non-deferred interest? And who decides where that payment is applied when I make the payment? Is it going to the non-deferred first, or is it going to the deferred first? And then if it's not going to the non-deferred first, am I getting charged interest on the non-deferred immediately? Do you see the confusion? So I never thought when the good representative brought this up, I was like, well, everybody understands deferred interest. We all bought a TV at Best Buy 20 years ago and it all worked. But I got to tell you, that to me is confusing now. How do you reconcile that?
I don't know the back end of how
Yeah.
it is reconciled, but I know it is clearly differentiated on your statement. I would also point out that 80% of our consumers pay off on time. So to your point, so 80% of the people using Care Credit nationwide are paying 0 interest for the medical care that they want and need. And so let's just start with, a lot of people do understand it. Then it would be differentiated on your statement, and one is paid before the other. You can call and change that as well. I just don't know which one it
So
defaults
you would
to.
have to actively tell you guys where the payment's going to, meaning, no, this $200 payment, 150 is for my deferred and the other 50 is for the whatever I just bought using the MasterCard logo.
Right.
They would
And
have to tell you that every time they made the payment.
Well, no, it defaults to one or the other. I just personally don't know which one it is. I could find that out.
Yeah.
But if you also wanted to change it, or you wanted to split the payment, then you could call and do that.
and the payment order that you're getting at, it's actually, the rules are established under federal law. And so we have to follow federal law on that.
Can you articulate what the law is?
Sure, I may not get it totally perfectly here, but I can get you the proper answer. But essentially, the payment that is going to be on a deferred interest promotion. So let's say, 2 months ago, I took my dog to the vet, and then this month I got my eyes checked and paid there. The payment will be applied to the deferred interest promotion that is paid, that is due first. So it's based on that due
The
date.
entire payment? So that means that the eye doctor that you just went to now is interest now. So you're actually paying the interest. It's paying off your non-interest one before your interest one?
No, it's paying the interest one first.
So you're saying that if you make a $200 payment and you owe $500 for the optometrist and $2,000 for the vet, it all goes to the optometrist first?
Yeah.
Because that one's bearing interest.
Maybe I'm not following. I think what I could do for you is I can talk to our folks internally and get back to you on the payment ordering.
Clear? I
Is she-
didn't
that
know if my
okay?
question was unclear or not. But if the level of confusion for, I have 2,000 in deferred and I just made a 500 in non-deferred and I just made a payment of 200, where does the payment go? Like by default, does it go to the one collecting interest immediately Or does it go to my deferred one first so that I don't get all that interest in whenever the promotion period is up?
I see. So because, the non-deferred promotion is, the due date on that is first, really, it's going to be applied to that. And so then when the deferred interest piece comes in, and all of this is spelled out on the monthly statement, it's actually in a box on the front page that specifies, what balances are, subject to a promotional period, when that ends, and then in what order.
So contract, just to be clear, you go to the doctor and say, hey, would you like to take our credit card? But basically they could take any credit card because they have a merchant number, but your credit card, the advantages of your credit card is it allows them to come up with a deferred interest promotion for their services. So that's what you're offering them. And you look at them and say, okay, it's 2% if it's not deferred. And depending on how long you choose to defer it is how much we're going to take. Is that essentially?
Yes.
Okay.
Yes.
All right. But they're not compensated other than you giving them the money. I would imagine you pay
money that they have earned by providing a service.
That's
for
right.
their
But you
clients.
give
Yeah.
that immediately regardless of the contract they set, the 2, 3
Correct.
days, whatever the turnaround is for you.
Correct.
Okay.
Yes.
Okay. And there's no compensation for them signing it up.
None.
Period.
Zero. No incentives. Representative Turco, I heard you say that there are prizes and rewards. We do not offer anything to our providers other than perhaps to get them to do the training renewal, a pizza. But, and that is
Depends where the
only,
pizza's from.
and that is only, of course it's from New Haven.
Yeah.
No, that is only, only for training, nothing on promotion of the product, nothing on volume of product, nothing on number of applications, no incentives whatsoever, ever.
So one of the previous testifiers invited us to go to the website and take a look. And you are offering perks. But the way I read it, I think it's for that MasterCard.
It's for the
like you showed,
consumer.
like, it's for the consumer,
Right,
right?
just like your American Airlines card gives
That's
you
right.
points, or your, Brooks Brothers card gives you rewards points to put. Yes, we offer rewards for consumers on the MasterCard version only.
I appreciate your answers. Probably could do this for another half hour, but I won't.
I know.
And I believe Representative Turco could ask his questions.
Representative Turco.
Thank you, Mr. Chairman. Mr. Nikolai, am I correct in that? And Ms. Bishop, it's nice to see you again. I was on campus, as you know, this past summer. And I know you're both very nice people. Everybody I met at Synchrony Bank was very nice and pleasant. You're Connecticut residents. And I just want you to know, my questioning, my concern of this product, it's not personal. I think you're nice people. You work for a company, you have a job to do. But I have serious concerns with the actual product that Synchrony Bank is, providing with Care Credit that I think we have to improve some of the consumer protections around. And maybe there's some things that we can find alignment on. I think I'm making an assumption that I think you would probably agree, and you stated too, it should be illegal anyway to be able to provide, for providers to provide these products when an individual is undergoing an emergency, under sedation, anesthesia, if the treatment should be covered under Medicaid, Medicare, or private insurance. One area in the bill is that the card should not be charged prior to the actual treatment taking place. Because if it is, then the clock starts ticking towards the end of that deferred interest model, right? So you would think it, so I think there may be some things that we could find some agreement on. I don't want to, this legislation, and we've stated several times, is not trying to prohibit the patient, the consumer, from using the product. Like most credit card companies, they find their customers some way, and I get information in the mail, I get targeted ads on social media, there's billboards, there's other ways that you can market this product. And I think for some people, maybe this product is a benefit. Maybe if they have, $500 and they can pay that off in 12 months without receiving that deferred interest, this may be a better product than other products. And I'm glad to hear that you said that 80% of the people are paying it off and not receiving any interest. But obviously those 20% of people that are paying the interest supports your business model, or this product wouldn't exist. All right. And from what I've read, those 20% of people that are paying interest are paying billions of dollars in interest. And that's where I have my concern is with the healthcare industry being the ones to promote this product when sometimes it may be the best product for those patients, but sometimes it might not be. And I know you said you don't provide any sort of rewards or prizes. I thought I saw that on the website. Now, my colleague mentioned maybe that was for the actual client, the person with the card, that they can earn rewards, but I thought I saw that under the provider section of your website. But we'll just clarify. So there is no rewards, prizes for the office staff or the providers for doing anything related to the Care Credit product?
No incentives.
Okay. For other products that you provide, that you white label, like, I don't know if you white label the TJ Maxx card, but those type of cards. And the Senator Ciccarella mentioned when he goes to the checkout counter, somebody's trying to get him to sign up for those cards. Do those stores, those employees pushing those cards, do they receive incentives?
I think they might, but I would defer to Jim.
Yeah, there are revenue share agreements with some of those traditional retailer cards, but that's not the case with Care Credit.
And it would be, right, and it would be determined alongside the retailer. So it might be, a competition that the cashiers have for a month, but that's determined by them, not by Synchrony.
Okay, so thank you for that clarification. We heard some testimony earlier regarding the number of lawsuits from Synchrony Bank to Connecticut residents. Going back the last, 4 or 5 years, how many lawsuits would we say that Connecticut residents are involved in from Synchrony Bank?
Representative, I don't know the answer to the number of cases when it comes to debt collection claims or things like that. I will tell you, before we ever get to that point where we're working through the court system on that, we're trying to work with the customer because it's in our interest to make sure that they can be successful with our products. It's in our interest to make sure that we're underwriting it properly so that they're able to make those payments. And in fact, when people apply for Care Credit or any one of our products, we're doing our work to determine if they have the ability to pay and, what an appropriate credit limit would be as well. So it happens on the front end, but then also throughout the life of the relationship with the customer. So if they continue to use our product, if at some point they're unable to make their payment, we really try to work with them to make sure that they're able to continue paying us. Are there certain types of plans we have in place? I'm sure. I don't have the specifics on them. So, before I ramble on too much further, we're trying to work with them. We don't, that's sort of a last resort.
Sure. No, thank you for that. So do you know that if Care Credit or Synchrony Bank, before entering into that lawsuit, let's say there was a consumer that did not understand these deferred interest mechanisms, and then all of a sudden that year hit, they started with $12,000, but they had $1 left after that year. Now they're going to get the deferred interest of 30-40%. It's going to significantly increase their bill. Does Synchrony Bank, if an individual does not understand those terms before going to a lawsuit, try to waive those deferred interest or make some sort of settlement with the consumer?
Yeah, we have a couple of things. We generally have a 30-day grace period. So if somebody were to call us on day 3 after the deferred interest kicked in, or day 29, we would waive the entirety of that deferred interest for that consumer. In addition, we do negotiate with our consumers who go into default. right? We have been in business almost 100 years. Care Credit has been in business for 35 years. We only stay in business if people pay us back. That's kind of how this works. So we actually want to only lend to people who pay us back. There was some talk earlier about prime and subprime. Less than 6% of Care Credit consumers are subprime consumers. We probably would not approve someone for Care Credit if they qualified for state or federal or a health system contingency program for care, right? Every single person who applies for Care Credit has to go through our rigorous credit screening because we do want to ensure that they pay us back. If it gets to the end and they are not able to pay us back and they say, I absolutely cannot pay back, we will work on a payment plan with them over a period of time to try to pay us back. It is only after they default, and don't pay us anything that we may move into the deeper collections.
And if I could just add one thing, in the spirit of continuing to be proactive and making sure consumers understand the terms. So when a consumer does apply and is approved for Care Credit in a healthcare practice, within 3 days, one of our customer service representatives is reaching out to them to see if they have any questions, to make sure they understand how deferred interest financing works. So we're really doing what we can to make sure that the customer can be successful.
Yeah, I read about that. I appreciate that due diligence. That sounds like a great idea. I hope consumers are actually picking up the phone and having that conversation, not thinking it's a spam call and ignoring it. But it's great that you take that initiative. We've seen we've heard about complaints from consumers. I've read a lot online, Consumer Reports, other places, with the confusion around the products. And you've mentioned all the things that you're doing by educating medical providers, the phone call, trying to provide information on your website. Why do you think, though, there are still a good number of consumers that they take the time to make a complaint that are just not understanding it? And when they get hit with that deferred interest, they are really surprised. Why do you think that's happening?
People don't read enough of the disclosures, and that's where I appreciate what you're saying, right? How can we continue to further educate people? And that's why we have proactively, and I heard Mr. Chow mention earlier the consent order that was put in place in 2013. The Biden administration actually rescinded that consent order in 2021 because not only had we met all of the terms to be more transparent and more clear, we continue to meet them, and we have gone beyond the terms of that consent order to try to educate people and be transparent. We understand that this product opens up access to care. As we've discussed today, the providers are paying us. And that's why they're offering it. They recognize that it helps their patients get the care that they want and need. So they are willing to pay us so that their patient can get the care. This would all work if a couple more people understood the product better, and we're going to continue to work as best we can to help them get there. That's what Jim was just saying, right? We actually call them and try to make sure they understand. 60 days before, on their statement that they get 2 months before the program is over, before the deferred interest period is over, we put it in big red letters on the front of the statement. 30 days before, we put it on big red letters. Every single statement says this is a deferred interest product and this is the date that it is going to end. So lots of psychological reasons that we could probably get into that are beyond me, but this is where we are happy to continue to partner on educating people on the benefits of the product if they fully understand how it works. And we believe we are doing above the current law to educate them.
And this should be my last question, but I'd love to understand why this product has to be starting at a 33% interest rate when it's, 1 month is missed, it goes up to 39.99, 40% interest rate. Synchrony Bank, you're here in Connecticut. You want to be a good partner to the state. You're providing charitable donations. It's a Fortune 200 company. It's worth $26 billion. Why does it have to have an interest rate which seems very predatory? I mean, it seems to me like modern day loan sharking to have a 40% interest rate. when it is way above the national average, when it's much worse than other credit cards that people can apply for? Why isn't Synchrony Bank being a good corporate partner, resident in the state, and you're both not responsible for this? Again, this is not personal. You work for the company. Someone else is making these decisions. But it just seems like Synchrony Bank could do better and chooses not to. And I just love to know why. And if you don't, maybe, you know, the CEO or somebody could let the committee know. And thank you.
Sure. So when we look at how to price our lending products, we look at the competitive landscape, and because we know that if we charge way too high, consumers aren't going to use the product. I will clarify that with the APR that's on there, that APR is set, so it does not elevate, on the same transaction at any point. And that's again dictated by federal law. So the rate that you have on that transaction, the APR stays the same throughout. So I hope that helps answer the question a little bit.
Could you clarify a little bit more what you meant by that last statement with respect to the APR does not change for the life
Sure.
of the...
Just like on any credit card transaction, the APR that is set at the time that that transaction was made on the account, that stays through. So I think I overheard you, Representative Vitigliano. Yeah, so and that's all disclosed, upfront. There may be a late fee or something like that. That's all disclosed upfront.
Can the interest rate go up if somebody's late or misses a payment? Misses a payment. I think that was the representative's question. So yeah, I understand what you're saying, that as long as you pay your bill, your rate's not going to go up. But I think his question, the way I understood his question was, what if somebody's late or misses a payment? You get a late fee, which is probably pretty significant, right? And is that person eligible for interest rate to escalate at that point since they're delinquent or have been delinquent?
I don't believe that's the case, but let me confirm and get back.
There are some penalty rates that kick in after a certain period of time.
So the rate can go up. I guess that the answer to the representative's question was yes, there are certain circumstances where the rate could go up.
Yeah, and I will have to check whether that happens on the Care credit card. I know it happens on some of the revolving cards. Yeah.
Thank you. Yeah, I mean, I'm looking at the Care credit interest in terms, and it does appear as if there's a penalty APR of 39.99. Yeah. Look, I've had credit cards for what now? 50 years old, 30, a long time. About 32 years or so I've been having a credit card. First MasterCard was a great Boston Red Sox emblazoned card I got.
There's a lot of Red Sox fans in here.
Yeah. I got a free t-shirt out of it. I then proceeded to spend about a few $1,000s on DP Dough at the University of Massachusetts. It was outstanding. I loved every minute of it. Paid it off for the better part of 9 years. And the shirt was not free. Look, like the reality was, as an 18-year-old, I did not fully understand or comprehend the choice I was making by entering a credit card. Fully admit that. That was on me. I didn't understand it. Got into debt. Didn't quite understand how to handle it. Took me a long time to get out. Never missed a credit card payment. The minute I paid that credit card off, I paid in full every single month. Any day. Great. I'm in a financial position to do that. That's wonderful. Folks, I think Senator Ciccariello referenced earlier, a very bad time for him to incur like a huge debt. It was related to his dog having an emergency procedure, and would have paid anything. Like you couldn't have given him a number that he wouldn't have thought, I need to figure out a way to pay for this. Whether it's a medical procedure or caring for a loved one or caring for a pet, like this is a rough time. If you're utilizing this product, it's probably not a great moment for you. And I think that's where we get concerned about what our consumer protection laws should say. It's probably not a great moment for you if you're utilizing this specific card.
Again, the one thing that I would say is we don't want to lend money to people who can't pay us back.
Right.
Our average balance on the Care credit card, our average balance is $1,700. I think I heard you say you spent 12,000 on your dog. $1,700 is our average balance. And again, around 6% or less are subprime consumers. This is not a product that you're probably not going to qualify for it or get approved for the card if you are already in some type of financial trouble and are in that moment.
To me, the question becomes like, if you're able to avail yourself of another payment mechanism, you would. This feels like a last resort sort of option.
80% of the people, though, are paying zero interest.
That's
That
fair.
is a fantastic option for somebody who otherwise
Right.
might put it on a credit card and start paying interest 30 days later on the full amount. So this is why, look, I also applaud you for, I have a 17-year-old senior in Wilton High School. I applaud you for the financial literacy law for students, right? And we are helping to support that by trying to provide education to the teachers to teach it, because just to your point, there is so much that people need to learn. And that's why we are trying to get as much education into the hands of the providers, the office managers. You heard it from Dr. Della Porta today. We're putting training in front of them. We want people to understand it because healthcare is expensive and we want to be able to give people options. And that's what this is. This is an option. We certainly don't force anyone to take the CARE credit card. They do have to apply.
Yes, definitely. All right, I'll have a lot of questions moving forward. We'll
And
have
happy
time
to answer, yes.
Representative Acker.
Thank you, Mr. Chair, and I appreciate your time. And you had mentioned the competitive level, and just doing a quick sort. You're the big player, right? You are the most. Looks like you're the. Without naming any names, I don't really see any typical other options. It looks like you're the ones that most people look for to provide this card for their businesses. Is that true?
There are a fair amount of competitors at our heels.
Okay, I was just curious because everything I looked up, your name pops up. So you're doing well in terms of the Google searches. So just letting you know. But this has been enlightening in terms of what we've learned so far today and what you've brought forward. I think the dialogue was going to continue, and I think that everybody up here we just care about our constituents, and you care about your customers. So I think it's something we got to find some balance on. So again, thank you for taking the time to be in here. Thank you, Mr. Chairman.
Thank you. And we're, again, happy to continue the dialogue.
I think that exhausts the questions of the committee at this time.
But we're going to.
You know where to find us.
Thank you. I appreciate that. Next up is Brandon Baker, to be followed by Brooke Foley.
Good afternoon, chairs and members of the committee. My name is Brandon Baker. I serve as the Senior Director of Ticketing and Sales at the Bushnell right down the road here. My team works directly with Connecticut patrons every day, and we regularly see the confusion and financial harm caused by deceptive secondary ticketing practices. First, I want to thank you guys for the great work reflected in HB 5125. The effort to increase transparency and curb abusive resale practices is meaningful. This is a real issue for Connecticut consumers, and we appreciate your attention to it. From where we sit, though, the bill needs to be stronger in one central area, and that's speculative ticketing. Consumers believe that when they click buy, they are purchasing a real ticket that exists and can be delivered immediately. The law should reflect that expectation. No ticket should be listed or sold unless the seller actually possesses it and can transfer it right away. Allowing deposits, best efforts language, or a window of time to obtain a ticket after it's been sold simply keeps the door open to the very practices this bill is trying to stop. If a ticket is offered for resale, it should be real, in hand, and ready to transfer. Transparency must also be meaningful. Buyers should see the full seat location before they purchase, section, row, and seat number, not vague descriptions. They should see the original face value of the ticket and all the fees paid by the seller, clearly separated from any markup. Simply saying this is a resale ticket is not enough for informed consent if a patron has no idea how far above face value they are paying. Finally, enforcement matters. The bill strengthens consumer protections, but without clear consequences and a straightforward way to report violations, bad actors will continue operating as they do now. Strong rules only work if they are enforced. Resale itself is not the problem. Selling something you do not own, creating artificial scarcity, and obscuring the true price, that is the problem. We are grateful for your leadership on this issue and would welcome the opportunity to work with you to ensure this legislation fully protects consumers in Connecticut. Thank you for your time.
Thank you. I appreciate your testimony. I think, look, I've reread this section. A number of folks have brought it up. I understand the concern. I don't know that that loophole exists, but I'm convinced I have to close it if it does. So I'm going to continue to work with you. We're going to make sure that language does what we intended it to do, which is provide an opportunity for folks who, like I've referenced a few times, bought Red Sox season tickets. They don't physically have them in possession. They don't get them until 2 weeks before, but like, give them an opportunity to resell if they know they're going on vacation, if they're going away.
Absolutely. But when they buy that season ticket, I'll say they do have a seat location. You buy a season ticket, you know exactly where you're sitting. Whether or not it's delayed delivery or whatever it is, you do have an opportunity to explain that seat location and sell it.
Yeah.
Right out.
So that was the goal for that section. I can see where the language needs to be tightened up to ensure that we're not in some way codifying an activity that you know is deceptive and taking advantage of your customers. So you have my commitment to do that. So we'll work on that. I think we're all in alignment on that. So you've got the full attention of making sure that it's fixed. Representative Acker.
Thank you. So you brought up the dialogue here, just raised a question. So I have season tickets to the ball game, right?
Absolutely.
And I have the exact tickets. I know exactly where I'm sitting every game. A membership at Bush, no, and by the way, I love your facility. I love when I get there. I feel like I'm, really treating myself well. But if you have, is it similar? Do you have memberships to individuals that have specific seats, or do they for the season?
For the season, they're sitting in specific seat locations. It's a seat, it's a row, it's a section, it's all the information. They're paying for that and say, we'll do renewal in March. They'll be getting those tickets in June. So there's a large period of time where they don't have those tickets, but they absolutely know what that seat location is. They received confirmation of those locations. And once they're able to deliver that, they can send them. But I'm perfectly okay. As long as we've got a real seat location, it's a true possession of a ticket, send away. And it doesn't matter the delivery of that ticket. It could be a physically printed ticket. It could be a digital ticket. Whatever it is, we can always automatically deliver if it's being purchased on a secondary site.
Right. So now continue this dialogue. So I have my season tickets. I know where I'm sitting. I can't go July of something. I won't have, there is no ticket. There is no in hand anymore. It's on the phone.
We live in a digital world. So
Right.
which
Right.
means
So there is no in hand, right? So I can reach out and have that resold usually through the stadium I go to, not through another rate. But one of your members has the tickets. They won't get them. You said they can probably buy now or soon, right? But they won't get the ticket. So they won't have that in hand. But your kind of early comment was until they have that in hand, they might not have that in hand until they know the show lineup, right? How would they transfer that in your thoughts if they wanted to?
So most ticketing systems now, you can build an integration with secondary markets. Our integration was with SeatGeek. So I have a season ticket. I can go into my account. I can easily post that ticket. It recommends a price to resell at. Away it goes as soon as it's purchased. And once it's sold, it's not being touched. I've got a digital record of the person who's coming to that show, which is very important today, is being able to communicate with that patron who's actually sitting in the seat. If that show was canceled, we've got legislation about getting those refunds quickly and promptly. But it's important that we understand face value, I think, is really important here. And that's something that lives on the ticket, especially in this digital world. That ticket's $89. It's $89 no matter which way I turn it, no matter how I transfer that ticket, that face value remains. And I think it's important that we understand that. What's the lift on that ticket that a patron's paying above whatever the original price of that ticket was?
Thank you. Thank you for that information, that clarification. I appreciate that. Thank you, Mr. Chairman.
Any more questions? Seeing none, thank you. I really do appreciate it. We will be in touch.
Thank you for your time.
Brooke, followed by Leslie Wolfgang.
Good afternoon, Senator Maroney, Representative Lamar, Vice Chairs, Ranking Members, and other honorable members of the committee. Thank you for the opportunity to testify today. My name is Brooke Foley, and I'm the General Counsel at the Insurance Association of Connecticut. I'm primarily speaking in opposition to Senate Bill 117, and I would also like to offer general comments on House Bill 5128. On Senate Bill 117, we share the concerns of protecting consumers and ensuring appropriate responses to cybersecurity incidents. However, this bill is problematic and duplicative for insurers, which are already subject to extensive regulation, including cybersecurity and data breach regulation. This bill would require insurers, in the event of a massive breach of security, to immediately retain a third-party forensic examiner, prepare a detailed forensic report in a format prescribed by the Attorney General, and submit that report to the Attorney General or face significant financial penalties. If an insurer does not comply, the Attorney General may retain a forensic firm to conduct the investigation at the company's expense. Our most serious concern is that the bill compels the disclosure of investigative and potentially privileged materials. Forensic reports are often prepared under the direction of legal counsel to preserve attorney-client privilege and work product protections. This bill contains no clear protection for privileged material. Compelled disclosure to the AG's office could result in a waiver of privilege with far-reaching consequences. These requirements could also undermine effective incident response and may ultimately discourage candid investigations and delay remediation efforts. Companies may not know immediately how many residents are affected by a certain particular breach, so this would effectively require the same level of response to every breach incident. Turning to House Bill 5128, the insurance industry strongly supports consumer consent, transparency, and consumer control over personal information, including genetic information. Insurers only obtain personal or medical information from consumers with their full knowledge and express consent. We believe it's important to preserve consumer choice. If a consumer owns and controls their genetic information, they should retain the ability to consent to disclosure of that information for lawful purposes, including insurance underwriting. In closing, we strongly oppose Senate Bill 117 and urge the committee to reject it or at a minimum exempt insurers and address the serious privilege and operational concerns it raises. And we appreciate the opportunity to comment, and I'm happy to answer any questions.
Thank you, Rick. I appreciate your testimony. Just kind of catching up with it now. The conversations with the Attorney General that other industries have had, have you potentially entered into them with respect to 117?
We have not spoken with the Attorney General. Okay. My boss may have, but to my knowledge, I'm not sure yet if he has or not.
Okay. All right. I do think that there's been some fruitful conversations about different approaches to this, protecting sensitive information. It might be useful for an engagement there. It would help us quite a bit if there was some consensus about how to protect industry needs versus protecting constituents' needs across Connecticut. So I think it could be a fruitful conversation if you were to engage with them at this point. Sounds like other industries have gone there. They've had a robust early stage conversation. So ideally, we get to a good point on that specific aspect of the legislation. I know it might not necessarily solve all of the concerns you have with it, but as to that, I think we could potentially see some headway. Any questions?
Yeah, in regards to, requesting an exemption for insurance, can you go over some of typically we only exempt industries if the regulations are duplicative. Can you just explain what federal regulations you're already you're already regulated by?
So in terms of federal regulations, there's a variety of different insurance products that are federally regulated, like variable annuities, anything like health insurance is federally regulated, and various other insurance products. And I can get you more specific information if you would like on that.
I understand the products, but so would a data breach, is that what you're opposed to the extra requirement to the data breach?
In terms of the data breach, and it's my understanding that the insurance industry already gives certain information to the Attorney General's office. And so the issue there in terms of the privacy, the attorney privilege problem is that when you're doing an internal investigation, you have attorney-client privilege, but then when you're requiring an outside agency to conduct, or a firm rather, to conduct a outside investigation, that could potentially impute the investigation that you would have from the internal investigation to the outside firm to the government as a government investigation, which puts the privilege, it could waive the privilege for lots of different outside reasons, and it could go further outside of Connecticut. So specifically to the federal law, I think that only certain insurance products are covered by federal law, and as you know, it's regulated by the insurance department.
And so your opposition is mainly to the third-party forensic audit. Am I understanding that correctly, or?
That's a big piece of it. It also brings up First Amendment protection issues with compelled speech, but also the biggest, most serious concern is the attorney-client privilege and work product protection.
Okay, thank you.
Thank you.
Thank you. Yeah, I'm parsing out some of the concerns you raised in the testimony, and I just want to say, like, some of this I think we need to continue to explore, largely because I'm not as familiar as Senator Maroney on some of this stuff, so I think I might need some background on what is informing the need for an exemption here versus just potential changes up in the legislation. So
Sure.
I appreciate it. Thank you.
Thank you.
Next up, we have Tanaya Taylor, followed by Leslie Wolfgang. Oh, yeah. Tanaya Taylor, followed by Leslie Wolfgang.
Hi, it's Tanaya.
Oh, Tanaya, I'm
Um,
sorry. It's not coming
So
through
my
very.
name's Tanaya.
Tanaya,
Now?
I don't know if you can hear us. We're actually frozen on our end as well, so it might not be. Okay, we're
What
good
about
now.
now? Okay, yeah, I was on the wrong Wi-Fi. Sorry. My name's Tanaya. I'm the founder of Nonprofit Accountability Group, or NAG. We're a low-income group that represents residents in Hartford to advocate for environmental health and economic justice. I'm testifying in support of HB 5127. I'm here to share my experience with medical credit cards. In the past, I was like a minimum wage, low income worker. I hadn't seen a dentist in over 10 years, and I was in a lot of pain. I Googled the first dentist office that was nearest to me, and I walked over to get some help. And they gave me an extraction. So I was like heavily under anesthesia when I got my bill, and I know I needed more work. And they said it was going to be thousands of dollars and very expensive. That's when Care Credit was offered to me. And, with no money, I just said, yeah, sure. And I signed up. And even though I signed up for the card, they didn't reach out to do any follow-up appointments or to continue care. So it was just be seen, get the card. And when the card came in the mail, I realized that it would just cover a fraction of the work that I needed, which was thousands of dollars. And I was probably only approved for $500. So I put it in my drawer and walked away. Years later, experiencing financial and housing insecurity, I applied for an apartment. And when they ran my credit score, I had a very low score, even though I never had a credit card, and Care Credit was on one of the markers. So I was like, I didn't really think that was fair, that mistake that I made years ago and didn't even use the card could negatively impact my credit like that. So, just asking for more regulations on these medical cards, because they can really cause financial harm and, kind of snowball people into being under these situations. Thank you so much.
Thank you for your testimony. I don't know that Representative Turco has any questions at this point in time, but I appreciate you reaching out to us and letting us know about your specific circumstance. We've received a lot of testimony today and over the last couple of days on a written basis. And the more that we can collect just sort of a baseline understanding of how the product helps people and ways that it hurts people is helpful as we craft the legislation. So I appreciate you taking the time to share your story with us. Next up, we have Leslie Wolfgang, followed by Kendall Gilvar.
Okay, thank you. My name is Leslie Wolfgang. I'm the Director of Public Policy for the Family Institute of Connecticut Action, and I'm testifying in favor of HB 5037. Supporters and opponents of this bill can probably agree that there's a problem. Everyone cares about these children and wants to help. As far as developing a policy to protect kids from the dangers of social media while balancing other very important interests, this bill is good. It's good. And I encourage legislators to give it a shot. Our children need more robust protections. Threats of lawsuits are just that, they're threats. Anyone who tells you it is a constitutional slam dunk, either way, is overstating their case. This is a new area of jurisprudence with fair arguments on either side, and the protection of our children is worth the risk of being challenged in court. We must do something, and the time for relying on more self-policing by covered entities has passed. Some argue that parents alone should manage this, but Connecticut parents are currently up against multinational corporations with sophisticated engagement algorithms designed to maximize screen time. To strengthen the proposed legislation, I recommend reversing the presumption in subsection 2A that a user is not a covered minor if a covered operator is unable to make a determination. The bill also relies on the strained resources of the state to enforce its provisions. I strongly recommend we add a private cause of action to this bill, which I've included in my written testimony. Children are suffering and families are being undermined, and they should have recourse to the courts in order to enforce this law. Thank you.
Thank you, Leslie, for your testimony. Are there any questions? James, Senator Maroney, sorry.
Hi, I know it is confusing because the way the enforcement is done, it's through CUPPA 42-110, but CUPPA allows for a private right of action through 42-110G. But I don't know if you'd wanted different limitations or suggestions, but.
No, I don't have any. Thank you for that clarification.
Okay, thank you.
Kendall Gilvar, followed by Dawn Holcomb.
Chairs, vice chairs, and members of the committee, my name is Kendall Gilvar on behalf of the National Independent Venue Association and the Fix the Ticks Coalition, representing countless independent venues, fan groups, and artist teams in Connecticut. We strongly support the ban on deceptive URLs and spoof websites in HB 5125, and we support the current transparent pricing provisions. Connecticut should absolutely join states like Virginia and Maryland in enacting these types of provisions. Without reiterating too much of what's been communicated today, the multi-page carve-out in lines 9 through 54 in the interpretation of the live events ecosystem would allow scalpers to sell speculative tickets that they do not have. A representative from a major secondary ticketing platform has actually said that carve-outs like this would allow them to continue operating exactly as they do today. And we know, because you're taking up this issue set and are so committed to consumer protection, that that's not your goal here. I'll also note for the record that AstroTurf groups like the Sports Fans Coalition, who testified today in support of the bill, are funded by the secondary ticketing market and StubHub and do not represent independent fan voices. Nationally, momentum is moving in the direction of a complete speculative ticket ban. Maine and Maryland have enacted full bans on spec ticketing. Washington, D.C., Washington State, Delaware, Indiana, Ohio, Wisconsin, California, and Pennsylvania are all advancing these full bans on fake ticketing. Yeah, we stand ready to work with you on amendments to craft a narrow exemption for legitimate sports season ticket holders while clearly prohibiting speculative ticket resale. Season ticket holders are not the goal for anyone, I think. I'd be happy to dig in further to these provisions as well as the FTC guidance that was brought up today and why this bill as drafted is in fact more protective of consumers when it comes to price transparency and fee breakdowns. There are a number of provisions in other states that would rectify the questions brought up by the committee today. And again, we look forward to meeting with you all, suggesting edits, and working to fine tune the language. Thank you.
Thank you, Ken. I really appreciate that. I presume that you'll receive a phone call or email from us in the next few days trying to schedule time to get together. Next up is Don Holcomb, followed by Kathleen Garrity, and to be concluded with Christopher Davis.
Good afternoon. Thank you for your time. My name is Dawn Holcomb. I live in South Windsor, Connecticut, and I serve as the Executive Director of the Connecticut Oncology Association. I appreciate the chance to share my perspectives. I do have to say I submitted written testimony in support of the bill, but after hearing the Connecticut State Medical Society, I realized that there was an interpretation I had not considered, and so I have now submitted revised testimony with some suggestions for edits. While I have done a lot of research on the medical credit card companies, I've included in both of my written testimony details of what Care Credit promotes to patients, and they do have a page for providers, and on that page they are promoting marketing materials, both in print and shipped to providers, and also digital marketing materials, custom links, ready-to-use messaging, social media posts for providers to use on their social media, etc. So I do believe that there is a very unhealthy relationship between providers and the medical credit card product. So what I would very much like to suggest is that this is not something we want providers doing, but the bill as it's written is saying providers shall not do this, shall not do that. My suggestion is that we retool the language to say that medical credit cards shall not use or engage providers in any of these activities. They shall not engage providers in marketing. They shall not be training them on how to address and provide the credit card access to the credit card. It's fine if they want to do their predatory pricing and their restrictive parameters for patients, but patients need to find access to that credit card outside of their provider's office. We can't afford to have providers put in that risky situation of trying to advocate for predatory credit card pricing. So that's the gist of the suggestions that I have made. I do find the terms very onerous. I did find on a provider site for Care Credit, when I wrote an editorial about this 2 years ago, specific mention of rewards and prizes that can be earned by the provider and employees for promotions, photo displays, treatments or procedures, or competitions related to integration of Care Credit into the practice as a source of patient financing. They may have taken these down, but they were there when I wrote an article specifically about the predatory use of Medicare credit cards, medical credit cards. I would also speak to the question that was raised about, do physicians or providers know about this? And it is entirely possible, particularly with the predominance of larger hospital systems, that someone in a marketing department or an administrative department decided that they were going to collaborate, and they put the Care Credit brochures in the front lobby where you walk into the hospital. The physicians could well have no knowledge about this. Provider is a generic term that encompasses very large health institutions, very large veterinary offices, as in addition to specific small providers. So we have to be careful about blaming the provider sources. And I would really like to see this language of this bill rewritten so that we are prohibiting the medical credit card industry from using the healthcare provider or the veterinary care provider as part of their marketing. It's fine if they want to reach out over their own social media or their own internet advertising, but do not rely on catching patients at their most vulnerable by having a QR code or a brochure right there readily available in the provider's office. I personally believe that that is reprehensible, and patients can find access to funding outside of the provider office, but the provider office should be there for the care of the patient, whether it be a pet or a human being. And I would love to work with people on reworking the language of the bill. I do support the idea of banning these practices in certain areas and certain aspects. I don't think we can shut down the Medicare medical credit card itself, but I do think we can put parameters around it. But we don't need to, in the process, blame the physicians. We just need to create protection for them so that no one is going to knock on their door and say, we want to use you as a platform for marketing our credit card. Thank you.
Thank you, Don. Representative Turco.
Thank you so much, Donna, for your testimony. I'm sorry. It was Dawn. Sorry, Dawn.
It's okay.
Dawn, thank you for your testimony. First, I just wanted to ask, because you represent the Oncologist Association, why do you think it is that your association is supportive for consumer protections around these products, but other medical associations don't seem to be?
I will say that when I first wrote my editorial about this, I did that not as a representative of the Connecticut Oncology Association, but I also will say that we are very protective of our patients as a specialty. And the reason I wrote the editorial in Oncology Practice Management, which is a national journal, I'm the editor at large, 2 years ago, was that we don't always know what's out there in the front desk, particularly if we may be part of a medical office building. And so the purpose of the editorial was to say, hey guys, these are the predatory terms of these particularly in this case of care credit. And if you see that these brochures are being used within your practice, this is a good time to double check, because did you know the APR, the insurance rate, is 33%? Did you know it escalates to this? Did you know that if they miss even one payment, it goes back to billing the entire amount from day one? So I don't think most physicians, providers, whether they be medical or veterinary, really stop to think about what might be sitting out there in the front yard or in the front door, or what these cards really mean to their practice. They're not bankers. They're not going to be digging into the details of the credit cards the way I did. And so I feel very confident in saying that the terms of these credit cards are so onerous and so predatory that patients really need to be able to dig into them and understand them before they sign up for them. And if they're being offered in the physician's office or the provider's office at a time when the patient is extremely vulnerable, the patient's not going to have that due diligence and not going to be able to do that due diligence. So I don't think it's a matter of a specialty versus another specialty. I think it's more a matter of opening our eyes to what these care credits and these other medical cards truly are doing to our patients, and then stepping back and say, well, that's not our role to make a decision. If the patient wants to come up to us and give us that card, that's fine. But we don't need a contract to be in their network. We don't want any financial connection to them, because that's not our job. We don't have a financial contract with Medicare, MasterCard or Visa or any of those, other than maybe to agree to pay a fee if we swipe. That sort of arm's length transaction should be in place for any medical procedure, any medical credit card. And we don't want to be in the business of even remotely looking like we endorse these kind of choices.
Yeah, no, thank you for that. And I'm glad you brought up that you read about prizes and rewards being offered. We did hear testimony today that is no longer happening. So hopefully that is the case, because I can see that being a big conflict. And Yeah, I really appreciate your testimony on this. Thank you so much.
Well, when I look right now on what's on the website right now, I really don't think most physicians would be comfortable with meet your patients or clients where they are on social media online, using ready-to-use images, captions, and links for your social channels, tying that credit card to the practice, or offering videos on your website and in waiting rooms to help patients and clients learn about Care Credit. We wouldn't do that for normal Visa or MasterCard. Why would we in the world would we do that for any other credit card? So there are still aspects that are being provided ostensibly as tools, and I would include the training for physicians in that same category. We don't get trained on how to swipe a Visa card. We certainly don't need training on how to swipe a Care credit card, unless that training is also included with messaging about how to convince your patients that this is the best option for them, which is completely inappropriate.
Thank you very much for your testimony here today and for sticking with us for about 4 hours. I really appreciate it.
It's worth it. Thank you.
Next up, we have Kathleen Garrity, and to conclude with Christopher Davis. Kathleen, if you're available online, you need to accept the invitation that has come from the clerk of the committee. That will allow you in to testify via Zoom.
Hello.
Oh, Kathleen, how are you?
Very good. Thank you very much. I've been scribbling notes for the last 4 or 5 hours, so I have a lot of territory to cover here, but thank you for your time. Good afternoon, chairs, ranking members, and esteemed members of the committee. My name is Kathleen Garrity, and I have the privilege of being the executive director for the Connecticut State Dental Association, representing dentists of Connecticut, our oral healthcare teams, and most importantly, our patients. CSDA's mission statement is to support our members so they can provide the very best care to the people of Connecticut. And I think that the subject matter today of HB 5127 is detrimental to our mission statement. So we respectfully oppose this measure. We are universally small businesses, and this bill not only impacts our business, it also severely impacts the level of care that we can provide to patients. And it is necessary for us to have these financial mechanisms, especially for emergent care. One of the reasons that medical credit cards are vital to our business is the fact that dental insurance is so very different from medical insurance. Most plans have low annual maximums and significant limitations. Patients often reach their cap quickly and are left paying the balance out of pocket, even for preventative care. Restorative and emergency treatment increases the burden on patients. For most, paying that remaining balance all at once simply is not possible. That is why patient financing options exist. These medical credit cards are voluntary, transparent, and allow patients to make informed decisions about how to pay for treatments. They are responsible means to manage healthcare debt and ensure that providers are paid for services rendered. There was an example used earlier today about using a store-based card to purchase a suit. If you wanted that suit, you make a decision on how you're going to pay for it at the store. You do not walk out of that store without making a payment. You probably do not read all the disclosures in the store regarding the credit card being offered. There are many parallels to the medical credit card being used, except the suit is optional. Healthcare is not. Delaying healthcare is not. When people delay dental care because of cost, small problems become big ones, more painful, more invasive, and more expensive to treat. Dentists want to focus on providing excellent care, not acting as collecting agencies. Flexible financing allows practices to operate efficiently while keeping care accessible. Practices in Connecticut routinely check insurance and Medicaid for patients. In fact, most network contracts require that we do that. Credit care training that's already been discussed today is something that we participate in for practices that choose to enroll with Care Credit. And I know that my members are effectively talking to patients about the deferred interest issue. I am aware of many options that are available to patients, including in-house financing that was discussed earlier. However, not all practices are able to provide that level of financing. The market of medical credit cards exists because some patients need this option. Earlier, a point was made about money coming into practices from Care Credit. I am not aware of that happening in Connecticut. I've asked scores of dentists in the last few hours if anybody is aware of it. They are not. I even asked the American Dental Association, who also replied negatively. No one has heard of this before, But we do acknowledge that it costs practices to process any credit card, including the ones under discussion today. It costs dentists about 10% of the actual fee that we're charging patients in order to use a Care credit card. So the obvious question is, why do we do it? Because offering these cards is a community service for people who have no other means to get essential health care. I would like to also underscore another point made earlier in this hearing about existing Connecticut law regarding patients under the influence of mild or general anesthesia, opiates, sedatives, etc., who enter into a financial contract. Those contracts are generally considered voidable, and I am unaware of any such activities in dentistry in Connecticut. The case cited was, I believe, in California, as was the attorney who provided that testimony. It is an anomaly based upon our information. Similarly, I am unaware of any practice who is handing out goodie bags worth hundreds of dollars to patients and then subsequently charging patients on medical credit cards for those products. Furthermore, returning items such as unopened fluoride rinses that was discussed earlier and other products poses a serious health concern, as rinses are, for instance, temperature sensitive. Once a product leaves the practice, we cannot attest to its quality, and therefore we believe that portion of this bill poses more risk than anything else. The charge of this committee is to includes consumer protection. Consumers are patients. Patients deserve health care. Healthcare providers need to be paid for the services rendered. The earlier point of a failing system was right on target, and CSDA agrees completely that overhauling the insurance industry and increasing reimbursements from both Medicaid and insurers would perhaps be the best way to address the concerns cited as the reason for this particular piece of legislation. Revenues for
Hold on, Kathleen, we're way over the 3 minutes. I'm going to give you an opportunity to keep going, though.
I am just going to wrap it up with 3 sentences, I promise. Revenue for the top 7 insurance companies has tripled in 10 years to $1.5 trillion. So if we're looking for some of the problems with the system, let's look there. For all these reasons, we respectfully urge you to oppose HB 5127 and work with us on other pathways to ensure patient protections without restricting access to essential oral health care. We thank you for your time and your commitment to the health of Connecticut residents. Thank you for your
Thank you for your testimony today and for providing the perspective. This isn't your fault. You don't know you're walking into something that I hate about public policy sometimes, where folks will highlight, since you can't solve every single issue, you shouldn't bother to solve one. And we cannot tackle the insurance versus doctors versus cost of medicine versus facility fees in the General Law Committee. That's not before us, but what is a consumer product that is the very subject of countless points of litigation across the country. So in that I can't change Medicaid rates in this committee doesn't mean I can't look at a consumer product that is the subject of multi-state litigation, federal action, consumer complaints that are countless in oration in Connecticut, right? Like I think you walk into it's a thing I have. I get frustrated every time someone says, well, since you're not solving the global issue, you can't look at this one specific thing either. And so like I need you to understand why this committee can't address you and meet you on the big picture issues. Most people on this committee agree with you. We agree that that's a larger issue that we need to continue to work on. A lot of that is decided outside of this building, outside of this General Assembly. And I have to worry about a product that my vice chair has highlighted for the last few months in this committee, that consumers have highlighted in written testimony to this committee, that the federal government has highlighted, the Consumer Financial Protection Bureau has specifically denoted, that Consumer Reports has suggested are all deeply problematic in their structure. Now, Care Credit and Synchrony Bank have both come here and they've made major modifications to the program terms, it seems. They complied with the consent order from the federal government. They've improved business lending practices, but it's still a product that causes deep concern for this committee. And just because we can't solve Medicaid reimbursement rates here doesn't mean we shouldn't look at a very specific product that's been noted in multiple places as being problematic and exploitative and potentially discriminatory. And so that's why that's here today.
I appreciate that perspective. And if I may respond, Representative, of course, we'd all like to solve the problem with the magic wand, but we can't. It is about chipping away at the mountain and making some significant changes that would improve patient care. We're all for that. I would like to just underscore one point that I thought was pretty salient to this, which is that 80% of folks do pay back on time with a 0% interest. That means that 80% of the people in this collective group are getting healthcare that they need with 0% interest. They're not putting it on their other credit cards and automatically generating interest rates. So there is an option here that I don't want to throw the baby out with the bathwater. 80% of people getting healthcare is better than 20% not getting healthcare. So I just want to make sure we're looking at this the right way and we're not confusing the concepts.
Thank you. I appreciate your testimony. I think I might look at that 80-20 number a little bit differently and worry that if we were to make a policy choice based upon 20% of a specific identified group having a very severe negative outcome, we would suggest it needs deep, even more structural regulatory reform than is proposed by this bill. Like we're suggesting a 20%, like that 80-20 is somehow a successful sign of a good product when 20% of the customers are hit with a deferred interest back from the date of origin of 32.99% to 39.99%. That's a 20% of customers aren't able to meet the term and they end up in a disastrous situation in which if they took out $1,000 and they paid back 900 of it, they are now subject to a 32.99% interest rate on the full $1,000, despite the fact that they only owed 100, right? Like if I were to tell you that 20% of the people who went into a dentist's office got a really negative consequence from the service they received, we wouldn't deem that to be a successful service. So I think some people might look at that number a little bit differently than others. So I think that's where I'm at.
I apologize. I would just say that means 100% of people got care. And so that's the perspective I look at it. And I agree. I understand where you're coming from. I just hope that people that are not able to afford the care do not defer their treatment, because that is the worst case scenario for everybody in this conversation.
Thank you. I appreciate that. Representative Ackert.
Thank you, Mr. Chair, and Kathleen, thank you for your testimony. Do you know, have your members or yourself know of any other product similar to this that you have, that they have reached out to you to use those credit cards for this service?
There are quite a lot of other players in this market. There's, I can send you certainly some names offline. There's nobody that has come to testify on this other than CareCredit, obviously. But there are other payment plans. There are other systems in place to offer it to patients. There's Cherry payment plans. There's Sunbit. There's a couple of other ones that are specific to dental as well. But the option here is that we keep the most payment systems available so that practices can determine what's best for their populations and what they want to offer. I mean, this is a small business. We're trying to continue to provide care, and what works for one practice may not be ideal for another practice.
And I appreciate that answer. I did know of other ways to pay for it. I was wondering if there was another competitive business credit card specifically like the one we've been talking about.
There's a host of medical credit cards like Cherry, Sunbit, Patient Fi, Scratch Pay, a couple others.
Cool. Thank you. Thank you much. Thank you. Thank you, Mr. Chairman.
Are there any other questions? Representative Turco.
Thank you, Mr. Chairman, and thank you, Kathleen, for being here. It is good to see you. And Kathleen, you know from my other work, when I'm not a legislator, that I've spoken to, hundreds of people around the state with difficulties paying for dental care. So I completely agree with you. The system has a lot of holes on it, and it's very unfair to dentists and the industry that Medicaid is so low reimbursement rates, and that private insurance really doesn't cover a lot and has a lot of out-of-pocket costs, and there really isn't a lot of government regulations on dental insurance compared to medical insurance. So I understand that, for dental practices, it's even more difficult for their patients to pay with these out-of-pocket costs. My concern, and we've talked about that throughout today, is the steering of this product when there may be other products that could be a lot better for that particular consumer, lower interest rates, not as predatory of terms. But one of the things in your testimony, I think that we really, as we go forward with some legislation here, work with you on is your concern with the gift baskets regarding custom-made devices. And I completely agree with you. If there's retainers or bridges or dentures or any personalized items, I agree with you that automatic return policy might not necessarily work compared to over-the-counter products like mouthwash or something that's unopened that maybe it makes sense to have to return. So I think we can work together on that.
Thank you. I appreciate that. I think the terminology that was used for ancillary products was a little bit too ill-defined at this point in time, and that's something we can certainly work on together to tweak. But I would also caution that some of the unopened products, even that are more of over-the-counter, there is a concern that if they go out into the world and then they come back to us after they've been sitting in somebody's hot car or cold car for a couple of weeks, the validity of that product and our ability to, put it back on the shelf and sell it to somebody, I would have some real concerns about that product.
Yeah, thank you for that, and look forward to working with you on trying to improve that language. Thank you,
Appreciate it.
Thank you. And that will bring us to Christopher Davis, closing us out.
Good afternoon. My testimony says good morning, but obviously we're a few hours behind that. So I am number 41 out of 41, and I very much appreciate the opportunity to testify before you here today. And I actually very much appreciate all of you still staying here and being here, especially on a rainy and cold day this afternoon. It's a great sign here in this committee how much you guys really do care about each one of these issues, and you ask really good questions. I'm very impressed. But I'm here to testify on two bills in opposition: Senate Bill 117, the act concerning breaches of security involving electronic personal information, as well as House Bill 5127, an act concerning medical credit cards. And I'm happy to talk about both and go into one a little bit more now and talk about the other in a moment. But for Senate Bill 117, as currently drafted, it would impose first in the nation mandates and penalties that add significant legal, financial, and operational risks on Connecticut's employers without meaningfully improving the consumer protection. And I did notice that I did not state for the record, my name is Christopher Davis. I'm the Vice President of Public Policy for the Connecticut Business and Industry Association, Connecticut's largest business organization that has thousands of member businesses across all industries, including 90% of our membership being small businesses. And that's what I wanted to talk about here today on SB 117. There is no clear delineation in the bill about how a small business would handle this situation. In fact, it talks about any small business being fined $100,000 if they do not comply immediately with a forensic audit. Keeping in mind that forensic audits by third parties often cost hundreds of thousands of dollars in many cases to review some of these potential breaches. And it was actually earlier testimony that raised something that I did not include in my testimony because I didn't think about it before. But if a breach were to happen, they may not be aware if it's going to trigger that massive security breach. So would they then have to, under the law, have an immediate forensic audit done? And would that then require any breach technically to potentially have the requirement that a forensic audit be done? So I thought that was interesting discussion earlier. However, significant concerns do exist about what kind of substantial new legal exposure these Connecticut employers could be faced by providing this. And to give you an idea, if a forensic audit is then handed over to the Attorney General, you theoretically could be handing over information about how your system's designed, all of the security that you have within those systems. Now that information is provided to the Attorney General's office and either available through discovery in other cases or potentially subject to a breach itself. And as we know, the state of Connecticut is a high target for breaches. And if that information were to get out, then all that information about all these systems outside of here would be also exposed, which certainly would not be good for the state of Connecticut as well. So we have a lot of concerns about this. Happy to talk about those. House Bill 5127 happy to talk about that, as well as I am actually in the process of paying off one of those cards right now for a vet bill.
Thank you. I appreciate, I'm going to give you time to go into more detail. I just wanted to, you always respect the 3 minutes. I wanted to give you the chance in the way that you like, which is, Mr. Davis, could you please expand upon your feelings about the following bill on the agenda that you had no chance to address?
Yeah, House Bill 5127. So I think there's been a lot of discussion here today about the actual product itself, and I think it's a robust discussion and certainly a lot of things. But the way that the bill is currently drafted now would not allow any kind of discussion, quite frankly, to be had between the providers and their patients about what is available to them. And I can tell you a little bit about my situation. My beautiful 8-month-old puppy ate too many sticks. And it was December. I had to rush him to a late night veterinary clinic, right? And I called the Bolton one, they were full. I called the West Hartford one, they were full. Windsor was full. So finally I found one in East Hartford, went there. Grace of God, it was a surgeon that was on duty that night. He was able to help him. Cost about $10,000. So, you know, it's a lot of money up front to have to pay. So they said, you know, there are other payment options that are available, because I did not have pet insurance. He was only 8 months old. I didn't purchase it. And it was through they had multiple options that they said, hey, you know, we have these here. And it was through a small fintech. It wasn't through one of the big ones that I financed it with interest free, went forward. But while I was in that waiting room, there was some really interesting stories of people also accessing this type of credit. There was an individual who found a dog that had probably been hit by a car, needed a lot of work. They were the ones that brought them there. It wasn't their dog. And they still paid the medical bills to get this dog fixed, right? And they used one of these products. Another one of a young individual whose dog leg was broken, and they clearly had no other way to pay for it, and they were able to get it. And it was a smaller amount. It was above the threshold, but it was a smaller amount of money that I'm fairly confident, just hearing them talk through it, that they were going to be able to pay it back. But you know, these products do play a role, right? And they do provide the opportunity for individuals to have access to care that maybe perhaps they weren't able to have before. So as drafted, the limiting that kind of conversation, the access to that, I don't know if that's the direction that you're actually trying to go in, which is more a little bit towards about some of the usury charges for the interest and things like that, rather than saying completely like you cannot even have these discussions about these products unless someone specifically asks for that specific product, which is how this bill is drafted, which I had no idea about the small fintech that I ended up financing through, right? I would not have known to specifically ask them about that specific product and have them provide that specific information to me. So I think there are opportunities for, you know, discussions around how to address this, but I think the way that the bill is currently drafted probably goes a little too far about completely chilling the entire industry, when there's actually perhaps some reforms that you can have that can make it a little bit easier for consumers that unfortunately cannot fulfill their obligation to pay within the deferred period.
Thank you. I appreciate that. And I think we're all struggling with how to best, you know, respond to concerns that we're seeing from constituents across the state, recognizing that there's certain limitations that we have as a state and how we can approach the rates that we see on offer. There's certain responsibilities that the federal government holds and regulates, and so we're kind of restricted in our approaches to benefit consumers. So I think we're working our way through this policy with a little bit of care, trying to figure out what the right way to go is. Representative Acker.
Thank you, Mr. Chair. Chris, thank you for being here. I'm sorry about your fur baby.
He's doing quite well now, thankfully.
That's
'Cause
great.
the emergency service he was able to receive, yeah.
So on that, were you presented multiple options at that, not just a specific one?
Yeah, in fact, it was as simple as them pointing over to the corner saying, we have a bunch of brochures about other products that are available. It wasn't like, we only use this one, we only want you to use this one. It was like, literally, here's a few options that are available to you in the room that had and in fact did have a QR code, which did quite frankly make it easier for me to be able to scan and use.
Thank you. It seems like the conversation we've had in the medical field, though, isn't like that. It sounds like they sign up with a contract, right? with a specific one rather than like, I know it, to the, when you have a merchant services, you are signing a contract. I have a small business, we take credit cards. And we do sign a contract with all the cards that this is, we're going to take your card and it's with the merchant services that provides it. It seems like though, I believe that there was a better, like that option that you were presented with isn't what were happening in the medical field, that they have, you have other options, have you exhausted everything else? But here's the product that we have that we're finding out that it seems like the healthcare person is paying 10%-ish on, on the access to it, like most credit cards are under 3% per, that if you have a merchant services, 10% seems high. But then also if on the other end of it, it's a high mid-30s-ish interest rate after, which seems to be, to me, a little bit aggressive in terms of the financing. So that's where I struggle with that, and being a business owner that, and then with you, I'm happy to hear there was multiple options. And I think that's something that we might look at in terms of it, rather than the targeted one where here's the option. And that's why I asked if there's other options out there, because if they're saying, hey, here's some products out there if you really need some assistance, rather than, oh, we've signed a contract with ABC and they're the one that's going to provide this. So any thoughts on that?
Yeah, I think you raise an interesting point, and I'm not sure. Do you accept Discover Card? Do you accept American Express? Do you accept Visa, MasterCard? Because not every retailer, not every point of sale accepts every type of credit card either, right? So those kinds of contracts that are made between the merchant or service provider and the credit card company in which they choose to do business with can differ, in part because if you were to mandate that they have to have multiple ones, say the next provider requires a 25% fee, right? And maybe they do want to contract with the one that only charges 10%.
Yeah, great question. So merchant services, it's typically a fee, so that merchant services handles all the cards for you, and that's the fee that you get used for it. So it's usually a set fee that's, a certain percentage. So I would imagine if they signed up contracts with 4 or 5 of these Medicare cards or care cards, whatever they are, I'm using the company name now rather than that one, then that would be different where they had multiple access to it. But it seems like there's really the one big player, and they've kind of, I want to say cornered the market, but they didn't have a lot of, when I look up and as you start to look it up, when you're here for 4 hours, you get the chance to do a lot of research. So I think that's the piece that is kind of a struggle in mind. I don't mind a healthcare provider. Hey, here's an option for you. We're not here to help you, discuss it with you, but here's an option if you need that assistance. Right. And like they did for you, right? What they did for you. Because I don't have that load up my MasterCard or whatever it is with the dog care. So that's, I guess, a little bit that when I started research a little bit more about this, and then typically the average person's credit card's probably in the 12 to 15%, not a 34%. So that's a little bit about it, but I do appreciate you being here and bringing your story and your thoughts on this.
Yeah, and to that point, Representative, I would say that as currently drafted, this bill would not provide the opportunity for you to offer to any of them, right? So, that's a conversation that can be had, but, as currently drafted, you wouldn't even be able to say, hey, we even have this option available to you.
And that's why it's in this process, the public hearing process. I brought out a great bill, I thought, about 6 or 7 years ago, and it was after public hearing, we found out it was not a very good bill. So that's what we do in this business. So thank you again, and thank you for the work that you do. Thank you, Mr. Chairman.
Thank you. Any other questions? Seeing none, we have concluded our public hearing testimony sign-up list. Is there anyone here with business before the committee? Seeing none, we stand adjourned.